I let the day pass without doing that, so I'm asking the court for permission to recall Investigator Sautel. I anticipate the questions would be anywhere between 3 to 5 minutes to inquire into that subject matter, and I have Investigator Sautel outside ready if the court were to grant that request.
So you want to do that first thing?
I would like to do that first thing, yes.
All right. Anything? I think the defense isn't going to. Well, Ms. Levinsky, any thing you want to add to that?
Your Honor, I don't know what the issue is that they did not raise, but I would assume that that opens the door for me to cross-examine on that issue.
Oh, certainly. Certainly. If there's something new that comes up, that will give you a recross. And if he's coming back, then I suppose we do need to address this issue that we left off with as to the email, Defense Exhibit 4. And so...
Your Honor, it was my impression that the court...
Five? No. 5 is already admitted. 4 was the one that was not admitted. No, it was not this one. That's it. Okay. Yes, Mr. Fawcett.
Yeah, Your Honor, it was my impression that the court was indicated a desire to wait until Investigator Bryant testified, as that may resolve the issue.
That was my impression, but now you've got him already coming back, so I don't know. I mean, it seems to me that might be the most efficient course. If you're willing to have him come back a third time if he needs to, depending on where we go with this.
I think Investigator Bryant's testimony would be comprehensive, and I think after that, I don't get the impression that Investigator Sautel isn't willing to assist with the investigation.
Okay. Ms. Levinsky.
Your Honor, it's I'll leave it at that. If the court wishes to leave it for after Investigator Bryant has testified, I'll leave it for that.
All right. I think that probably is the most efficient course here. So we'll go ahead and have Investigator Sautel return to the stand here. You can go ahead and bring him in for this redirect and recross on this new issue and where we go with that. And then you've got, I guess, your other witnesses lined up. Jury appears ready to go. So let's bring them in. Deputy Scott. I'll get this back to you. 5 was admitted, 4 was not.
You want to they can orient to you have my PowerPoint pictures of it. How about Jared? Perfect. The same thing. Go.
Thank you, Deputy Scott. Please be seated, everyone. Welcome back, members of the jury, and thank you for being here on time. We are ready to resume with the state's presentation of their case in chief.
Your Honor, are we using the same Zoom link from the previous week? Because we're in the waiting lobby now.
All right. Just a note. I believe we've got some folks perhaps still in the lobby for the Zoom conference. If we could have them re-added in as a co-host. And while we're doing that, the state has asked to recall one of their witnesses, and so I'll let the state make that announcement now.
Yes, Your Honor, this time the state is requesting permission to recall Investigator Sautel for a limited redirect examination.
All right, so Investigator Sautel, I'll remind you that you remain under the same oath as yesterday.
Yes, Your Honor.
And Mr. Fawcett, unless you need to wait on the Zoom link, feel free to proceed.
Investigator Sautel, turning your attention back to the investigation involving the homicide of Miss Kay Thomason, can you tell the court if you've had experience or been trained in collecting or swabbing for DNA evidence?
Yes, I have.
And talk about the process of swabbing for DNA evidence. How's that done?
So what you do is, of course, the concern is cross-contamination, but what you're ultimately trying to do is collect a sample of a particular area and then make sure there is no cross-contamination. So what you begin with is putting on a fresh new pair of gloves. Then you open a brand new set of applicator pads. You use a brand new bottle of sterilized water, pour that onto the first applicator, roll that into the particular area to get a sample. Then put that one in a box, label it. Then you do a second sample, which is already a wet or moistened area, and you do a second 2 swabs per area.
Okay. And did you collect any DNA evidence utilizing those techniques in this case we're
Yes,
talking
I
about today?
did.
And
Yes.
talk about what you did to collect DNA evidence in this case.
Sure. 2 days after the incident, we recovered the vehicle at a location off of Chambly Dunwoody Way. It was her Kia, the 2012 Kia Sorento, and I responded to the scene. The vehicle was secured. Nobody was allowed to touch it. We had it towed from that area to a fire station bay. It had been raining, so the vehicle was wet on the outside, and I knew I wanted to process the outside and the inside for any type of evidence, and to include fingerprint evidence. So once we had it towed to the fire station, that's when I began the DNA collection samples.
Okay. Can you talk about where in the vehicle that you collected samples?
Sure. There was a long list of areas. I can cover some of them, but if you have my notes, that would be helpful to cover everyone. But I did the exterior door handles, the interior driver's door handle, the gear shift knob, rear view mirror that people touch to adjust. And then I took samples from the seat, starting at the headrest. I did tape lifts for that area. I did some DNA swabs, and then I did tape lifts beginning at the headrest all the way down to the seat. And then ultimately, I actually removed the headrest. I considered removing the seat, but it was we talked about it. We knew we were going to keep the car anyway, but we wanted the best piece of evidence, best of any evidence possible, which is always the original evidence. That's why we looked at the headrest and we were able to remove it. And we knew based on the suspect's long hair that the hair would very likely touch the headrest. So that's why we were most concerned, or I was most concerned with getting that headrest.
Okay. So you talked about that. Was that information you received from the surveillance video? You talk about the description of the suspect's hair?
Yes, yes.
Can you tell the jury what determined or how did you pick what places in the vehicle to collect DNA evidence?
Well, based on my training and experience as a crime scene investigator, if someone drives a vehicle, I know there's certain key areas, as I mentioned before, like the rear view mirror, gear shift, maybe the stereo console, the seat. And in this case, we knew that someone drove the vehicle away, a suspect. So it was, even if I hadn't seen the video, I still would have collected those areas.
Okay. And those are the techniques and those are the areas you're testifying to this morning that you collected in the vehicle of Kay Thomason?
Yes, I did.
And what did you do with the samples after you collected them?
They were all turned into property and evidence.
Describe that, like talk about what is property, what measures are in place to prevent unauthorized access?
Sure. It's a secure area. I think at the time we probably had 2 different officers that worked in that area. And what you do is you bring evidence to their, kind of like maybe checking out at the convenience store. So you go there, you have your paperwork in hand, you have your evidence in hand, you sign it over to them. They then put it into their inventory.
Okay. And did you do that in this case?
Yes, I did.
Okay. And after you submitted the evidence to property, as it relates to the collection of evidence in Ms. Thomason's vehicle,
Yes.
did you do anything with the evidence after that?
Not once it was put into property and evidence.
Okay. And so when evidence is put into property and there's an intent to do something with the evidence, what happens with it then?
Sure, that's a great question. Detective Williams, what happens is the assigned detective, the case detective, does a follow-up and they do a submission to the GBI or to a private lab for further analysis. That's not something that's handled on my end.
Okay, and so that was what would typically happen with evidence, but you weren't involved in that process of it being transferred to the GBI and the next steps?
I don't believe so.
Okay, all right. And can you tell the jury whether or not you observed or had a reason to believe there was any tampering with the evidence you collected from Ms. Thomason's vehicle?
No, I did not.
And throughout the investigation of this case, do you have a reason to believe there was ever anything, a foul or not in accordance with the standards of procedure and operation at Sandy Springs Police Department?
No, I do not.
Okay. I'm gonna hand you what's been marked as State's Exhibit 188, 189, and 200. Take a deep look at these exhibits and tell the court if you recognize them.
That's the 2012 Kia Sorento, registered to the victim in this case, parked at that Chambly Dunwoody Way address, backed into a parking spot, and I took these photographs.
The photographs are fair and accurate representations of what you observed at the time you did the collection of Ms. Thomason's vehicle.
Yes.
Beyond this time, the state needs to tender the evidence, State's Exhibit 188, 189, and 200.
Any objection?
None, thank you, Your Honor.
They're admitted.
Published in respect with Exhibit 188. Okay, sorry. What's it? So we'll start with Exhibit 188. Can you tell us what we're looking at?
Yes, the victim's 2012 Kia Sorento.
And and 189. Can you tell us what we're looking at?
The victim's 2000, the Kia Sorento again. Yeah.
And the Exhibit 200. Is that the inside of that vehicle?
Yes, it is.
And is that the vehicle of Ms. K. Thompson?
Yes, it is.
And is that the same vehicle you collected the evidence and the swabbings that you've been testifying to this morning?
Yes, it is.
Fine, Judge.
Cross-examination on those points.
So let me see, Detective Sautel, after you submitted the evidence
Yes, ma'am.
that you'd processed, did you ever see it again?
Not that I recall.
So you don't know whether it was tampered with in any way whatsoever?
Once I turned it to the property and evidence room, I no longer have control of it.
Correct. Okay. Now, let's talk for 2 minutes about the car. As I read your police report, there was only one clear seating area in the car. Is that correct?
Yes, ma'am.
The rest of the car was full of trash, random building supplies,
Yes, ma'am.
tools,
Yes, ma'am.
fertilizer, cat litter, and other miscellaneous items.
Yes, ma'am.
And what you did is you looked at those areas which a person who's driving a vehicle would normally touch. And
Yes, ma'am.
you processed those areas.
Those areas were, there wasn't even room for someone to sit in those areas. It was more of a storage area. Really, the driver's seat was the only seat that was able to be sat in.
I have nothing further. Thank you.
You're welcome.
Any redirect?
No redirect, Judge.
Okay. Investigators, same instructions as yesterday. You can step down, but you still may be subject to recall later in this trial.
Yes, sir.
All right.
Thank you.
Thank you, sir. Statement calls next witness.
Judge, we need to go outside and sound for our next witness, if we could do that. Investigator Barkley? Okay, all right.
McCabe.
Okay, that'll be Investigator McCabe, Judge. Investigator McCabe. It almost a meeting password. Okay. You swear upon to test testimony is the truth, and that's what's true.
I do.
Please be seated. Please state your name on the court.
It's Jason McCabe, JASON MCCABE.
Just a minute, Investigator McCabe, good morning.
Good morning.
Can you tell the court where you're currently employed?
The city of Sandy Springs with the Sandy Springs Police Department.
And what do you do with Sandy Springs Police Department?
I'm currently the criminal intelligence manager.
What does a criminal intelligence manager do, if you could describe your duties?
I oversee the operations for the criminal intelligence unit, which provides administrative support, statistical support, real-time support, and investigative support for the department.
Okay. How long have you worked in that capacity?
Approximately 2 years.
All right. And at any point during this investigation, did you assist Investigator J.T. Williams with this case?
I did.
Okay. Can you tell the court, at what point did you become involved in the investigation of the homicide of Miss Kay Thomason, excuse me?
It would have been in June of 2018. And at the time I was a street crimes detective. So my
Okay.
primary responsibility was canvassing.
All right. And is your testimony that you were primarily responsible for canvassing in this case?
Yes, the directive we had at the time was to try and locate the victim's vehicle.
Okay. And what information did you have at the time, or what specifically were you looking for, if you can recall that?
The victim had a black Kia Sorento SUV that had been stolen from the scene. We had a direction of travel, I believe on Windsor and Peachtree Road, but it was eastbound from the victim's residence. And so we were directed to go search those areas to see if we could locate the vehicle abandoned anywhere.
All right. And at any point, were you able to locate the vehicle in question?
Yes, sir.
All right. Do you recall where the vehicle was located?
It was an apartment complex on Chambly, I believe it's Chambly Dunwoody Way off of Peachtree Road.
Okay. And how many officers were with you when you located the vehicle?
Initially, it was just me, and then 2 other detectives showed up shortly afterwards.
Okay. And are you familiar with the mechanism used to locate Ms. Thomason's vehicle? Was it a call, or was it some other technology that was used? You aware of that?
I'm not sure I understand the question.
I'll move on. So when you get to the vehicle, what do you do at that point?
The vehicle was backed in. When I saw it, it just fit the description and in the area. So I checked the license plate and the VIN to make sure it was actually the victim's vehicle. And once that happened, we secured it and then just kind of stayed in the area while detectives and crime scene and other personnel started to respond.
Okay. All right. Now, Investigator McCabe, if I were to show you some photographs of Ms. Thomason's vehicle in particular, the vehicle that you located, would you be able to recognize those photographs?
I believe so, yes.
Okay.
One second. 1 second. There's the car right there. Yeah. Did he see all that?
Well, we won't find out when I show it to him.
Before you should.
I'm sorry.
Think you should find out before you should.
That was being sarcastic. He was there. You looked at these before, right? They're
I
good.
haven't seen them before.
Okay. Okay, we good?
Hmm.
Okay. All right, Investigator McCabe, I'm gonna show you what has previously been marked as State's Exhibit 190 through 199. You take a look at these. Recognize it.
Yes, sir. I do.
I'm now going to hand you what's been marked as 202 through 296. Tell the clerk if you recognize those exhibits.
I did not do the search of the interior of the vehicle, so the interior I wouldn't recognize.
All right,
It
so
would have just been a visual, making sure nobody was in there.
okay, so 190 through 199.
But yes, where it's parked and located, yes, I recognize that.
Are those a fair and accurate representation of what you observed at the time?
Yeah.
You were searching, or you located the vehicle?
Yes, sir.
This time the state will be itinerant evidence, state exhibits 190 through 199.
Any
No
objection?
objection, Your Honor.
They're admitted.
Okay, Investigator McCabe, can you tell the jury what we're looking at? And this is exhibit 190 for the record.
The driver's side of the Kia.
That means that someone's laptop's off mute when it's echoing like that. On the laptop. Is everyone's laptop on mute?
Yeah,
And the Zoom as well. The Zoom's on mute. Could we just test that again?
Test.
Okay.
Okay.
So we were talking about exhibit 190. That's the vehicle,
Yes, sir.
right? All right. And is 191, is that the back part of the vehicle?
Yes, sir.
All right. I'm gonna show you exhibit 195. Tell the jury that's the front part of the
Yes, sir.
vehicle that you searched was Thomas' vehicle.
That's the vehicle I located, yes.
Now, as far as your role in this investigation, after you located the vehicle, did you assist in any other parts of the investigation itself?
I did speak to a neighbor, assisted with a canvas.
Okay.
I spoke to
What, and when you say canvas, talk about that process. What does that mean to canvas and what's the purpose?
A canvas, the typical process is to ask questions of any neighbors, people that live in the area, find anybody that may have seen something unusual. A lot of times it helps establish timeframes or patterns that were out of the ordinary that they may not have thought was significant to call the police for. That was asking to see if anybody knew when it pulled in, saw it pull in, saw who abandoned it, anything like that. But nobody I talked to provided any relevant information.
Okay. Was that just part of the process of getting information to assist with the case?
Yes, sir. That's a common process in
Do
cases.
you know if there were other officers involved in canvassing efforts related to this investigation?
I believe there were, but I was not present for that.
Okay. You were not the lead detective?
No.
Okay. That's all I have for this witness, Judge.
Any cross-examination?
The apartment complex where you found the vehicle, it's a busy apartment complex?
I'm sorry, ma'am.
It's a busy apartment complex?
Busy?
Busy.
I'm not aware. That's the first time I've been to that complex.
Were there a lot of vehicles there?
I couldn't tell you how many vehicles were there.
Are there a number of apartments there?
I don't know how many apartments are in the complex, ma'am.
You don't know how many vehicles and you don't know how many apartments. Let me ask you this, sir. States 201. Is this inside the vehicle?
It is.
Inside the vehicle?
I would assume so. It looks like a picture of the inside of a vehicle.
And then similarly, 197, is this inside vehicle?
It looks to be a picture of the inside of a vehicle, yes.
Is this one of the photos you took?
I did not take photos.
You didn't take the photos at all?
No.
You just located the vehicle?
Yes, ma'am.
Did you look in the inside of the vehicle at all?
Yes.
And can you identify that these items were in the vehicle or not?
I couldn't tell you specific items that were in a vehicle, but I could tell you there was a high amount of items inside of it because I looked inside to make sure nobody was inside of it.
And when you canvassed the area, how many people did you talk to?
I only recall talking to one.
Okay, extensive canvass. I have nothing further, thank you.
Any redirect?
No redirect, Judge.
All right, can this witness be excused?
No objection.
Take care, sir. You can step
Thank you, Your
down.
Honor.
State may call us next witness.
Yes, we would call Investigator Shane Barkley.
Just want to find the testimony is the truth and I'm good to help you. I do. Stay in there to the court.
Sure. I'm Ricky Shane Barkley, RICKY, SHANE, Thank you, Your Honor. Where do you work, sir?
I work for KPMG.
And what do you do there?
I do protective intelligence and insider risk.
Now, I'm going to draw your attention back to 2018. Where did you work then?
I worked at the Sandy Springs Police Department.
And what were your duties there?
At that time, I was a crime scene investigator.
And could you kind of tell the jury what your understanding of your responsibilities or what your responsibilities were as a crime scene?
Sure.
detective?
My responsibilities were to locate, detect, and analyze evidence and reconstruction of events that occurred in the process of the commission of a crime.
And how long had you been doing that for in 2018?
I think 17 years.
Were you post-certified at that point?
Yes.
Okay. And had you been post-certified throughout your law enforcement career?
Yes, sir.
Could you please tell the jury about your law enforcement career starting?
Sure. I started my career in 2001 at the Whitfield County Sheriff's Office. Once I graduated from the police academy, I went straight into investigations. I spent the next 2 years mostly in training in reference to forensics, bloodstains, fingerprint analysis, latent print detection, DNA collection, and a lot of other different disciplines. So I was then hired by the Sandy Springs Police Department in 2006 to begin their forensics unit at that department. I served there for a little over 12 years. And then I ended my career as a captain at Georgia Tech, and my responsibilities there were to supervise criminal investigations and the digital intelligence unit.
So your last area in law enforcement, you were a little bit broader than you were at Sandy Springs?
Yes.
But could you go through the training that you've had in collection of evidence? I mean, what does it entail?
Sure. There's multiple schools that I attended to and multiple academies that I attended. I'm a graduate of the National Forensics Academy at the University of Tennessee, often referred to in literature as the Body Farm. I'm also a graduate of the Southern Police Institute Officers Administrative course. I've attended blood pattern analysis at the University of Tennessee during the Forensic Academy classes and at the Georgia Public Safety Training Center. So I've actually done that course twice. At the time of this incident, I was either had held 3 certifications with the Identification Association, with the International Association of Identification. Please excuse my word fumbling there. As a crime scene analyst and a senior crime scene analyst. So I have multiple certifications and have held multiple certifications in forensics and crime scenes.
And on this case, is it fair to say that you're kind of in charge of crime scene?
Yes, I think that would be fair to say. The Detective Williams, I did not arrive at the crime scene when it was noted. Detective Williams, I believe he ordered it to be held until I arrived that morning before we got into the real deep forensic processes.
So when did you arrive on the scene?
I can't recall the exact time. I want to say around 1000 hours, but I can't recall the exact time.
So that'd be 10 in the morning?
Yes.
And do you recall what date that was?
No, I don't recall the exact date.
Was that the same date as the incident, do you know?
It was I believe the incident occurred the night before, so depending on the postmortem interval, it could be the next day.
And when you arrived, or who contacted you to arrive at that scene?
I actually arrived at the office, and office personnel told me, hey, the CID team is waiting for you at Old Woodbine. And when I found that out, I left towards that location.
Okay. So when you got to the scene, who did you speak to first?
I can't recall exactly who I spoke to first. What I can recall is I got a briefing from personnel at the crime scene, and I also was showed video that was captured from the incident location of the suspect's potential entry.
And why? Well, I guess I didn't. Could you describe what was at Old Woodbine as a house?
Yeah, it was a large house. I believe it was painted white.
So you said you saw some video. Why was that important to the investigation?
The reason why it's important is because we were able to determine several things that were very beneficial to the investigation before we started evidence collection. Number one, we had a very high reason to believe that the suspect was wearing gloves when he entered the scene. That tells us many different things. It tells us we're going to have to change our approach in how we gather evidence for a couple of reasons. One, there's an obvious attempt to not leave evidence behind by the offender. And two, we're going to have to get more granular in our search for artifacts of evidence. And in this case, we needed to do a forensic biology sweep for DNA of the house because obviously, latent prints, it's most probable that they're not going to be there.
Why is that?
Due to the fact that we believe we saw the offender was wearing gloves when he made entry. So due to that fact, we were able to streamline our processes to where we could do the least intrusive methods possible in order to collect the DNA that we believe would be present.
And how do you collect it? How do you typically collect DNA?
Well, there's a multitude of ways to collect DNA. It depends on which type of DNA that you're trying to collect. Your most typical DNA collection is for nuclear DNA. It's from blood. You're looking for the white blood cells that contain nuclei from all the red blood cells in a mixture of blood. In this case, not only, were there artifacts of blood, but we also were looking for artifacts of contact DNA, which is mitochondrial cells that come from the sloughing off of skin and making contact with objects with your skin. So that we had a very large focus on that.
And so that was your emphasis in that
That's correct.
kind of the way and does that guide your process?
Yes. Once I arrived at the scene, I saw the video and I did an initial walkthrough. And during the initial walkthrough, I was able to observe what I believe to be artifacts of a struggle, to be artifacts of assault, and to be artifacts of confinement to a chair and in a room.
Where did you find those?
In the bedroom, where the broken mirror was. There's also defecation in the bedroom on the bed, and I believe on the floor. And on the chair that was found in the room where I believe there was artifacts of confinement, there's defecation on the chair and also artifacts of blood in that room.
I'm going to show you what's been previously admitted as State's Exhibit number 120. And that'll pop up on the screen. Okay. Are you familiar with that picture?
Yes, I am.
And are you familiar with that scene?
Yes, I am.
And is that almost how it was when you arrived?
That was how it was when I arrived in C2, yes.
Well, there's some markers. There's some markers around. What does that mean?
Previous investigators who have been in that room notated some articles of evidence and left identification markers to identify those for photographs.
Now, earlier you had talked about that there was evidence of a struggle.
Yes.
Can you please point out to the jury where on that picture is depicted what you relied upon?
Well, in this particular picture, you probably can't see it, but in the roll of photographs that was taken, if you look at the top of the chair, you can see artifacts of blood transfer on the top of the chair. And you can also see circular drops of blood that are coming down from the chair and on the floor. Those, when they're circular, those indicate they're more 90 degrees. They're more vertical drops. So there was blood loss in that room. And also there's some additional artifacts in the hall. I believe there's a door that we collected as evidence that had a blood transfer on it. And also in the bedroom, that's not really associated with this picture, but the artifacts of defecation, that in some circumstances that could come from fear or shock. Okay. You have transfer in the bedroom, you have a broken window, you have objects that are in disarray. So to me, those strongly signal artifacts of some type of struggle.
And let me go through the evidence markers. What is depicted by evidence marker number 1?
I believe that is an artifact of defecation, or I don't want to speculate. I don't recall exactly what that artifact is.
Okay, let's try evidence marker number 2. Oh, sorry.
Number 2, those are blood transfer stains that are located on the carpet that indicate blood loss and some type of movement in that area.
And are you familiar with what was depicted by evidence marker number 3?
No, not offhand.
Okay. And then
if my memory serves me correct, I believe that's a heel mark, but I would need to see other photographs, more of a macro nature to identify that.
Okay. Okay, I'm going to show you what's been entered as State's Exhibit 122. Is that kind of a better angle for you to describe some things?
I can attempt to, yes.
Okay, could you please do so?
In regards to what, sir?
Actually, let me go ahead and move along. All right. Now, I assume it's important to have a systematic, methodical way of doing this.
Yes.
That's critical.
Mhm.
And you kind of in charge of that portion of the investigation.
I would support that, yes.
Okay. How many people were working with you at that point?
I don't remember the exact number, but I believe it was a team of probably no less than 6 detectives.
And you're actively supervising them?
Well, I'm giving orders on the processing of the scene, what articles and what locations are important, what locations are important to swab for contact DNA and things of that nature. So I was in charge of directing the evidence collection.
So when you got to the scene and decided to make a game plan, what was your game plan to methodically do this?
The game plan was to do a forensic biological canvas of the house. As I testified earlier, we already knew that most likely fingerprints are not going to be involved in the identification attempt due to the fact that they were gloves worn on the hands. So you have to adjust your plan to what the most probable probative output of evidence collection is going to be. So we didn't want to get into powders for processing prints. We didn't want to get into brushes because once you start to powder and make contact with with brushes, you become more intrinsic with the evidence. And the more intrinsic you come with the evidence, that increases the likelihood of potentially losing evidence. We're talking about collections on a cellular level here when it comes to DNA. So we wanted to take all the care that we possibly could in order to get these very granular pieces of evidence. So I directed the team to begin doing wet and dry swabs for contact DNA in specific areas of the house, like the railings, the doors. You know, we wanted to do separate processes for the bed sheets, so we just collected those. But we started to take wet, dry swabs of multiple areas of the house in an attempt to collect skin cell DNA from the perpetrator.
So did you find anything, or did you direct people to start, let's go downstairs, started them downstairs? There were 2 levels of the house?
Your Honor, I'm going to object to the leading.
Okay. Look, let me hear the end of the question first.
Okay. Were there 2 levels to the house?
I believe so, yes.
How many levels were there in the house? How did you start this?
Well, we typically you want to start from the outside in when it comes to DNA collection, because the more you move towards, ground zero of the physical activity, that's the more chance you have to walk over or disturb potential evidence before you get there. So I ordered investigators to start at the bottom of the house and work our way up.
Do you know whether or not things were collected? Where were the first, excuse me, let me try that again. Where was the first location in the house?
I can't recall exactly where they started, but if my memory serves me correct, I believe it would be logical to believe that it would be the area of entry.
Okay. And what kind of things are you looking for?
We're looking for cellular DNA. We're looking for artifacts of contact. We're looking for smudges that may represent an arm brush or an elbow brush. We're looking for any type of artifacts of contact That way we could swab that area in an attempt to gather mitochondrial cells.
And I don't know if I asked, could you tell the jury what the process is for swabbing for DNA?
Well, there's many different processes. If you're doing cellular DNA from a blood pool, you could use a dry swab because typically the blood itself is going to contain moisture. But when you're looking for mitochondrial skin cells, you don't have any artifacts of that. So it's important to hydrate the area first with a wet swab and then follow up with a dry swab behind that. That way those cells are hydrated and it's easier for them to be collected onto a dry swab for analysis. So you hold two swabs together, one's wet, one's dry, and then you swab the areas that you're looking to find evidence from.
And did you explain that to the detectives who were collecting evidence?
Yes,
And made sure as best you could that they followed that procedure?
yes.
Where did you go first in the house?
Once detectives finished their collections downstairs, I went up to the upstairs to examine what I believe were the artifacts of assault that are articulated in the bedroom and in the room where I believe there was confinement.
Did you go to like what you felt like was the most important place? Okay. And where was that? Could you describe what that was?
I believe the two key areas in the crime scene were the bedroom, the master bedroom, where the broken mirror is, and the room that contained the chair and the blood stain on the carpet, where I believe artifacts of confinement were present.
So which room did you go to first?
I can't recall specifically. It's been 7 years. I can't recall which room I went to first.
Did anybody else assist you in collection of evidence in those two rooms that you remember?
Some of the artifacts were collected before I got there, such as a tool that was located in the bathroom. So there were some initial collections that were done before I got there.
Did you observe that tool?
No, it wasn't there when I got there.
Okay. But as far as your team, you were the one that concentrated on those two rooms.
I'm sorry?
Were you the one that concentrated on those two rooms?
There's a lot of people looked at them, but my main focus was those two rooms, yes.
I mean, and I'm talking of the evidence collection aspect
Uh,
or DNA collection aspect.
I can't recall specifically, but I believe that would be right. I could see myself sticking to the most important artifacts of evidence.
And when you went into the bedroom, what did you look for, and what did you collect? What did you end up doing?
We're looking. The biggest thing in the bedroom that caught my attention were the sheets. I believe there was some type of activity that occurred on the bed. So it was very important to me to collect those sheets because I knew more in-depth laboratory analysis would need to be done on those sheets due to the artifacts of defecation, due to some transfer. I believe some type of activity occurred on the bed. And then the second would be the carpet and the chair that was located in the room where there was artifacts of confinement.
Okay. So what all did you do with the bed sheets?
We collected the bed sheets in large paper bags, and we sealed them and entered them in as evidence for analysis, which eventually made it to a crime lab.
Did you do any swabbing on bed sheets?
No,
Why not?
because the most appropriate way to process those bed sheets would be in a laboratory. As I explained earlier, the more intrinsic you get with the the more potential evidence you can lose. So we were more than able to pack up those bed sheets appropriately and store them in paper bags and transport them to a lab where they could be processed in a sterile condition.
And when you said intrinsic a few times, what do you mean by that?
Intrinsic as referred to
As far as the way the term you're defining it, what is that kind of?
inside, intrinsic inside.
Okay. And do you recall if you collected anything other than the bed sheets from the bedroom?
We collected the chair and we collected the carpet where the chair was located.
What else did you collect? What else did you collect from that?
And Your Honor, now this has been asked and answered, I think about 3 times.
The question was, what else did you collect? So I don't think that's overruled. You can answer the question.
What else did you? I'm
I
sorry.
believe I collected some blood swabs as well, although I can't specifically remember from the locations.
And blood swabs, was that the same collection as before?
Yes.
Process?
Yes.
And the other room that you looked at, what did you collect from there?
Which are you referring to the room where there's artifacts of confinement?
Yes.
The carpet and the chair. And I believe we collected some scissors and some tape that may have been there.
Okay. And what did you do next?
Once we documented all those items, we entered all those items into evidence at the police department.
And when someone collects the DNA swabs, what happens?
They're stored appropriately in little containers for DNA swabs, and then they're entered into evidence.
And that's what happened?
And that's what happened.
Do you recall how many swab containers you had? Ballpark.
I would estimate we took well over 100 swabs from the house.
And what else? What did you do next?
Once the scene was processed and all the items of evidence were secure, we went back to the police department and tendered those into property and evidence.
May I just have one quick moment, Your Honor. Showing what's marked as what's been entered as 122. Is there anything of significance that is not indicated by an evidence marker as far as you're concerned?
No.
In that picture? Is there anything? Okay. Your Honor, I have some heavy pieces of evidence that I think would be appropriate to display at this moment, but I do need a moment to set it up.
All right. So how much time do you need?
What about 2 to 3 minutes?
Okay.
2 to 3 minutes?
We'll hold in place.
Okay, thank you. Okay, I heard you. Yeah. Do what you need to do. Here, Vincent, come on. There.
Your Honor, may I assist him?
Your Honor, may I approach? May we?
Well, no, we can't approach because you have a prior decision. Is there something you want to address?
Yes.
Why don't you take it up with counsel and then let me know if you need me to step in.
This is it's prejudicial. It's probable.
So we need to take it outside the presence.
We need to take,
Okay.
Your Honor, we would need to address this outside of presence.
All right, members, just step out just for a moment. I don't think this should take very long. All right. I mean, Ms. Levinsky, if you're asking to approach, I think you waived or said you didn't want to waive bench conferences. So I would ask you to be mindful of that for me. What's the issue?
This is unnecessary and it is more prejudicial than probative to display these items in court. Unnecessary, prejudicial, more prejudicial than probative.
All right. So I'm hearing 403 grounds. And just to make it clear for the record, state's brought in a physical actual door, I believe, and to anticipate that was collected from the scene. We've got the chair that was displayed in the photo. I'm not sure what's in the wrapped with a rug. And we're just going to display these, the state intends to display these physical items to the jury.
Yeah, put the rug down, set it up, and put the chair on top
Okay. And how much, I mean, is that a 5 to 10 minute display?
I would think no more than that. Just a few questions so the jury can see it. I think it does not. I think there are some additional facts that Investigator Barkley is gonna testify.
And perhaps we
Well-
can do this without Investigator Barkley being present.
When you say this, you mean just this discussion?
Yeah.
Perhaps, but I don't know if that's necessary at this point. He's just explaining what the next steps are. So, and was positive DNA actually collected from this door? And that was,
That was swapped, correct?
I can't recall. I presume it was, but I can't recall exactly.
I'm just saying, do we know, I mean, what came from the door?
Well, now that we're out of the presence, there is a blood transfer mark on the door.
And that was tested?
Nothing that actually relates to this defendant, actually.
Well, I know your position would be that nothing relates to the defendant, so
But
under
nothing
the
that
state's theory of the
actually-
case.
But nothing that actually relates
Okay.
to this defendant
All right.
comes from any of these items. So I don't know what
Sure.
the display is about. It's pretty and all that, but
All right, anything further, Mr. Wilson?
Well, yes, Your Honor, it does, what we're trying to do is demonstrate, we believe that there is a blood transfer mark of handprint that is run across, and I think Investigator Barkley testified to that. And that demonstrates the victim's actions, possibly of a victim.
All right. Okay, at any point, I mean, under the 403 standard, if it becomes unnecessarily cumulative or we spend an inordinate amount of time on it, then I will reassess the objection, but I certainly think the state has a right to present the actual physical evidence that is relevant to this case.
Thank you, Your Honor.
And so we will do that, or at least I'll note that the objection is overruled at this time. Did we locate some scissors?
Yes, we did. Do you want me to
Okay.
kind of, well,
You go ahead and do what you need to facilitate a efficient presentation of this evidence as we bring the jury back in. Thank you, Deputy Scott. Okay. Hmm.
I'm making this. It's kind of shearing.
All right, well, we've got a vacuum. We'll make you clean up afterward. Just want to check on it again, Deputy Scott.
Last one, adjourned.
Thank you, Deputy Scott. Please be seated, everyone. State may resume its examination.
Investigator Barkley, I'm gonna point you to exhibit State's Exhibit number 511. Are you familiar with that?
Yes, I am.
What is that?
That is a door that I believe was adjacent to the hallway on the second floor.
And adjacent to the hallway, did you find anything of evidentiary significance on that door?
Yes, there appeared to be a potential blood transfer stain located on that door.
What do you mean by blood transfer?
There was a object, potentially a hand that was bloody that transversed the door.
Could you please point that out to the jury on that exhibit?
Sure. Your Honor, may I, Ross?
Around this location here.
And I'm going to show you Your Honor, at this time I'd ask that State's 511.
Other than the objections previously raised and noted, any further objection?
No.
All right, 511 is admitted.
Thank you. Who was marked as State's Exhibit 512. Are you familiar with that
I am.
item? What is that?
That is a chair that was located in the room as depicted in photographs that may have been involved with artifacts of confinement.
And what did you find as an evidence technician? What did you find significant on that?
There's a couple of things significant about the chair. If you look at the top of the chair, there are artifacts of blood transfer. But if you look at the left side of the top of the chair, there's a noticeable void or a lack of blood on the top of the chair. And also, if you look at the seat of the chair, there's artifacts of potential defecation and blood transfer on the chair.
And is that the chair?
That is the chair.
Your Honor, at this time I'd ask for State's Exhibit number 512 to be admitted.
All right, again, and preserving any previously noted objections. Any further objection, Ms. Levinsky?
No further objections, but proceed.
All right, 512 is admitted over objection.
What do you find significant about that? About the void?
Yes, particularly when you're doing blood pattern analysis, not only is it important to analyze where the blood is present, but it's equal.
Going to object, this witness is not an expert in blood pattern analysis.
I think it's to his significance of collection of evidence, Your Honor. So I do think that I don't think there needs to be expert witness testimony on that.
All right. He's,
He has not been qualified as an expert in blood pattern analysis. He is not an expert in blood pattern analysis.
all right. I don't think he has been tendered as an expert. I agree. I think he is stating at this point his opinion as a lay witness, and this and his ability to do that, if any, is a matter for the jury to consider. And he's laid out his basis for making these statements already. And so objections noted, overruled. You can, if you remember the question, you can answer it.
Yes, not only is it important when you're analyzing items of evidence that contain artifacts of blood, it's important to analyze where the blood is, and also equally important to analyze where the blood is not. In circumstances such as that, we call those areas voids. They're void of blood transfer, which means there could be some type of object that absorbed that blood as opposed to the surface of the item of evidence that's displayed.
And let me draw your attention to State's Exhibit 513. Or do you recognize this?
I do.
And if you need to step off the stand, I'm sure you can to get a better look at it. Is it acceptable?
That's fine.
And what is this?
That appears to be blood transfer, stain resting on the carpet that was in the bedroom that contained the chair.
And how did this carpet end up in this courtroom?
I cut it out.
Okay. And so that's the same carpet?
It is.
All right. Your Honor, at this time, I'd ask that State's 513 be admitted into evidence.
All right. Again, over any additional objections other than those previously noted and preserved?
And the crime
So,
scene-
well, let me check with the defense.
No,
All
no
right.
additional object.
All right. 513 is admitted over objection.
Now, based on your experience, what did you find significant about this?
Well, there's a couple of things that I found significant. Number one, you can see, artifact transfer here, but if you take a closer look at the actual evidence, you'll see what looks like a line of demarcation here. Okay, you have significant blood transfer here, but all of a sudden, as you start working your way to this quadrant of the carpet, there's none present. So that could be due to a number of circumstances.
And anything else you get about that?
No.
Now, when you arrived on the scene, where was the chair located?
The chair was located as depicted in the previous photographs that the state submitted. It was located closer to the drawers where the scissors and tape and those artifacts were.
Okay.
May I take my seat, Counselor, or you want me to? Photograph 2-5.
Let's see here. I'm going to pull up. And this was the scene. There's a different chair there. Was that what you saw?
Yes.
Okay. And in reference to these stains, where would this chair be located?
Well, potentially, if
When you found it?
when I found the chair, it was exactly where it was in that photograph.
So is that a pretty fair representation of where the chair was located?
I would say it would be a fair representation.
Okay. Is there anything outside of this, on referring to states 513, is there anything outside of this general area that you find significant as an evidence technician on the carpet?
In regards to this piece of evidence, I believe the most significant artifacts are the large stain and the chair.
Is there anything else though?
Not that I recall.
You can have a seat. May I just have a moment, Your Honor? Thanks. Your Honor, at this time, nothing further.
All right, Ms. Lewinsky, how would you prefer the room to be set up before your cross-examination?
I would like these items removed if possible.
All right. Do you anticipate referring to these again, Mr. Wilson,
I mean,
at this
totally
time?
depends on redirect, but I
Sure.
don't think so.
At a minimum, let's just move these off to the side against the wall there, out of view. And Ms. Lewinsky, you can just proceed when ready.
Oh, sorry.
It'll just take a moment. You're out.
I'm sorry. Uh,
Oh, thank you, sorry.
um, laptop, up to it.
Gotcha. Thank you. Right.
Good morning.
Good morning. You are no longer a detective, correct?
Excuse me?
You are no longer a detective, correct? I call
That's
you
correct. That is
Mis-
correct.
Mr. Barkley.
Yes, you could call me whatever you like, but yes,
So let's call you Mr. Barkley. Is that okay with you?
that is okay, ma'am.
Okay. So, Mr. Barkley, you had extensive law enforcement experience, correct?
I would agree with that, yes.
And during part of those years and years of law enforcement experience and your training as a crime scene analyst, is one of the things you learned to prepare reports.
Yes,
And when you go out and you analyze a crime scene, you prepare a report, not so?
yes, that's correct.
And you prepare a detailed report as a crime scene analyst or a crime scene technician.
That's correct.
You prepare a detailed report regarding exactly what you did and what you found on the scene.
Correct.
Correct?
Yes.
And is that what you did here?
I prepared a report testifying to the best recollection of what I did to the scene.
Well, did you prepare a detailed report regarding exactly what you did and what you found on the scene? It's a simple question, yes or no?
Well, it depends on what you define as exactly. I didn't record every step I took, but I recorded the general items that I performed on the crime scene.
Why didn't you record every step you took?
I recalled every step that I believe was relevant to the investigation.
I see. Aren't you taught, in fact, to record every step you take as a crime scene analyst?
Well,
As in taking off those purple nitrile gloves, putting on a new pair of purple nitrile gloves, etc., etc., etc.
Well, and typically that's not recorded. That's recorded in pictorial photographs. But yes, you do want to change gloves when you're collecting DNA.
And you want to record what items you collected, where you found them, etc.
Yes, and that's recorded on the property sheet when the evidence is submitted.
You don't record it in any report that you write.
No, when I testify to exhibits, I need the exhibits to be in front of me, and I also need the property sheet to validate that. So no.
Okay, all right. So you talked a little bit about arriving on the scene at 10 o'clock. You don't remember the day, but presumably that would have been June the 28th.
I presume so.
You don't know.
I don't remember the date, no.
Okay. When you arrived at the scene, there were a number of police officers, crime scene analysts, detectives wandering around.
That's correct.
And where did you look at the video footage?
I can't recall. There was a command truck or a command trailer that was located at the scene. I believe that may have been where I reviewed that footage. I can't recall exactly where I reviewed that.
Okay. And from that, you determined the person was wearing gloves.
Yes.
And you then decided not to bother with latent fingerprints.
I believe we dusted for latent prints after the DNA collection.
You did?
I believe we did, yes.
Okay. We didn't hear about that before. So there would be results from latent fingerprint analysis?
I'm sure they're detailed in the reports of the analyst if those prints were good enough for review.
Now, let's see. You went through the house and you saw everything that was in the house, correct?
Yeah, I saw everything to my visibility that was in the house, yes.
Ever see any zip ties in the house?
No, I did not.
Did you see a door standing loose upstairs?
I don't know. I can't recall if it was standing loose. I can't recall if any of the doors that I saw were actually detached from the hinges at that time. I can't remember.
You don't remember that?
No.
It would have been unusual, correct?
Yes, I would say it could be unusual to arrive at a scene and the door be off the hinges.
And finding a door just standing perhaps in a hallway upstairs.
Perhaps.
But you didn't see that?
I don't recall seeing that, no.
Okay.
Not saying that it wasn't, but I don't recall
The
specifically.
door over there, that's the door from the room next to the bathroom in which Miss Thomason's body was found, correct?
The best of my recollection, that door was located on the upstairs floor in the hallway running off the railing. I don't recall if it was the exact door next to the bedroom, but it was located upstairs.
And you removed that door from its hinges.
I can't recall if I removed the door from the hinges. We collected the door, which eventually would require its removal from the hinges, but I don't recall if I specifically did that or another detective did that.
You talked extensively about mitochondrial DNA. You used the term repeatedly, mitochondrial DNA. I was looking for mitochondrial DNA. What is mitochondrial DNA?
Mitochondrial DNA is DNA that's associated with artifacts of the skin. And I believe the mitochondria around the nucleus is what you're looking for to establish identity.
And I think the term you're actually looking for, sir, is epithelial.
Well, epithelial is the cells, but the mitochondria is the element in the cell that you're wanting to examine.
Mitochondrial DNA is something entirely different. It is DNA which is obtained from the mother.
Your Honor, I do object to the form of that question. That sounds like testimony to me.
Well, I will instruct the jury that the questions of any counsel are not evidence. And so the witness can take that question as he chooses an answer if he can. If you recall the question, you can answer it.
Yes, I believe if I hear you correctly, madam, I believe you may be referring to maternal DNA, but mitochondrial DNA is the mitochondria itself is artifacts outside the nucleus of the DNA or of the cell.
Who were the detectives that you were ordering to do their work?
I can't recall specifically who the detectives were.
No idea whatsoever.
I believe one detective was William Johnson. I'm not sure if Detective Delaney was at the scene. I can't recall. But the one individual I remember specifically was Detective Will Johnson.
So let's see. What did you specifically do at the scene?
I'm sorry?
What did you specifically do at the scene?
Well, in this particular case, I analyzed the scene and I issued directives to detectives on what I believe were the significant areas of evidence for collection.
You did not collect evidence yourself.
Well, I collected the carpet. I believe I collected the chair. There may have been some swabs that I've taken, but again, I would need to see those actual exhibits of evidence along with the property sheet to be able to validate that.
And when you entered the master bedroom, did you see anything else in the master bedroom other than the sheets?
I saw artifacts of defecation. I believe there were artifacts of blood stains in that bedroom.
Anything else?
Broken mirror. Some of the drawers were pulled open and a jar in the dresser drawer as though they may have been rummaged through. But that's the things that come first to mind.
Do you have any recollection of a purse lying open on the bed?
I don't recall a purse. I remember seeing articles on top of the bed that could have come from a purse. But yes, there were articles on the bed that look like they may have come from some type of personal belonging.
And you did not do anything with those articles?
Not that I recall.
And you did not do anything with any other items of evidence that you can recall other than these 3 items and maybe a couple of swabs?
That's correct.
May I have one moment? You talked about the point of entry as being the first place to start. Where was the point of entry?
If I recall correctly, I believe it was either a window or a door.
Do you know which window or door?
I believe it was located at the back of the house.
You don't know whether the door was open, unlocked, forced open?
I don't recall any forced entry, and I don't recall whether the door was open when I arrived. As I said, detectives have been on scene for a number of hours before I got there.
Anybody talk to you about forced entry, show you a broken door,
I don't recall that.
show you a broken window? You spoke about a broken window earlier.
I don't know if I spoke about a broken window.
You did.
Okay. I don't recall a broken
A
window.
mistake.
Okay.
You had looked at video footage which showed how many angles of entry?
I believe just one.
1. And that was where? Into the back?
It appeared to be the back of the house, yes.
And that was all you looked at?
Yeah, that's all I saw, yes.
And you saw one person?
That's correct.
And how long did you look at that footage for?
And until it was exhausted, I believe at that time it was like 15 minutes. I can't recall.
I have nothing further for this witness. Thank you.
Any redirect?
Thank you, Your Honor. Mr. Barkley, when you arrived on the scene, could anybody come in and come out of that scene?
No, the scene was secured, and I myself had to sign the crime scene log before I obtained entry.
So there was nobody there other than officers from Sandy Springs,
That's correct.
and you knew who they were, and that was documented.
It should be on the crime scene log, yes.
Okay.
I can't recall exactly each officer, as I can't recall exactly each detective, but all that should be documented on the crime scene log.
Okay. I want to show you what's been entered as State's Exhibit number 110, you referred to you personally collecting some items as evidence. Are those indicated in this exhibit?
Yeah, I believe I collected the scissors and the Scotch tape, yes. Again, the property sheet would designate that.
Nothing further.
Any recross on those points?
You don't remember?
I don't remember.
I have nothing further.
All right, can this witness be excused?
Yes, sir.
Thank you, sir. You can step down. State may call us next witness.
Your Honor, the state calls Investigator Bryant. Yeah, we do. Please state your name.
First name is Jana, Jannah. Last name is Bryant, Bryant.
Okay, Investigator Bryant, can you tell the court where you are currently employed?
With the Sandy Springs Police Department.
And what do you do with the Sandy Springs Police Department?
I am the GIS analyst.
What is the GIS analyst and what does GIS stand for?
GIS stands for Geographic Information Systems.
Okay. And just briefly tell us, what does that mean when you say geographic information systems?
The geographic is geography. Basically, any mapping, any location-based data involves mapping and analytics.
Okay. How long have you held that title at Sandy Springs?
10 years.
All right. And can you talk about your day-to-day role as a GIS analyst at Sandy Springs Police Department?
Yes, I do. So I work in the intel unit, and it is definitely a support unit, mostly to the detectives in CID. So any mapping requests regarding cell phones, we also do a lot of research for the detectives.
Okay. Can you describe your education and training that allows you to work as a GIS professional at Sandy Springs Police Department?
Yes. So I have a degree from Kennesaw State University in GIS. Prior to working for the Sandy Springs Police Department, I worked for a private company that did utility mapping, utilities being electric mapping. I did that for 3 years prior to coming to the Sandy Springs Police Department. That was all mapping, all location-based database mapping.
Okay. All right. And when you say you got a degree in GIS from Kennesaw State, what type of degree did you obtain?
It's a Bachelor of Science.
Bachelor of Science, okay. And can you describe your geographic information systems degree Can you describe what type of courses or training was involved with that education from Kennesaw State?
Yes, so the most basic course would be the cartographic part of mapping, which is just the visual parts, all the elements that go onto a map. There were more advanced courses dealing heavily in geodatabases and mapping large data sets.
And what is a geodatabase?
Well, the geo stands for geography. It's a database that has all the data in it has location. And location can be an address or it can be coordinates, latitude, longitude,
Okay.
that type of thing. But all the data has a location attached to it.
Okay. Did you study process involving building geodatabases and study that technique at Kennesaw State University?
Yes, yes.
And did you utilize, or were students at Kennesaw State in that degree program taught to utilize computer software in their studies?
Yes.
And describe that, and what type of training did you receive at Kennesaw State during that degree program on computer software?
So the computer software is called ArcGIS. It's pretty much the only software used in all businesses, government that deal with GIS. And you get large data sets. You can you map large data sets, and you can do a lot of different analytics. The analytics can be typically with GIS, you're answering a question. You get the location data, and you're answering a question. Well, why is it there? What do we need to do? Is there something else we need to do with this data? You can attach descriptive data to locations, find out why something is where it is.
Okay. Are you familiar with the term geofence?
Yes.
Can you tell the jury what a geofence is?
A geofence is a virtual boundary around a set of coordinates.
Okay. And in what context would you say use a geofence, either at Sandy Springs or any other capacity that you've worked in your professional career?
So typically with a geofence, you're wanting to see everything inside the boundary. What is inside this boundary? Other applications for a geofence would be like how many times something goes in and out of the boundary. So yeah, you're looking at what's inside that boundary.
All right. And can you tell the jury if you studied geospatial science, and what is that?
So the geospatial science is what locations and why they're there in all over the earth. Geospatial science is just another term for GIS. It doesn't just mean the data and the databases. It means also the software that you use, the hardware that you're using, servers, databases. You learn all of that in the degree program.
Okay. Have you engaged in ongoing training or education since you've gotten your GIS degree from Kennesaw State?
Yes.
Okay. Can you describe the trainings that you've pursued since you've graduated from Kennesaw?
Yes, I don't know how many hours. There's a lot of hours basically with cell phone mapping, record analysis, cell phone record analysis, and also mobile forensics.
Have you had an opportunity to take courses related to smartphone and cellular technology in
Yes.
particular?
Yes. Typically, that course and a lot of the courses are just to keep up to date with the technology. A lot of these courses you learn about the devices, what's contained in the devices, what kind of data is contained in those devices, how they reach out to cell towers, the technology used for doing that, and mapping.
Let me ask you this. How many hours would you, just an approximate number, would you say you've undergone training in cellular technology itself?
Probably 145 hours.
Okay. Now, I want to turn your attention to one thing you mentioned. You were talking about your previous work history, and you mentioned that you did mapping for a utility company. What did that entail?
So the company that I worked for had contracts with utility companies to map almost always its power. So that would be like the telephone poles, the lines, substations, any equipment associated with that underground, above ground mapping of all that type of equipment. And then in the end, delivering a product
Okay.
to the companies that we had contracts for.
All right.
It was all mapping.
Okay. How many ballpark, how many instances would you say you had a chance to perform that function of mapping for that utility company?
It was every day,
Okay.
every single day.
During that 3-year period?
Yes.
All right. Now, turning to your experience at Sandy Springs, have you had an opportunity to work with geofence data? And how has that been done? And what have you done with that data since you've been at Sandy Springs Police Department?
Well, this case, this case was the first case for this Sandy Springs, but even after that, there probably were, maybe 2 other cases for geofence
Okay.
data.
All right. And what did you do with those cases? Just kind of describe the techniques that you use for those as well.
Where you get the data from Google and you put it into the software and the software maps it for you.
Okay.
Then you just run analysis. The analysis can be pretty simple. Just an idea of the number of devices within that geofence, how they're spatially located. Are they sitting on top of each other? Are they spread out? Are they more sporadic?
Okay. And can you tell the jury how many cases in particular that you've worked on while you've been at Sandy Springs where you've utilized either Google records, geofence, or geofencing data itself?
Probably 3 with the Google data, but with cell phone mapping, hundreds.
Okay.
There would be hundreds of cases.
All right. And the mapping with cellular technology, how does that similar to other types of mapping, say if we're talking about geofencing in particular?
Well, typically with all the mapping, all the towers have location. They have a latitude and a longitude that locates the tower. So if a cell phone is accessing that tower for anything, for a call, for data, any type of messaging, we know immediately in the general area where that device is.
Okay. All right. Your Honor, at this time, the state will move to tender Investigator Tatiana Bryant as an expert in historical cell site data analysis, cellular phone technology, geofence software, and cellular device location information.
And Your Honor, I'd like to warn you.
All right.
I'm not sure, do I call you crime scene analyst, what I believe? Detective or just
You analyst.
analyst? Good morning.
Good morning.
So let me ask you. You were asked, you told us today that you had, and perhaps take this along, but I think you told us today that you had some 145 hours at, since you've been at Sandy Springs.
Approximately. Yes, ma'am.
Now, in April of this year, Mr. Fawcett contacted you. That's Mr. Fawcett, incidentally. He contacted you and he asked you about your training on mapping mobile device locations and cellular records. Do you remember that?
Yes.
And you told him you have approximately 56 hours of outside cell phone record analysis and mapping training.
Yes.
And that includes cost basic certification.
That's correct.
So there's a difference between 56 hours and 145 hours.
Yes, ma'am.
Do you want to try and clarify the difference?
Sure. I went back and calculated, went back through all the classes that I had taken and calculated the approximate hours that I had taken. So when I initially gave him that, it was just off the top of my head. I went back and calculated.
Let's see, when did you take those classes?
They were spread over, probably the first one would have been in 2017.
Actually, 2018, judging from your resume.
Okay, yes.
And most of those classes were 21, 22, 22 and 23. And let's see, when did you become certified as crime scene analyst?
That was in 2024.
So when did you do your work on this case?
Initially, I believe the first set of Google data came in 2019.
So that's when you did your work on this case.
Yes.
And at that stage, you had how much training?
Well, prior to the Sandy Springs Police Department, everything I did at Davie Resource Group was mapping, location-based mapping.
Yeah.
Plus the degree that I had, all the classes I took it was all location-based mapping.
I have nothing further. Thank you, Your Honor.
All right. Any response to the state's tendering?
No, Your Honor, we would just renew our motion to tender Investigator Bryant as an expert in the category we just defined. I'll say those again for the court. Historical cell site data analysis, cellular phone technology, geofence software, and cellular device location information.
All right. And any response from the defense?
No, Your Honor.
All right. The state may proceed.
Investigator Bryant, did you receive or make a request to receive any records from Google in this case? And if not you personally, I'm referring to Sandy Springs Police Department.
Yes.
Okay. And typically when records are received from Google, how does that process work?
Well, the investigator that did the search warrant would send me whatever he's requested from the carrier or Google.
Okay. And when you receive those records, what do you do? Or what did you do in this case after that?
Immediately mapped them.
Talk about that process, and you've talked about your training, but talk about specifically what you did for that process of mapping in this case.
So I open up the file. It's a comma separated file, which typically opens in Excel, a spreadsheet, visually inspect the data. in this particular case, there were not a lot of rows of data. I believe 124, 25 rows of data. Visually inspect, look at all the field headings, the columns to see what data's in there. Then after inspecting, I put them in the mapping software, ArcGIS.
Okay.
Yeah.
Investigator Bryant, I'm going to hand you what's been marked. Well, actually, I'm going to move to tender this in. Your Honor, this is Exhibit 499. This is a thumb drive of the contains the records received from Google. And I have what I've labeled.
Now, I haven't seen the content of what's on there as opposed to what I've received. Am I assuming it's correct? It's identical.
What we gave you, I copied to this thumb drive.
Okay.
You want to review it?
Well, we'll just go on that representation, and if you review that later, we'll revisit if there is any discrepancy. So there's I think you were finishing your tendering of 499.
That's 499, the thumb drive of Google Records. 499A is the notice that the state provided of our intent to introduce business records in this case, along with the affidavit and certification from Google itself.
Which was objected to back in November of 2023.
I believe that was before Judge Carnesale. Was that was during a motions hearing before, and she ruled on that, did she not?
Don't know that she ruled on it,
All right.
or that it was ever ruled on.
I guess you can show me in the exhibit if you don't mind. All right, so the grounds to your objection to 499 or 499A, just generally the rule and the grounds, if you have any currently, Ms. Levinsky?
Your Honor, this was very specialized technology, which one would expect Google to testify about.
All right, so your grounds were that this is not appropriate as a business record, is that right?
Yes.
Okay,
It's not a business record.
all right.
Google does a specific search.
I'll find the certification from Google at the end of that document.
Right. I do wonder in here, there's the search warrant itself. Is that also what you're tendering as a document?
No, the primary piece of that is certification, so I can check everything else out.
Okay. All right, we can perfect the record on this at a break, at the appropriate break, but at this time, again, with the caveat that we're assuming the contents of this thumb drive are the same, and defense counsel can bring it to my attention if at some point during the trial they realize that it is not. It is admitted over objection. State can proceed. Do you want this back? Well, if I can hang on to this one, unless you're.
All right. Now, Investigator Bryant, I want to hand you what's been marked previously, Exhibit 498. Can you tell the court if you recognize this exhibit?
I do.
How do you recognize that exhibit?
I made this exhibit.
Okay, what is it?
This is the analysis, the breakdown of the devices that were in the geofence.
Okay. And do you know whether there was a specific account in particular that, a specific account later identified that's included within those records that were?
Yes.
received?
Yes, there's an ID.
Okay, and who did those records belong to? Or the ID itself, who was that associated with?
Well, at this time, I didn't know. I mean, mapping the software is just, this part of it was to determine which ID I suggested to Detective Williams, you should request this particular ID from Google.
Okay, but ultimately, were you able to find out the ID itself?
Yes.
Okay, and what was that?
Are you asking for the number that's on here, or?
Is there a name associated with it?
Yes, James Jones.
Okay. Now, and that exhibit 498, is that an exhibit that you prepared via analysis using those Google records?
Yes,
And the Google records that were retrieved and requested in association with the homicide at 1095 Woodbine Road?
yes, they are.
All right, Your Honor, at this time, I will move to tender in Exhibit 498 as a demonstrative exhibit to aid with testimony.
Objection to 498.
None, thank you.
498 is admitted.
All right, I am now, for the record, publishing the first page of Exhibit 498. Can you tell us what we're looking at and describe the different parts of this exhibit?
Okay, the image is 1095 Old Woodbine.
Your Honor, I do have an objection.
Oh, all right. I'll let you state the objection
Your
for the
Honor,
record,
it
but
needs
then
to be taken up outside the presence of the jury.
if you can give me just the rule number without the basis for now.
There is I'm trying to think of how to phrase this. Assumes facts not in evidence. It definitely assumes it's not in evidence.
All right. Mr. Fawcett, I'll ask you to confer with Ms. Lubinsky, and then you can tell me whether you believe that this is something the state will be able to connect later under 104B.
Oh, sorry, and on the next page, yeah.
See, we should get out outside for it.
All right, members of the jury, let's take 5. We'll be back with you.
The next map.
All right, Ms. Lubinsky, jurors have exited. You can describe your motion.
Assumes fact,
Objection.
sorry. if we
Objection,
can
rather.
Do it without the witness in the room, please.
All right, ma'am, if you can step out. While she's stepping out, I'll give you a minute. You can just complete the record on your objection to the business record, State's Exhibit 499. You have anything you wanted to add to that objection?
Yes, Your Honor. Geofencing data is not like I issue a warrant for a cell phone record and the cell phone company does a search and gives me my records. That's not how it works. Geofencing records are a situation in which Google has to go through millions, thousands, millions of records in order to locate the records of the persons who are in the particular area at the particular time. It is not a business record kept in the normal course of business. It's an analysis of records kept.
All right. I think I understand the argument and the objection. Some of this, I think, was actually touched on a little bit by the Supreme Court in a different context, rather. But in terms of the volume of the records that are reviewed or the manner they're reviewed, in this case,
And that was a different argument.
and I understand that. I'm just noting that this theme was addressed somewhat, but the objection is preserved for the record. I'm based on the business record standard and my understanding of how it applies. It remains overruled. So for the facts not in evidence.
Okay. Thank you, Your Honor. Your Honor, there is the state played video footage for the jury. The video footage that they played did not show anyone walking up the driveway of the victim's house. They specifically did not do so.
Okay, connect the dots for me. Is that in this demonstrative?
It is in this demonstrative.
Is that in the video somewhere?
Your Honor, it may be in the video, but it's not evidence before this jury. And it was not played before this jury. And Your Honor, this witness in her demonstrative gives a time. Approximately 1 a.m. to 1:37 a.m. And that again is a fact not in evidence because, as Your Honor will recall, Detective Sautel yesterday had no clue what the time difference was. He couldn't tell us what time the incident occurred.
Are those the sole grounds for the facts not in evidence?
Yes, Your Honor.
Okay. So, Mr. Fawcett, the video exhibits that were tendered yesterday, I suppose this would be Exhibit 506. Even if it was not published to the jury, did that contain the sum total of all the surveillance footage?
Sum total of all the videos. And I had one more thing to add.
All right.
I can clear this issue up with another question or two from Investigator Bryant because she watched the videos in their entirety. I want to say probably it took about 6 months for the entire Google records to come in through over the course of 3 phases. So they're watching the surveillance video during this period, trying to get insight as to what they need to look for. So she's got very detailed information about the entire 3-hour window that this defendant was at the residence, and she can testify to that.
All right. And even if she couldn't, I think you would actually be permitted under the rules to connect it up later through an additional witness.
And Your Honor, the timing?
If she can testify to that, we'll see.
She can.
And or if a later witness can also clean that up. And if they're unable to, then you can re-raise your motion through a motion to strike and potentially a mistrial if it's that prejudicial. But the rules allow this kind of flexibility. So the objection's noted.
The evidence, Your Honor, it's that prejudicial.
And if it gets to that point that they're not able to connect it up, there is a remedy. So with that, if we could have our witness come back in, and as they do, Deputy Scott, if you could check in with our jury. Deputy Scott. As the jury's making its way in, Mr. Fawcett, was there another witness you're trying? Well, no, we're not getting to another witness before lunch. Strike that.
I'm asking the jury.
Thank you, Deputy Scott. Thank you for patience, members of the jury. I believe our witness should be coming back to the stand soon, and then the state will resume its direct examination.
Okay. Now, Investigator Bryant, did you have an opportunity to view the surveillance video in connection with this case?
Yes, I did.
And was that prior to receiving or while the Google records themselves were coming in?
Yes, it was prior.
Okay. How many, can you describe, the process of watching the video and what you were looking for?
Any type of clue, something that the person was carrying, noting where exactly they are visually, like locate, like where they're walking.
Okay. Were you able to see where the suspect, the person of interest, was on the property while viewing the surveillance video?
Oh, yes.
Okay. And do you recall what portions of the residence you observed the suspect walking while you were viewing the surveillance video?
Yes.
Okay. What areas in the residence did you see that?
Along the edge of the driveway, on the driveway itself too. This would be the western side of the driveway, walking up the driveway.
Okay.
Also in the back, on the patio.
All right. And are you familiar with the block of time offhand that was believed that the suspect was on the 1095 Woodbine Road area?
I don't recall the exact time.
Okay. But did you watch the video and the different cameras in total to try to ascertain that?
Yes.
Okay.
Yes.
And how many times did you watch the video?
It would be a guess, but 20, 30
All right. All right.
times.
I'm going to turn your attention to State's Exhibit 498, and we're going to go to the second page of that State's Exhibit. Can you tell us what we're looking at on the screen when it pops up? And specifically the area, and start with the red dot in the middle of the screen and tell us what that is.
So I don't have that. Can you, there's a, on my screen, it's blocking, it's like stay muted, unmute, and it's blocking the image here.
The blue button.
Oh, is it touchscreen?
Yeah.
Sorry, my bad.
Okay, can you tell us what we're looking at?
Yes, this is a map of 1095 Old Woodbine. The red dot represents the coordinates.
Okay,
Um,
and up to the top right, what is that? Top
The
right,
address.
the 1095?
Yes.
And what is below that?
The latitude and longitude coordinates,
Okay.
basically on top of the house.
And kind of walk us through what you highlighted on this demonstrative exhibit and why you did that.
So both those yellow areas, that's exactly where I saw the individual walking in the video.
Okay. I'm gonna turn to the, and if we're talking about the gray shapes around, do those represent other residences in that
Yes.
neighborhood?
Those are the footprints of other homes.
Okay, all right. We'll turn to page 3 on the state's exhibit. Now, did you obtain latitude and longitude of Google devices in that area and talk about that in connection with the Sandy Springs investigation?
So this is this is the, I don't know what I'm seeing here.
You also, if the court will allow.
I got it.
Okay, you can stand up and show the jury.
So this is the actual spreadsheet. This is an image of the data that I received. Device ID, the date, the time that was notified, the latitude and longitude, the coordinate, the point that's going to be on that map. The map display radius in meters, all that means is this latitude and longitude, that dot can be within 11 meters. That device can be within 11 meters of the dot, the latitude and longitude. The source is how Google obtained that record. This one is through GPS, Wi-Fi network.
Okay. And what are the 12 columns themselves? What do they represent? When we're talking, I guess 12 columns, 12 rows. This is 1 through 12. What are each one of those?
An example.
Okay.
Instead of having the entire spreadsheet, this is an example of what was in there.
Okay. I'm going to turn you to page 4 of the state's exhibit. Can you walk us through each of the numbered boxes and describe that and what each one of them are?
So in my initial visual analysis of the records, there were 7 total devices in there. This device, there were 44 rows. At the time, that's the plotting, the mapping of that device ID.
Okay, I'm gonna leave it alone. Go ahead.
Again, each individual map represents all the devices that were in that geofence. 4 rows, all of the rows were time stamped at 3:23 a.m. Next, this device ID, there were 8 rows in there. So there's 8 points, basically. When I say 8 rows, there's 8 points there. Here, there's 4. They're just sitting right on top of each other. For this device ID, those are the timestamps for the 8 points. Same thing, just continuing down for all the devices that were in that geofence. These device IDs are anonymous by Google. They're just random assigned to the device. 12 rows, 12 dots sitting on that map and the timestamps. Same thing here. 7 rows, the time frame. So 7 dots are there and the time frame they were collected. Same thing with this device ID. 5 rows and the time frame.
And each of these boxes, they represent different devices?
Yes.
Okay. I'm going to turn your attention to slide 5 from the state.
So as I previously stated, this is where the individual could be seen on video walking. This particular device is very close to that area, unlike the other devices. So again, I suggested to Detective Williams, I would request this device from Google.
Okay. And so out of these 6 boxes, so with this on slide 5, does that make it 7 total devices you were looking at?
Total devices.
Okay. And when you're looking at slide 4, you're basing your interest off of what is circulating around the red square, which represents 1095 Woodbine?
That's correct.
Okay.
So this is the 1095 Old Woodbine. This is where the individual was seen in each one of these maps. And you can see where the other devices were located within the geofence.
I'm going to turn your attention to slide 6. And can you explain the significance of your highlights on that exhibit?
Yes, so this is that virtual 100-meter search request that Detective Williams asked from Google. Again, that's 1095, the latitude and longitude on top of the house. And then this is all the devices mapped together.
Okay. And are you familiar with, and I'm going to turn you back to slide 5, just to reiterate, what is the time period that you were looking at the movement on the surveillance videos? Can you tell the jury that time again for the record?
It would be a approximate time, I know, beginning probably at about 1 a.m. And then the car, the vehicle leaves the residence. It was slightly before 5 a.m.
Okay. All right. And when you say that, that's it, thank you. When you say that the records themselves, initially, when you receive these records from Google that you use to I guess, create these maps, how soon after we have the report or the incident, June 27th, 2018, did you actually perform this analysis? You recall that?
Yeah, this, I believe, was in October of 2019, I believe.
Okay. And do you know if Sandy Springs Police Department had all the records? Had they received all the records from Google at that time?
Well, they had received phase 1. I think the Google stuff comes in phases. So this is the initial, yes.
Oh,
they
so
had
what
received.
typically comes in the initial phase from Google?
So the initial request is I need to see all devices within a confined time frame and a confined area.
Okay. And so when you got those devices, you were just concerned with what was around 1095 Woodbine, is that correct?
That's correct.
All right. And so what was the next phase of records that you received, and what, well, was there an additional specific request from Google once this analysis was performed?
Yes.
Okay, and what was that?
Detective Williams requested that device ID labeled on the map,
Okay.
on that last map.
And just so I'm clear, what was the reason that Detective Williams requested the specific device, I guess, in the 7th device? What was that specific reason?
The reason he requested
That's correct.
that, yeah, because the suspect was seen on video in that area.
Okay. All right.
Okay.
All right. And is that information you relate to Detective Williams?
I'm sorry?
Is that information that you relate to Detective Williams?
Yes, it was.
All right. When I hand you back, State's Exhibit 499A. Now, just want you to read into the record this section, what it is, and what, just read these 2 lines for the, well, yeah, read these 2 lines into the record for the jury.
So
And just for the record, this is,
I'm sorry, you want which lines?
just, recovery.
Okay.
And then this, but this is a 499A for the record. If you could just read that into the record.
Account recovery. Recovery email, jamesjones00@hotmail.com. Recovery SMS, 1-404-838-3782, US.
Okay. Now, Investigator Bryant, now we're talking about 1095 Woodbine Road. Did you have information on any other locations that the suspect in question may have been at or where you were looking at during the course of this investigation?
For that particular device, yes.
And what other areas were you looking at?
Well, we received a second phase from Google only for that particular device.
Okay. And what did you do with that information once you received it?
I mapped those locations.
All right. And can you tell us anything in particular about where, if any, what movement you saw that phone or location you saw that phone at that night?
Yes.
Okay, and where did you see that phone?
I saw that device move from Chamblee, the Chamblee area, into Brookhaven, then to Old Woodbine.
Okay. And is there any indication that you have as to the mode of transportation or how that travel was made?
Yes. In
And
my
how was-
opinion, the device, it was walking.
Okay. Is there any, when I say transportation, do you have any evidence of any type of vehicles that were utilized to make this transportation?
No.
All right. At any point, do you know if Sandy Springs received any records from MARTA? In particular, any surveillance video or information related to MARTA itself?
Yes.
And what information, your understanding of what information was received or requested from MARTA? You aware of that?
I believe the train station in Chamblee, there was video from there.
Okay. And when you were tracking that device, were those records you received, was that consistent with MARTA locations along that route? Was that consistent with
Yes.
that?
Yeah,
Okay.
they were right across the street from the train station.
Okay. The locations that where the
Yes.
Jones phone was? All right. Did law enforcement, do you aware if they considered that the travel was made via MARTA? Are you aware if that was a part of the consideration?
I may have been at the time. Yeah, at the time, yes.
Okay. Okay. All right. This will be.
No. One map was turned over to me and that was not it.
This was I.
No,
Okay.
not it.
That's pretty much it was turned over. It was a discovery.
Actually, certain emotions.
So that's an example.
Not that.
That wasn't.
I'll see what was.
Yeah, I would ask for a break. I think we need to discuss next exhibit we intend to use, so I would like to take a 5-minute break to discuss that with the court.
All right, are there any further topics that you're going to cover on your direct examination with this witness?
No, Judge. Well, other than that.
Why don't we do this? I'll allow you to revisit that if applicable during redirect. And we can begin cross-examination on what she has already covered now. And we'll go from there to best utilize the jury's time here.
So you want me to start cross now?
And we'll revisit this during redirect and recross if we need to.
Okay. Thank you, Your Honor. Ah, found him. So let's see. And we said we were going to call you analyst, Bryant.
Sure.
Correct. When did you first learn about geofencing warrants?
When did I first learn about
Geofencing warrants?
it? Probably maybe 3 weeks prior to this warrant. It was a new thing
And how did you learn about it?
from Detective Williams.
Okay. And you never worked for Google.
No, ma'am.
Did you have any experience in the technology industry?
Well, GIS is technical, yes. So yes, I had prior working experience in GIS, in mapping.
Do you know how Google obtains the information, the location data, which it supplies to your agents?
I have a general knowledge of how they obtain that data.
You've heard of the sensor vault,
Yes, I have.
and you are aware that the information is stored in something called a sensor vault.
Yes, ma'am.
And you don't know where the sensor vault is.
No, ma'am, I do not.
And you don't know where or on what server Google manages this data.
No, ma'am.
And the sensor vault is managed by Google employees.
That's my understanding.
And you don't know who has access to it.
No, ma'am. Google.
And you don't know the security protocols, if any, that are implemented to protect the data from breach, manipulation, or loss, correct?
No, ma'am, I do not.
And you don't know what third parties may have had access to the data before it was disclosed to your agency.
No, ma'am, I do not.
You don't know if there are any errors in the vault.
No, I do not.
Are you aware that Google claims to accurately capture roughly 68% of users within its confidence intervals?
I'm not familiar with the stat. No, ma'am.
Would you agree that it is that Google in effect deals with Android devices?
Yes, ma'am.
So that if an Apple device was being used, it might not be captured on the geofencing warrant if the person did not have a Google account.
You need to repeat that for me, please.
So let's start with this. The Google location data comes from Google, correct?
That's correct.
And Google does Android devices, not Apple devices.
That's correct.
And what, 50% of people in the country use Apple devices?
I don't know the stat.
But a large number of them do.
Probably.
And Google only captures data if location information is switched on, correct?
In general, yes.
And that means if the device is switched on.
The device has to be powered on. Yes, ma'am.
If a device is powered off, then Google is not going to capture any data from that device, correct?
If it's off, no.
And if it runs out of power, it's not going to capture any data from that device, correct?
Likely not.
So, and you know that Google only obtains location data if people opt in to location or making their location available to Google.
I believe that's a current Google practice. Yes.
Now, you told us, I believe, that you had looked at these videos, correct?
Yes, ma'am.
And when you looked at the videos, you saw a person along the edge of the driveway
Yes, ma'am.
and the back of the house.
Yes.
But you're not sure of the time.
No, I know the general time from approximately 1 a.m. until the vehicle left the house, which was slightly before 5 a.m.
I think that you may be a little mistaken. It's actually after 5 a.m. But on the,
Approximate.
where do you get those times from?
The video, the known, yeah.
The times on the video.
No, ma'am. Not on the video itself.
Ah, do you get them from somewhere else?
Well, I believe the timestamps on the video were off.
So who gave you the times?
I believe the CSI adjusted the times. They looked at maybe at a live view.
Do you know who did that?
Not probably Detective Sautel or Detective Williams.
You have no idea.
No, it was one of them.
So you have no idea what time this offense actually occurred, correct?
No, I do.
Now, while you were looking at the video footage, did you see a person walking in the back with a cell phone to his or her ear?
I don't recall
You don't
if there was a cell phone.
You don't recall that. So you obtain these geofencing records. And this is the first time you've ever seen geofencing records.
This is the first case of Google records. Yes.
First time you've ever seen them,
Yes.
ever.
Yes, ma'am.
So you look at them and you see there are 7 devices pictured on this document.
There were
correct?
7 devices in the data. Yes, ma'am.
One device ends with the ID 86, correct?
I would have to look at the list of the devices.
You don't have it with you?
No, I don't.
Mark for purposes of identification as defendant's 30. You said 13? 30. 30. Do you recognize the document I've shown?
Yes, ma'am.
What is that document?
This is the data, the Google data.
Is that the data you received from Google?
It looks like it, yes.
You can't say for sure?
Yes, it is.
Okay, all right. So you look at that, and it's got latitudes and longitudes, and you have to figure out addresses from those latitudes and longitudes, correct?
No.
You just map them.
Yes. You map the latitude and longitude. You don't have to figure out addresses.
Okay, so you never figured out an address at all?
No.
Okay. So you don't know where those devices were, other than on your little maps. Is that correct?
That's correct. The mapping software maps the data using the latitude and longitude.
And incidentally, you just look at the location, and if you look at the device with ID 427-49146, it appears to show as being actually inside 1095 Old Woodbine.
That's correct.
But did you obtain information regarding that device?
Yes, ma'am.
Because you did not know who that device belonged to.
Yes, we did in advance. We did.
You did.
Yes.
How did you know?
Detective Williams got the victim's Google information.
Now, so what you did is you looked at the fact that a device was moving in the area of Old Woodbine, correct?
That, in my opinion, it was moving in the area where I saw what I saw on video.
And
That's correct.
it does not appear to have been in the house.
No,
It never appears to have been inside the house.
they're mapped. I mean, it's on the map.
And on the map, it does not appear to have been inside the house.
That is correct.
And if you look at the document in front of you, there is no location information whatsoever for that device from 3:14 a.m. Is that correct?
That is correct.
What does that mean?
In my opinion, the device was powered off.
Powered off or lost power?
Yes.
May I have one moment? Sorry, let me get this straight. Did you see the warrant that Detective Williams prepared in support of the geofencing warrant?
Yes, I did.
And you watched the video footage, I think you said probably 20 times?
That's a good guess, yes.
And you never saw anybody with a cell phone in their hand?
No, I didn't. Not what I thought was a cell phone.
And you saw that in his warrant in support of the geofencing in his affidavit in support of the geofencing warrant, Detective Williams referred to the suspect using a cell phone,
Yes, he did.
but you never saw that.
Okay. I wasn't looking for that.
You weren't looking for that.
No, ma'am.
I thought you were looking for any piece of information whatsoever that could help.
I was mainly focused on location,
Okay.
where he was.
And it didn't strike you as odd that if the person had a cell phone and they were using it at 4:43 a.m. and their phone was off at 3:14 a.m., couldn't have been the same device?
I don't understand your question.
If a device is off, it couldn't have been the device that was being.
If the device is off, it's not being used.
And the device that you said was not in the house, correct?
Which device are you?
The one ending in, well, let's make the ID clear. 12588219290. That device was never in the house,
Well, the locations did not show it in the house.
did not show it in the house, and it was powered off from 3:14 a.m., and that is the device you connect with James Jones.
Yes, ma'am, that's correct.
I have nothing further.
All right, Mr. Fawcett, why don't you redirect up to the point where we have that pin?
Now, Investigator Bryant, can you tell the court what can you do with that? When we talk about latitude and longitude, what can you do with that information?
You can map it.
But specifically, what does the latitude and longitude, what exactly does that tell you?
In this case, it represents, each dot on that map represents a device location.
Okay. And now, can you tell the jury, based on your knowledge and experience, is there a range in terms of meters, inches, yards, feet that you can tell us as terms of the proximity that a dot will be in terms of a phone or device? The dot representation on the map, what proximity and distance is that?
Well, Google gives you that in that data.
Okay. And so are you able to tell the jury what information you were able to obtain as far as the distance in this case?
Well, each location, each device location in there has a display radius in meters that Google is estimating based on Wi-Fi, GPS, or cell.
Can you speak in general terms about, on average, what meters, what is typically reported in terms of distance?
So typically when I'm looking at data like this, I am not looking at one dot. I'm looking at the entire group of dots.
And why is that?
That is the story, not one, because the locations are not precise. That's why they give you that display radius in meters in the data.
So when you say the locations are not precise, they give you the range of data, how are you able to use that range of data to get it, I guess, as close as you can to an accurate figure?
I just go by what Google is telling me. So I can't, I saw him walking, I saw the suspect on the video along that driveway. When I mapped this data, that device was in that area. There were one or two that were in in the box that I outlined. He was in that area, and it was a scattered pattern. All the other devices, the majority, whether it was 4 locations, 4 dots, or multiple dots, they were essentially on top of each other. What that told me was that device was still. It was not moving. This particular device, because it was more scattered than the others, suggested to me that, in my opinion, it was moving around,
Okay.
just like what I saw.
When you're looking at, you talk about devices that are basically on top of each other. Are those devices that, based on looking up, do you believe may actually be either at the residence or inside a different residence?
That's correct.
Okay. And even though you're looking at phones or dots on the map that appear to be scattered, but they're close together, your testimony is that, based on your experience, that could still be in the same house.
Oh, absolutely.
Okay. And when we're talking about location data in particular, latitude and longitude, how detailed is that information? I'll give you an example. Will that tell you on, in particular, what side of the street, say, a person is on?
Maybe not.
Okay. And what do you mean by that?
Well, I mean, I would look at the path. So the phase 2 data that I mapped, I saw the path. It wasn't necessarily on one side or the other, but it was in totality the path that was taken to 1095 Old Woodbine.
Okay. Have you had cases where you've had the benefit of Google records to perform an analysis?
No.
Okay. Well, in a case like this where, well, a case in general, where you're looking at Google records and that is the only data that you are looking at, would it benefit you to have additional data?
Yes.
And so in this case, how much of an additional benefit did the ability to go and look at surveillance video and compare that to the Google records, how beneficial was that?
Very beneficial.
Okay. All right. That's all I have, Judge.
All right, members of the jury, before we break for lunch, there's another issue I have to take up outside of your presence. I think it should be only a few minutes, and I'm trying to conclude this witness, and I think that we might be able to do that by about 12:30. So bear with us. We'll ask you to step out.
Jerry.
All right, the jury has exited, and as I understand it, we broke off the direct examination, the initial direct examination, as the state attempted to tender an additional demonstrative, anticipating an objection. We paused it there. So what is the nature of the objection? Well, first of all, let me ask this. What would be the state's exhibit number?
That would be, I think it was 499.
Did we already admit 499?
498.
So we already admitted it, but now,
Oh, you're right. I forgot about it. So that'd be 500. I did 499 and 499. You're right, Judge.
okay. So what's the new demonstrative you were wanting to get in?
500.
500, all right. And so what would be the objection to 500?
And I don't believe it's demonstrative, and I have barely seen it. It was just handed to me now and told that it was something that was given to me at the motions hearing in November 23. It wasn't.
So what is Exhibit 500 for the state?
Okay. So that will show me that one again.
Which one?
Which one was used?
It was the one that you showed us. This one. No. It's not part of those.
Oh, so that wasn't you. Judge, my understanding, and I'm getting this information, trying to remember from when the case was initially heard. Investigator Williams, his belief is that the maps were turned over during the motions hearing. They were submitted by Sandy Spring. I think we have a gap in terms of him turning them over, I don't have the in-office.
Well, let me just start here. Exhibit 500. It's a demonstrative.
It's a demonstrative and it is a description of where the phone was being tracked in and around the MARTA station. So it's consistent with the videos that are in evidence. It's consistent with the test, with the summary of the reports that have been turned over to the defense.
And it uses the same Google data
Yes.
that has already been admitted and was turned over. And I didn't conduct the motions hearing and I wasn't there and I haven't had a chance to review that transcript. So I couldn't tell you what was admitted then and to clean that up. But it seems, Ms. Lubinsky, I gather from the shake of your head, you don't believe this is a demonstrative. Can you walk me through what you mean by that?
I don't believe it's the demonstrative. It appears to track a path that the witness believes the defendant took, or the person who was using that cell phone took during that time period. So I don't believe that constitutes a demonstrative, not in my version of a demonstrative.
Okay. What is your requested remedy here?
They should not be allowed to admit it.
All right. So you're requesting exclusion. And
They have had, I think, 5 years to give me documents. They shouldn't be giving them to me in the middle of a...
I don't disagree with you there that this is not the ideal time for disclosure of documents. I'm not.
This is the map that I was given during the trial.
But without weighing in and knowing exactly whether it came up at the motions hearing or when it was covered over.
It came up during the motions hearing because I have the map that came up during the motions hearing. That did not come up during the motions hearing. It was not even remotely discussed during the motions hearing.
I understand, Ms. Levinsky. So in guidance of this situation, I'm looking at Ledger versus the state, which is 291 Georgia 584, and it talks about demonstratives and cell phone data. I know this is not cell phone data, it's Google data, but I think the principle is the same. And if demonstratives should be turned over in advance, let's say assuming it was not, the data that underlies it was, and the witness is here and available. So if you want to voir dire this witness or you want more time to interview this witness, we can take the break now if that's what you need. So I think we can remedy any potential harm that would come from this, assuming there was an untimely disclosure. So that's the path I'm following.
That a document that actually has a step, can we see the document, please? Please. I don't have it.
Do we have this exhibit available?
I am, Your Honor. I got kicked out of the Zoom meeting. I'm having to come back into it, and I should.
Can we just forward it to her on an email?
I could play it, or I could put it up right now.
Okay.
The printed.
Uh-huh.
I'll have it printed out by the.
While he's doing that, let me note, because I'd forgotten to mention this at the outset of trial, to remind counsel, we're going to need digital copies of all exhibits for the record. And if we could have those, maybe as you go, just be adding those to a thumb drive to provide to our court reporter. All right, so this is exhibit 500 displayed on the screen right now.
I think technically the last exhibit we entered was 513, so it probably should be 514. I think, right?
Yes, that would make, I mean, going off your sheet, you made the door 512 on your chart. It's also 500, so you can go back and renumber if you want. You tell me, but right now you have it as 500. Do you want it to be something else?
I think it's 514 would be
Okay.
easier, just keeping.
All right, so 514 would be this demonstrative. Is it just one page, just this one screen?
There are four, Your Honor,
Four of
four
these.
slides.
Okay, let's email these all over to Ms. Levinsky. And again, your position that these are based on the same Google data that we've talked about here. Okay. All right, so really, Ms. Levinsky, you tell me. I don't think that exclusion is going to be an appropriate remedy based on the fact that I do believe this is demonstrative. It's based on the data that is actually the core of the evidence. And so if you want more time to talk with this witness and ask her about the charts or that, I'll certainly accommodate that.
I'd like to. I know the starting point.
It should be coming to you any moment now.
Your Honor, I'm going to need a few minutes.
All right, Ms. Levinsky, I'm not putting any pressure on you. I'm just trying to plan accordingly. If you think you'll take longer than 5 to 10 minutes, I'm going to go ahead and just excuse the jury for lunch. It's completely balls in your court.
Probably a few minutes, Your Honor. I at least think the obligation to look at this.
And just going to be precise, when you say a few, is that more than 5 to 10 we should go? You recommend excusing them for lunch? A few could be 2 to 3. I just don't know. It's up to you.
Can probably do it in in 5 to 10. I'd like to print them out and look at them.
Okay. Well, if we have to printing, who knows what that'll do. Let's go ahead and bring in the jury. We'll just go ahead and let them go to lunch, and we'll come back and deal with this when they're returned. All right, so maybe you can go ahead and step down. But I'll remind you over the lunch break, you're still under the obligations you're up and don't discuss the case with any other witnesses. All right, that's fine.
That's me too.
Thank you, Deputy Scott. Members of the jury, don't get too comfortable. We still have some things that we're going to work through ourselves in the lunch hour, so we thought we'd go ahead and excuse you for lunch. So if you could be back at 1:20. 1:20, ready to go. We'll resume. Please don't discuss the case with anyone, including amongst yourselves, or do any research. Thank you so much. All right, we'll be in recess until 1:20. Ms. Levinsky, if you need a printer, you can let us know. We can accommodate you.
I've sent it to our office.
All right. Then if there's nothing else, we'll be back at 1:20.
Would like to take one thing up.
All right, then let's do that.
Okay.
On a tanky.
Your Honor, Your Honor, we contacted and spoke with Dr. Henninger last week. He was up here for a trial, and he was advised and consulted about the trial this week. In going to pick him up, we learned that he was on his way out of town on the flight. So we're working through that now. We've already contacted Dr. Sullivan, and she did review the report, signed off on it back in 2018. And so I don't know right now if Dr. Henninger would be here, but if he doesn't come here, I would anticipate probably end of the day or tomorrow morning. I expect we'd be finishing by then. I would ask that Dr. Sullivan be allowed to be a substitute. She is still employed as a chief medical examiner with the Fulton County Medical Examiner's Office. She was a part of the team back in 2018 when this autopsy was performed. And she was a part of the team that reviewed and signed off on the autopsy when the cause of death was determined.
All right, so just to be precise here, when is Dr. Henninger's flight?
We were on our way this morning to go pick him up and, well, from the DeKalb County Medical Examiner's Office. And we were advised then that he was at that point on the way to the airport. So we've been calling him, trying to see if we could catch him. And of course, the other option, which we're trying to do, is if we catch him, we're going to fly him back here for the trial.
Do we have any idea where he's going?
We didn't know he was leaving and hadn't talked to him. We were trying to call both him and his spouse. So I wanted to make the court aware of that we've already resolved the issue if the court's agreeable with that.
All right, well, I'll note before I turn it over to the defense. I know Dr. Henninger is retired here in Fulton, and he's other testified in dozens of other cases here in this docket, and that I understand that logistically he can be challenging to reach sometimes. I don't think he always answers his cell phone. Let me first just ask the position of Ms. Levinsky, if they were to sub in Dr. Sullivan if need be, or potentially have Dr. Henninger testify remotely, perhaps.
I'm going to object, Your Honor.
All right. to both
I'm going
scenarios.
to object to both scenarios, Your Honor.
And do you want to lay out the
Your Honor.
remedy
I
if
believe-
you're
I
asking for
believe
exclusion or?
is very, very clear. I didn't bring the cases with me because I didn't know this was a situation that was going to crop up. I can find it in a few minutes, but I am going to object.
And I understand the virtual aspect. I don't think I need to really hear any argument. If that's not the preference, then certainly that's not going to happen. The issue here would be using Dr. Sullivan instead. If
That's a substitute.
right.
And that again, I believe the law is clear. She did not do the autopsy, Your Honor, and under those circumstances, she cannot testify.
If the anticipated testimony is that she would have reviewed the report and independently come to her own conclusions that coincide with the report. I mean, this wouldn't be the first time we've had substitute medical examiner. To me, it seems more of an issue of notice and discovery.
Your Honor, it's hearsay.
Okay.
It's hearsay. You know, like yesterday when the state was saying it's hearsay, this is hearsay. And the law is very clear on it. And I think this case is called Smith versus Arizona, and I believe I can find it for you.
Well, let's do one thing at a time. It sounds like that's not going to happen until later today or tomorrow morning if it needs to. Let's let you focus on those demonstratives, and we will take it up. I'm glad the state raised the logistical issues now. Any others that you're anticipating right now?
No, Judge, I think
Okay.
we're nearing the end of the trial, and I think that's where we're at.
Where would Dr. Sullivan be coming in? Today or tomorrow?
Depending on where we are with evidence, but we're prepared to put Detective Williams up, depending on the timing. So there will be the last one or two witnesses.
Okay. So I'll await further argument on that. I'll give counsel time to respond since we're dealing with two other issues. I'll just go ahead and tell you my initial inclination just on hearsay grounds alone is that I do believe that would be, as long as the foundation is laid that she's reviewed the report and is coming to her own independent conclusions, that it would be allowed, but I'm willing to consider your arguments in the case that you present. I just want to tell you where I had an understanding of how that would apply in the situation, as I've seen it before many times. So, but every time could be different. We'll see. All right, with that, anything else from the state?
No issues, Judge.
Anything else from the defense at this time?
No, thank you.
All right, back at 120.
I know.
I'm glad we brought that up.
Not having it, findings that she did, not having it, that she did, not having
Yeah, I'm done with that. Oh, it's around here somewhere. Oh, here it is.
process
Pop up.
off the top of your head.
Let's, do we,
By his own standing orders and by.
my office and go through everything
That's the stronger. He's right.
along with what I think?
I
You'll be okay.
On it, but I'm not
think
sure what you
that's
have,
Smith-
but
Smith is a-
I've seen other stuff.
Smith versus Arizona is exact.
I mean, present that as well, because, you know,
Okay.
we need to observe that, but I think the notice and the, um,
13, so it's 5-4.
Five 14.
Nothing other than what I've already said.
All right.
It was not disclosed prior to today. We have received it in the middle of the testimony of the witness.
All right. Noted and preserved for the record. And so at this point, I will allow the state to proceed with presenting it over objection. I'll then allow the defense to proceed with a recross on that and any of the other new points the state brought up in their redirect. Sure.
Yeah. Other than the map, that's all we intend on going into with this witness.
Okay. And well, you did have some things before we broke that defense counsel might want to follow up on. Deputy Scott?
Yeah.
Well, maybe not. You think we're good? Are they ready? Just about. Okay, then we'll use that just about. Defense counsel, I believe, said they wanted to present some case law on substitute medical examiner and the anticipated objection of hearsay. Is that something you're prepared to do now, Mr. Linsky? You want to put that off?
Correct, Your Honor. Your Honor, firstly, I would ask, was this witness under subpoena? Is there a filed subpoena for Dr. Henninger?
Yeah, and I don't believe there is.
Okay.
Dr. Henninger was up here last week. He's been up here the past 3 weeks on different trials, and he was told last week, and we've operated like that over the past. So there should have been one, but we didn't do it in this case.
Well, I mean, I think that it would be relevant to an analysis if the state was asking for a continuance. They're not.
It's relevant also to the analysis here,
All right.
where the state is asking to substitute a medical examiner due to what is apparently gross negligence on their own part. Your Honor, the case law that I am referring to is Smith versus Arizona. It is 2024 Westlaw 3074423. It was a decision of the Supreme Court of the United States on January the 10th of 2024. And basically, the upshot of that decision is that when you tender a witness, even an expert like that, for the truth of what he is saying, and it is hearsay. And also, Your Honor, we have received absolutely no notice of this intended substitution. This court's own standing case management order requires notice. Concerning the identity of all expert witnesses, CVs, any reports they have prepared. Any party seeking to rely on expert testimony at trial or any evidentiary hearing must provide written notice to the opposing party. This notice must include a meaningful summary of the expert's testimony as well as his or her qualifications to serve as an expert witness. The notice must be provided at least 14 days before the final plea or trial calendar call and 7 days before any evidentiary hearing requiring expert testimony.
All right, so incorporating now the discovery related objections, so that's noted. Let me ask this from the state. Is there anything that you, Dr. Sullivan, testifying to that is outside, separate, or apart from anything contained in the autopsy report that was originally noticed to come from Dr. Henniger?
No, Your Honor. Dr. Sullivan is reviewing photographs and the measurements that were taken in dictation during the autopsy itself related to the size, measurements of organs, as well as any defects that Dr. Sullivan can review as described during the autopsy itself. And so based on those things that I've just mentioned, that is what Dr. Sullivan will be basing her opinion on. And the court has consistently determined that, or held that, medical examiners are not, are in fact basing their opinions on their own opinions if they're basing their information off of those things I just mentioned.
And as such, Your Honor, they are testifying regarding the truth of what is contained in their testimony.
All right, I will take a look at the Smith v. Arizona case. Looks like it's very recent, 2024. So I don't know if Georgia courts have yet incorporated it. If there's anything new in there, I'll see. But in terms of prior Georgia case law, and I'll provide the.
Bound to follow the Supreme Court.
I'm sorry?
I believe we're sort of bound to follow the Supreme Court.
I think that's a correct statement of the law, assuming they said anything new or different to add to the analysis. We'll see where it falls in, because otherwise, Georgia Supreme Court has addressed substitute medical examiner testimony before. So I'll take a look at that. We'll come back to it at an appropriate time. And I'm checking in. Is our jury ready? Then, all right.
I do also want to incorporate this as part of our argument that the court standing or notwithstanding that we are also entitled to a summary of findings 10 days before trial statutorily as well. So that would be another discovery violation because they haven't provided those, because she's making independent analyses about the autopsy now in preparation for this last minute switch up. So we need a summary of her findings 10 days before trial, which is not happening.
Sure. I don't think the state's contesting that this is falling short of the discovery statute, because this is an unexpected event, I think, on their part. And so what I am hearing is that they would just hand you Dr. Henniger's report and say, these are them, and there's nothing new to add. But she would be coming to the same conclusions as I understand it. So
If I could add to that, Judge,
Yeah.
the point I would make is Dr. Sullivan's name has been on the report since 2020 when the case was indicted and they received initial discovery. Dr. Sullivan, and I know the court has the court typically considers witnesses' names that are in evidence as on the witness list, although we did try to be as accurate as we can with
Yeah.
what we anticipated. But I would say this is solely comes down to a notice issue.
Right.
And we're asking the court to exercise its discretion to allow us to do this.
All right. I'm just making sure everyone's preserved their issues, and I'll read this case. But as I've indicated before, when it comes down to notice, I think everyone's well aware of the standard that has to be applied to justify exclusion. I'm not finding bad faith in this scenario and under these facts. I think the Supreme Court has explicitly said negligence does not rise to the level of bad faith. I think I can find that fairly recent case. And so the lack of a subpoena to Dr. Henninger, or the lack of them explicitly asking him, are you going out of town? I think that we're going to chalk that up, and I think I would, to negligence. So what do we do about it? The defense is absolutely entitled to have enough time they need to prepare for this witness, and that's what we can talk about as well. Just how much time that is and what's needed, and if there are any other appropriate remedies that they're requesting.
In that vein, Judge, then I will request that a summary of finding writing as soon as possible, per the statute, even if this past the 10-day deadline. I would like for the state to comply with that statutory requirement so that we can know how much time we might need based on that summary.
And Your Honor, Dr. Sullivan has reviewed the findings for Dr. Henninger and has signed off on it, and now she is the chief medical examiner.
Yeah.
So in her signing off on it is her approving the findings of Dr. Henninger
So her name is on the report.
on the report.
Okay.
Signature is not a finding, one. Two, she is re-reviewing these things now that she's stand as an expert for the state, which she was not expecting when she was reviewing those findings 5, 6, 7 years ago. So this is a whole different situation, Judge.
All right. I believe the jury's available. Then we'll bring them in. Thank you, Deputy Scott. Please be seated, everyone. State may resume their direct examination.
Investigator Bryant, I'm going to hand you what's been marked as. Take a look at this exhibit. Tell the court if you recognize it.
Yes, this is phase 2 from Google. Google data records in phase 2.
And is that an exhibit that you yourself prepared?
Yes, it is.
Okay. And what did you use to prepare that exhibit?
I used ArcGIS.
All right. And what in particular were you looking for, trying to analyze when you were in the process of preparing that exhibit or preparing the maps on that exhibit?
Well, I believe in phase 2, after the selection of the device, you get a broader time frame. So in the initial phase, there was the time frame of 1 to 5 a.m. When we made Detective Williams made the selection for the device, you get that device in a much broader time frame. I don't remember the exact time frame. I want to say it was 4 to 5 hours, but I really don't remember the exact time frame.
Okay. And talk about the process. The process that you described for, I guess, analyzing Google data, is that the same process that you conducted with Exhibit 514?
It is.
Okay. Your Honor, this time I would move to tender into evidence states Exhibit 514.
Any further objections other than those previously noted by counsel?
None.
Submitted over objection.
Your Honor, I don't think I have hosting privileges.
All right, if we could add Mr. Fawcett and everyone else as co-hosts. It appears you can proceed.
Oh, I don't.
Okay. Now we're publishing States Exhibit 514. Investigator Bryant, can you tell us what we're looking at with this exhibit? And this is slide 2 on the States Exhibit.
Yes. So this is the device Detective Williams selected. The beginning time frame here is 11:20 p.m. on the 26th of June, 2018. Didn't timestamp all of them because it would clutter, but you can see the general path of each location and the time frame.
Are you able to tell where there's a beginning of that travel?
Yes,
And what time is that?
11:20, Marta Chambly Station.
All right. And walk us through as you get to the ending of the map with the 11:59 indication. The travel and the distance and the locations is being traveled. Could you tell us that?
Sure. I mean, again, these are not precise locations. You can see the general path along Peachtree Road.
Yep.
Beginning 11:20, 11:27 across the street. These arrows just signify the direction of travel. 11:44 p.m. device is here. And then 11:59.
All right. Okay. Now we're publishing slide 3 on 514. Can you tell us what we're looking at?
Yes. Device here at midnight. This is Lanier Drive, near Lanier Drive and Peachtree Road. This is Brookhaven. Again, the general direction, the general path is this way, and the timestamps. 12:20 a.m. on the 27th, 12:26, 12:38. So this is going into this line to Sandy Springs. Going into Sandy Springs. Again, their dot there is the coordinates that were placed on top of her house. So this is her house. And then the device locations right around her house.
For the record now, publishing slide 4 in that exhibit.
Yes. Again, this is just a blown up version of that previous map as the device approached closer to her house. You can see it along Windsor Parkway. This is Sandy Springs. North on Peachtree Dunwoody Road. The device turns into the Croft. This is a small cul-de-sac right off Peachtree Dunwoody Road in Sandy Springs. 12:46 a.m. It's in the cul-de-sac or near the cul-de-sac. The device leaves the Croft, goes northbound again on Peachtree Dunwoody Road. 12:49 a.m. on the 27th. The device turns down Balmoral Road. 12:52 a.m. Balmoral. The device turns right, goes down Longchamps Drive. 12:56 a.m. Right around that time it's on Old Woodbine. And then I just circled this is the previous phase that was captured in that initial, or the previous cluster that was captured in that phase 1 that we asked for right here. 1 a.m. to 3:14 a.m. The device is here. again, this is Old Woodbine, 1095 Old Woodbine.
All right, we are publishing slide 1 on that exhibit now. Can you tell us what we're looking at?
Okay, the device is picked back up again. There was no locations from 3:14 a.m. until 5:37 a.m. So it's picked back up again in Chamblee, 5:37 a.m. Here's that MARTA Chamblee station. I'm sorry, the first location is 5:35 a.m. This is an apartment complex where the vehicle was located. Then the next is 5:37 a.m. right across from the MARTA station.
Okay. And Investigator Bryant, are you aware of, through the investigation, is there any significance to that particular location, the Azalea Place Apartments, where the phone picked back up? Are you familiar with that?
Yes, I am.
And what is that?
That is where the vehicle was located.
And the vehicle in question, what vehicle are you referring to?
I believe it was a Kia Sorento.
Is that the vehicle that your office, or then law enforcement was investigating that was taken from the residence of Ms.
Yes.
Thomason?
Yes, that's correct.
Okay. All right. Now, at any point, were you able to determine if Ms. Thomason's phone left the residence as well?
Yes.
And what information can you provide to the court about any movement of Ms. Thomason's phone during that night?
So the phone moved, the phone moved along Windsor Parkway also. After it left the residence to Balmoral, down Peachtree, Dunwoody Road, Windsor Parkway. Yes, it moved along that direction, and then it stopped in a general location in Chamblee.
Okay. And was the movement of that phone based off your experience and the reviewing the records for James Jones? Did they move consistent with the phone of Ms. Thomason once it left the residence?
Yes, they were.
Okay. And what do you mean by that?
So in my opinion, the device in question was powered off. So it didn't come back. There were no locations on it until 5:35 a.m.
Okay.
But it was along that same path.
Okay. All right. And was that information provided to lead detective J.T. Williams during the course of your investigation?
Yes, it was.
All right. That's all I have this witness, Judge.
Recross.
Thank you, Your Honor. So let's see, you said that the phone picks back up on at 5:35 a.m.
Yes, ma'am.
You're quite sure of that?
Yes, ma'am.
So I'm going to show you a document that has been marked as Defendants 31.
Okay.
Do you recognize that document?
Yes.
What is that document?
These are the Google records for the device Detective Williams requested for phase 2.
Okay. Now, I want you to show me where on that document there are any records for 5:35 a.m. for that device.
Well, this is phase one. This is not phase two.
No, no, with, so that's exhibit 31.
Oh, okay, yes, 537.
No 535.
That's correct, yes.
No 535. No results whatsoever showing 535. The first result that shows on that device is at 5:37 a.m. and that's in the vicinity of the Shamley Martyr Station, correct?
That's correct.
Perhaps, Mr. Fawcett, is that one of the records that's, oh, perhaps let me ask that it be admitted into evidence.
All right, so defense 31, Mr. Fawcett, have you seen defense 31?
I have, Judge.
All
Yes.
right. Any objection to defense 31?
No objection.
It's admitted.
And I do not have it on digital yet, Your Honor. May I publish the good old fashioned?
Sure.
Do you remember what you got from phase three? Okay, all right. Did you receive that in phase three?
So let's see if I understand correctly. What your records in phase two show is a person who walks from the Martyr Station to somewhere in the vicinity of the Woodbine Street address, correct?
Yes, that's correct.
In the process, this person passes the Crofts, Balmoral Avenue, and sorry, my apologies. Peachtree down Woody Road. Peachtree Road, correct?
Yes,
Windsor Parkway, correct?
yes, ma'am.
And the phone switches off at 3:14 a.m., possibly because the person reaches his or her destination and switches on again at 3:57 a.m. in the vicinity of the Martyr Station.
The phone, yes, the device did that.
And you've said these locations are far from precise, correct?
That's correct.
They bounce off towers and
No, ma'am.
correct.
No, they don't bounce off towers.
They don't.
No, they do not.
They don't.
In the
bounce.
Google records, they tell you the source, how they get the locations.
And how did they get those locations?
I believe most in phase one, I need to see the data. I mean, most of those were Wi-Fi. They were sourced from Wi-Fi.
And how do people get Wi-Fi on their phones?
And they turn the Wi-Fi on. So if you power Wi-Fi on, as you pass networks, the Wi-Fi network and the device see each other.
And how does Google obtain the location of that Wi-Fi network?
You'll have to ask Google that.
And how does Google obtain the GPS location?
You'll have to ask Google.
You don't know.
No.
May I have one moment? I have nothing further.
All right, can this witness be excused?
Just briefly, Judge.
All right.
Now, are you familiar with the different types of information that comes in on the 3 different phases from Google?
Yes.
And what information comes in on the first phase typically?
Anonymous device IDs, location, how the source, how Google obtains that, and then the display radius in meters.
What about the second phase?
The second phase is the same thing. It's an anonymous ID. It's the same exact set of records, but just for that particular device.
Okay. So the second phase, you're honing in on a particular device at that point?
That's correct.
And what comes in with the third phase of Google that they send you?
Well, pretty much the search histories, all the Google search histories, any mapping that they did, any location searches through maps, more locations actually come in on that third phase.
Okay.
I don't recall in the third phase, I mean, it was, I believe it was several months
Okay.
of stuff.
And did you previously testify as to 6 months? Was that the total time it took for all 3 phases of the records to come back?
I don't recall the total time
Okay.
that it took for the,
And the process for obtaining the first phase, did that require law enforcement, Sandy Springs, to obtain a search warrant?
yes,
What about the second phase?
yes,
What about the third phase?
yes,
So your testimony is that each time you wanted to receive additional records from Google, you submitted an additional search warrant?
yes,
Okay. And we're talking about the defendant's exhibit 31?
Yes.
31. Your testimony is that would have been information that would have been received in phase 2?
possibly phase 3.
Okay, you're not sure?
I'm not sure.
All right. Did law enforcement receive additional information in phase 3 that was beneficial?
Yes,
Are you aware of how it was beneficial? Did it
Yeah.
obtain search history for this defendant?
yes.
Okay. Was that information?
Yes, it had email addresses,
Okay.
phone numbers.
All right.
uh,
And was that information turned over to the lead detective, J.T. Williams, in this case?
Yes,
Okay. Have you heard the term global positioning systems?
yes,
Often acronym GPS?
yes,
Do you know whether or not that utilizes satellites to for the benefit of location?
yes, it does.
Okay. And is that something that you learned throughout your studies with your GIS degree,
Yes,
as well as your training in law enforcement?
yes, sir.
All right. That's all I have, Judge.
Any recross on those points?
No, thank you.
All right, Mr. Fawcett, can the witness be excused?
No objection.
You can sit down, ma'am. Statement calls next witness.
They calls Abby Snively. Snively, I believe.
You swear affirm to the testimony.
She does a lot of stuff. Just gonna ask whether you can talk about it.
Last name for-
Abby Bell, ABBYBELL.
Okay. Oh, I'm sorry. I mean, so Bell?
Bell.
Okay, all right. Good afternoon. Can you tell the court where you're currently employed?
I'm employed at Chamblee Police Department.
Okay. What do you do with the Chamblee Police Department?
I am a crime and intelligence analyst.
And what does a criminal intelligence analyst do?
I analyze crime trends, patterns, and I work with our investigations division to assist with solving cases.
Okay. How long have you worked with that department?
A little over 2 years.
Okay. And prior to that, what did you do?
I was also a crime and intelligence analyst at Brookhaven Police Department.
How many years did you work with Brookhaven?
Just over 5.
Okay. And would you have been employed in that capacity at Brookhaven Police Department in 2018?
Yes, I was.
At any point, and can you talk about whether or not Brookhaven Police Department has a way to read license plates within that department?
They do. We've got license plate readers, which are essentially cameras that are mounted throughout the city, or when I was there. And there's a database that you can go and search to see where license plates hit and the date and time that they hit.
Okay. And how long have you had an opportunity, or I guess while you were at Brookhaven or since you started working on that type of program, how long had you worked with that program?
I worked on it my entire duration at Brookhaven and my previous agency too. So 6, 8 years,
Okay.
a while.
How does it work? Can you describe, is it a camera system? What type of devices, how does it operate?
It's cameras that are mounted to either like Georgia Power poles or poles throughout the city, and the location is obviously affixed to it. You can, whenever a tag passes the license plate readers, it captures a picture of the tag and obviously takes note of the date and time that it was captured. And then I have access, or we at the department have access to log into a database system to be able to pull those pictures of the license plates and see where the license plate hit and when.
Okay. And is that system that enables you to pull the photographs, is that something that you have access to or had access to at Brookhaven at that time?
I did.
How do you go? I'm sorry, go ahead.
I had it my entire duration while I was there.
How do you go about retrieving that information?
Just log into the system. And there's a few ways that you can query the data. The easiest way is just to put either the full tag in the system or a partial of the tag. There are other ways you can query it, but when you run the tag in the system, then it returns in the database that you log into all the pictures of the actual tag, the license that it hit on, the location of it, and the date and time that the license plate hit.
Okay. And you were not employed with Sandy Springs Police Department in 2018.
No, sir.
How did you come to assist Sandy Springs Police Department?
Sandy Springs, at the time, the specific license plate reader that we had access to, it was limited to mostly the jurisdiction that you worked in. So because Brookhaven was near Sandy Springs reached out, that we would reach out to each other surrounding agencies and ask if the license plate, hit in the city, or see if you could see the location of the license plate. So Sandy Springs reached out to see if to run the license
All
plate.
right. And what, so your testimony is that you got a specific license plate number?
Yes,
Okay. And when you got that license plate number from Sandy Springs, you conducted a search for it?
correct. I went into the database and ran the tag.
All right. Did you provide that information to Sandy Springs Police Department?
I did.
All right. I'm going to state Exhibit 515. Can you take a look at this exhibit and tell the court if you recognize it?
I do recognize it.
How do you recognize that exhibit?
It is a picture of the way the database is to show the return for the license plate hits.
Okay. And the process for searching for that particular plate, that's what you employed as it relates to Exhibit 515?
I'm sorry, say that again?
The process you've been testifying to for searching for a specific plate, that's what you employed as it relates to 515?
Correct.
Okay. And that exhibit contains the information that you provided to Sandy Springs?
Correct.
Your Honor, this time the state will move to tender in evidence. States Exhibit 515.
515 submitted.
Okay. And lastly, how does it, like what type of depiction of the license plate is captured? Is it a photograph or is it something else? It's
a photograph of the rear of the vehicle and the license plates affixed to the rear of the vehicle, either a daytime or a nighttime photo with the date and time that it was. So you can see a picture of the plate when it was captured, and the corresponding date and time of when it was captured.
Okay. And can you do you see that? Can you tell the court the time if it's indicated on there as to when it was captured?
Yes, for all of the reads I can.
Yes, you can do that.
For all of the reads?
Yes.
The most recent one was on June 27th, 2018 at 5:09 a.m. And that was a Brookhaven camera. The next one was on June 19th, 2018 at 3:28 p.m. The next was June 11th, 2018 at 10:52 a.m. The next was June 10th, 2018 at 1:37 p.m. And the final one was June 8th, 2018 at 10:59 a.m.
Turn your attention back to the 18th and 19th dates that you testified to. What were those dates again?
I'm sorry, you
The
said
times again. What was those times?
for which day?
The 18th and the 19th.
The 19th was 3:28 p.m. And then the 11th,
The 18th. I think you said the 18th, did you?
there was the 27th, the 19th, the 11th, the 10th, and the 8th.
Okay, all right. Okay. That's all I have with this witness, Judge.
Any cross-examination?
None. Thank you.
Can this witness be excused, Mr. Fawcett?
No objection.
Thank you, ma'am. They may call us next witness.
Tatiana Johnson, Your Honor.
You swear affirm to the testimony is the truth, you know, the truth so help you.
You.
You may be seated. Or speaking to the mic, so reverend, you may spell your name for the court.
My name is Tatiana Johnson, Tatiana Johnson, Johnsson.
Where are you employed, ma'am?
I'm currently employed at the United States Criminal Investigation Laboratory.
What is that?
That is the Army's, basically it's the Army or military's crime lab.
Okay. And were you ever employed at the GBI Department of Forensic Science?
Yes, sir, I was.
And when, I'm sorry, when were you employed there?
Sorry, from about 2011 for approximately 10 years.
Okay. And did you have a specialty at that department?
Excuse me. I was a microanalyst with the trace evidence section. I examined hairs, fibers, and other small microscopic evidence.
What about well, actually, could you please go through your training or your education and training?
Yes, sir. I have a bachelor's of science in biology with a chemistry minor, as well as arts in criminal justice with a forensic science certificate from Hamline University up in Minnesota. I also completed numerous multi-year training programs through the GBI specific to the types of evidence that I examined.
And did you, let's talk about your time at the Georgia Bureau of Investigations. Did you have to prove proficiency, so to speak?
Yes, sir. We took annual proficiency tests in each subdiscipline that we were qualified in.
And so what exactly did you do when you were what was your role? Or actually, before I start that, have you ever testified in court before?
Yes, sir.
Have you ever testified in Georgia before?
Yes, sir.
Have you ever been certified as an expert in Georgia before?
More than 10 times, yes.
And what have you been certified as an expert in?
Hair analysis, fiber, and gunshot primer residue analysis.
Your Honor, at this time, I'd ask that Ms. Johnson be tendered as an expert in hair analysis and fiber analysis.
No objections.
They may proceed.
Thank you. Can you tell why do people hair? What is the point of analysis of hair?
Sure. Hair analysis can help to show a connection between different different areas. So between a connection between a subject and a victim and a scene, or a subject and the scene. So hair analysis is not a form of identification. You cannot say that it came solely from this person when their comparisons are performed. So it's not a form of absolute identification, excuse me. But it can help to provide some circumstantial potential connections there. You can also examine hairs for DNA analysis. There's a potential, if the roots are in the right growth stage, that they could be sent for DNA analysis, as well as if there's hairs, you could look at various characteristics throughout the hair, length, color, dye, things like that, that could be informative to an investigation. And then finally, even if there is no root, there's a potential, if there is a hair, for the shaft to be sent for mitochondrial DNA testing, which is a different type of testing that can be done on the shaft.
How do you, when you get a sample to analyze, how do you proceed?
So generally what we'll receive is a trace evidence collection. So in our section, there are some technicians that will do the actual collection from the initial evidence, and that's just to, the trace evidence will be lost if the evidence is not, if that trace is not collected. So that trace gets collected ahead of time, and then that evidence can go on for other testing in other sections. If the hair, or if the evidence needs to be examined for hairs or fibers or other micro analyst responsibilities, then we would generally look at those collections, which would typically be like a tape lift, or if it's a rigid item, they might do picking with tweezers. They examine it under a microscope and pick off any trace evidence onto tape at that point as well. Once I receive it, it's generally those tape lifts that I'm examining, and at that point, I'm using a stereo microscope, which is just a low-powered microscope, to do an examination for any hairs or fibers that might be present on that tape.
What is unique about hair that allows you to be able to identify?
Well, hair has, it's a special, obviously it's a biological item, so there's lots of variety within it. However, hair has 3 distinct parts to it. It's kind of like a pencil. Outside has some scales on it that kind of overlap like shingles on a roof, you could say. There's also, microscopically, there's inside a cortex, which would be like the wood part of a pencil. And then in the middle, sometimes, not all the time, there's what's called a medulla, which is just an open air pocket, basically, that runs down the hair.
And I'm going to draw your attention. Did you do analysis on a case for Sandy Springs Police Department in 2018?
Yes, sir.
And what could you or how did you receive that evidence?
Yes, sir. So the evidence was received through our lockbox system at the GBI. It came to the trace evidence section, as I explained previously. The technicians picked up the actual evidence. They brought it up to trace. They did the initial examination of and collection of trace evidence. The evidence was then sent to other sections. After those sections had completed their analysis, I then examined the tape grid that had been collected from that evidence previously.
And what exactly did you analyze in regard to this case?
I was just examining a tape. I don't know if the item, it doesn't have the same case number or item number, I'm guessing is what I examined, but it was a nail file, I believe, or a nail cuticle tool. And I examined the tape grids from it. So I didn't actually see the cuticle tool. I just saw a tape grid that somebody had collected from it.
And you see the tape grid well, you know it is by the way it's marked. Yes?
Yes, yes.
And could you go into your conclusions on what you analyzed and what your results were?
Yes, so my examination of the tape grid revealed no hairs present.
I just have a moment, Your Honor. Nothing further.
Any cross?
No, thank you, Your Honor.
Can this witness be excused?
Yes, Your Honor.
Thank you, ma'am.
Thank you.
Then we call us next witness.
Your Honor, the state calls Christina Cervidio.
You swear upon the testimony is the truth, and nothing but the truth to help you.
I do.
Maybe see. Please state your name for the court.
Christina Cervidio, Cristina Servidio.
Okay, Ms. Cervidio, good afternoon.
Good afternoon.
Can you tell the court where you're currently employed?
I'm currently employed at DNA Labs International. It's a private DNA laboratory that does forensic DNA work in Deerfield Beach, Florida.
How long have you been employed with DNA Labs?
10 years.
All right. Before you were employed with DNA Labs International, where were you employed prior to that?
I was employed at the Armed Forces DNA Identification Laboratory, where I processed fallen soldiers, remains from fallen soldiers from World War I, World War II, the Korean and Vietnam Wars.
Can you describe your educational background for the jury?
I have a bachelor and master's degree from the Catholic University of America in Washington, D.C. in biomedical engineering. And I have a master's degree from the George Washington University in forensic molecular biology.
Okay. Can you tell the jury that any laboratory prior to working at DNA International?
Yes, so at AFDIL for 6 years, I was also working in the laboratory as well, doing the same type of testing as I do at DNA Labs International, but it was mostly for identification of fallen soldiers.
Yeah. Can you describe for the jury your current position and the nature of your work?
I am a senior DNA analyst as well as the chief operating officer and technical leader of our laboratory. I analyze DNA evidence for the presence of body fluids. I analyze DNA profiles, do comparisons, issue statistics and reports, and testify in court to my findings.
Okay. How many times have you done that?
30 to 40 times.
Okay. And during those times, have you been qualified as an expert?
Yes, I have.
All right. Do you have any specialized training?
I do. As part of our training, when we enter a forensic DNA laboratory, we have to complete a rigorous training program that involves readings, competency exams, oral exams, written exams, all to ensure that we know what we are doing prior to working on actual casework.
Okay. And can you tell the jury what a competency test is?
Yes, a competency test is taken at the conclusion of training. The answers are known to somebody else in the laboratory, and you have to obtain the correct answers in order to pass.
All right. Can you tell the jury what a proficiency test is?
A proficiency test to a competency test, but it's given to us by an outside agency. So no one at our lab knows the results. And we have to complete one every 6 months at our laboratory to show we are current and we are still able to do our jobs appropriately.
All right. And have you yourself taken any competency or proficiency tests?
Yes, to both.
Can you tell the jury what the results of those were?
All satisfactory.
Can you tell the jury how many samples you've had an opportunity to perform DNA analysis and methods on during the course of your career?
Thousands of samples.
And when you are qualified as an expert, what are you typically qualified as an expert in?
Forensic DNA analysis and serology. Serology is the identification of body fluids, and then DNA analysis involves processing evidence for the DNA profiles and then analyzing and interpreting the data as well.
Okay, Your Honor, at this time, the state would move to enter Ms. Christina Cervidio as an expert in forensic DNA analysis and serology.
No objection.
State may proceed.
And Ms. Cervidio, can you tell the jury what DNA is?
DNA is the genetic blueprint that's found inside of your body. It makes you unique from other human individuals.
And can you explain generally the process used for analyzing the evidence in this case?
So the first thing that happens is the evidence comes into our laboratory. It is logged in and put into our secured evidence vault. The first step after that is called screening. We are going to take the evidence physically out. We are going to look for any potential body fluids, and we are going to take a sample of that item forward for DNA testing. The next step is called extraction. So that's where we're going to expose that sample to heat and chemicals in order to break open the cells that contain the DNA and release them, and wash, basically clean the DNA sample. Next, you're going to quantify the DNA. So we're just going to look and see if there is any DNA, and if so, how much. Next, we're going to do a step called amplification. It's like a genetic photocopier. We're going to put in one copy, and we're going to get millions of copies of the DNA profile. And lastly, we separate and we detect out what that DNA profile is. The final product looks like a heart monitor with individual peaks, and that's what we are looking at and comparing to other DNA profiles in the case.
Does your DNA unit follow any standard protocols and procedures?
Yes, we do.
And can you tell the jury what those are?
So we are an accredited laboratory, which means that we have people come into our laboratory every year, and we make sure we are following the standards that are set forth by our community. So we're following all the rules that the community sets forth. Part of those rules involve having standardized operating procedures that say exactly how we do everything at our laboratory.
Okay, can you tell the jury what controls are and whether you use them during your testing?
Yes, we use control during our testing, mainly two types of controls. The first is called a positive control. That's a known DNA profile. So we know exactly what that profile is, and it's processed at the same time as the evidence. At the end, if we get the appropriate profile, that tells us everything we've done has worked correctly. On the opposite side, you have your negative controls. And those are samples that we don't put DNA in, but we put everything else that we use during the testing process into that tube. And at the end, it should not have any DNA profile in it.
Okay. Can you tell the court and the jury whether your work undergoes any type of?
It does. All of our work is reviewed by 2 analysts who are qualified in the same technologies that I am qualified in. That's called a technical review. In addition, our work also undergoes an administrative review to look for clerical errors.
Okay. And can you tell the jury whether you had an opportunity to perform DNA analysis on items submitted to your laboratory from Sandy Springs Police Department?
I did.
In particular, in connection with the investigation in this case, the 1095 Woodbine Road residents?
Yes, I did.
And can you tell the jury, what was submitted to DNA laboratory?
Your Honor, may I reference my report?
That's fine.
So in total, I believe we received about 100 different items from this case. They included, to name a few, standards from several suspects and the victim as well. We received many different swabs from different areas of the house. We received some physical items as well from the house, and we received swabs from a car.
Okay. So jury, just an overview of the total number of items that were submitted as they were categorized as individual swabs or individual items?
I believe it was about over 100
Okay.
samples altogether.
And kind of walk us through the process for dealing with the number of items that were submitted. How did you organize and work your way through the testing process?
So at our laboratory, we won't necessarily just test everything. Our team will meet with the detective, and the detective will sort through what items they want tested first. And we kind of go in order from that. So I ended up authoring 6 different reports for this case with 6 rounds of testing in those reports.
Okay. And when you say 6 rounds of testing, are you referring to 6? What do you specifically mean by 6 rounds of testing?
So I have 6 reports that are dated with different results. So I issued a report 6 different times with different results for each thing that I tested.
Okay. And your testimony is that you consulted with the lead detective prior to determining what to test and how to test it?
Yes.
All right. Can you tell the jury if you had any known samples that were submitted?
Yes, we did.
And what were those known samples?
The known samples, correct? The known?
Yes.
Yes. We received known samples from James Jones, from Kay Thomason, from Timothy Bryant, from Sean Holt, and from Brandon McDonald and Brian Fromm.
Okay. And can you tell the jury what you did with those samples when you received them?
So with our, we call them standards or known DNA samples. They often are a swab of the inside of the cheek. We call it a buccal swab, but they would follow that same process that I talked about earlier as the evidence sample. So going through the screening stages, extraction, quantification, amplification, separation, and detection, they go through that same process.
Okay. And with regard to the testing and analysis that you did on those known samples, can you tell the jury if you were able to draw any conclusions?
Yes, I was.
And what were you able to determine?
For which sample?
Start with the first name you mentioned, I believe it was Mr. Timothy Bryant. And if you could go through those names that you mentioned and tell us what conclusions, if any, you were able to draw.
So for Timothy Bryant, I was able to exclude him from the mixed DNA profile that was obtained from the chair. I was able to exclude him from the mixed DNA profile I obtained from the red pillowcase. From the bed sheet from the bathroom, I was not able to exclude him from the mixed DNA profile. I had obtained a mixed DNA profile of at least 4 individuals with at least 1 male contributor. Since I was not able to rule out Timothy Bryant, I had to do a statistic that tells you kind of the significance of that inclusion. And when we do that, we do a statistic known as a likelihood ratio. And what that likelihood ratio is it's a statistic that compares the probability of observing the evidence, which in this case, the evidence profile. So the probabilities of observing the DNA profile under 2 different scenarios. So for this particular bed sheet, the DNA profile obtained from the sample is approximately 21 million times more probable if the sample originated from 4 unknown people than if it originated from Timothy Bryant and 3 unknown persons. After we give that statistic, we have what's called a verbal scale. It kind of puts it into words what that statistic means. Anything over 1 million is extremely strong support. So in this case, the analysis provides extremely strong support for the proposition that Timothy Bryant is not a contributor to that DNA profile. We also tested swabs from the wall by the door. The DNA profile obtained from those swabs indicated 1 female contributor. Timothy Bryant was excluded as a contributor to that DNA profile. We also tested swabs from a gear shift. The DNA profile that we obtained from those swabs was a mixture of at least 2 individuals with at least 1 male contributor. Timothy Bryant was also excluded as a contributor to that mixed DNA profile. We also looked at swabs from a rear view mirror. The DNA profile from those indicated 1 female contributor, so Timothy Bryant was excluded from that as well. We also looked at swabs from driver's seat adjustment controls. The DNA profile obtained from those swabs indicated a mixture of at least 2 individuals with at least 1 male contributor. Timothy Bryant was also excluded from that mixed DNA profile. In addition, the results were the same for the swabs from the armrest of the center console. Timothy Bryant was also excluded from that DNA profile. He was also excluded as a contributor to the DNA profile from the antenna, from the swabs from electronics in the living room, for the swabs from the flat screen TV in the living room. The DNA profile indicated a mixture of at least 3 with at least 1 male contributor. He could not be ruled out in that situation. So I went ahead and performed a statistic. And in that case, the DNA profile obtained from the swabs was approximately 73 times more probable if the sample originated from 3 unknown people than from Timothy Bryant and 2 unknown people. A number like 73 is a low number that falls in our uninformative range, where it really doesn't support one proposition over the other. So that's uninformative. Timothy Bryant was also excluded from DNA profiles that we obtained from the items on the living room floor. Another item from the living room floor, the TV stand dresser, the bathroom door, swabs from a return vent in the bathroom. We also tested swabs from the handrail of the staircase. Timothy Bryant could not be ruled out as a possible contributor to that mixed DNA profile, and that mixed DNA profile indicated a mixture of at least 3 individuals with at least 1 male contributor. However, when I ran it in our mixture software, it failed to produce a conclusive result in comparison to Timothy Bryant when 3 people were considered, basically excluding him from that mixed DNA profile. He was also excluded from swabs from the computer monitor in the dining room, for swabs at the top of the nightstand in the spare bedroom. He could not be ruled out from that DNA profile, that mixed DNA profile of at least 3 individuals with at least 1 male contributor. However, similar to the last result, the DNA software failed to produce conclusive results, basically excluding him from that. For the swabs from the top of the bed in the spare bedroom, the DNA profile indicated a mixture of at least 2 with at least 1 male contributor. Timothy Bryant could not be ruled out. The DNA profile obtained from the swabs is approximately 630 times more probable if the sample originated from 2 unknown people than if it originated from Timothy Bryant and 1 unknown people. So that falls in that uninformative range again. Timothy Bryant was also excluded from the right side nightstand, the top of the master bed, miscellaneous items on the master bed, the desktop flat screen TV master bedroom, the debit card on the desktop, miscellaneous items on the master bedroom floor, miscellaneous items on top of the dresser, the kitchen sink, the white trash can, the French door, the coffee table, the light switch. For the swabs from the bedroom door in the spare room, that DNA profile indicated a mixture of at least 3 individuals with at least 1 male contributor. Timothy Bryant could not be ruled out as a contributor. However, the mixture software failed to produce conclusive results, which excludes him. A similar result was obtained from the swabs from the bedroom dresser and from the back of the spare bedroom door. He was also excluded from swabs of blood from the dresser top, the flashlight, the wallet, the torn check, and the purse. And that was from the 3rd report. Additional items were tested in the 4th report. Would you like me to continue?
Yes, if you would, please.
He was also excluded from a DNA sample from the handle of the knife and from a $20 bill and from a sample that was collected from some cards. For a pair of scissors, we tested the handle area of those scissors, and it indicated a mixture of at least 3 individuals with at least 1 male contributor. Timothy Bryant could not be ruled out as one of those contributors. However, the software failed to produce conclusive results, therefore excluding him. He is also excluded from a sample from the exterior, or 2 samples we were taking from the tape, both interior and exterior. A glass cup he was excluded from. There was a red, white, and blue pouch that we tested. He could not be ruled out as a possible contributor to the mixed DNA profile on the exterior of that pouch. And the DNA profile from that indicated a mixture of at least 2 individuals with at least 1 male. The DNA profile obtained from that sample from the exterior was approximately 240 times more probable if the sample had originated from 3 unknown persons than if it originated from Timothy Bryant and 2 unknown persons. So again, it falls into that uninformative range. He was excluded, however, from a sample that we collected from the interior of that pouch. He was excluded from another roll of tape at the scene. He was excluded as a contributor from the profile we obtained from the checking account statement. He was excluded as a contributor to the mixed DNA profile we obtained from the carpet with possible blood stains. We had taken a sample from that carpet. And lastly, 5th report. We tested a sundress that the victim was wearing. We collected a sample from the upper back, lower rib cage area, and the front exterior chest area. And the DNA profile obtained from that sundress indicated a mixture of at least 2 individuals with at least 1 male. He was excluded from that DNA profile. And I believe that is it for comparisons to Timothy Bryant.
All right. Can you tell the jury, you've been specifically testifying to mixture DNA samples? What's the difference between a mixture DNA sample and other samples that you would analyze?
So what in the analysis world, a mixed DNA sample just means you have DNA from multiple people in that sample. So by looking at the number of peaks, remember before I talked about how you have that heart monitor with peaks on it, every individual person has 1 or 2 peaks at each location. And that's because you get 1 copy of DNA from your mother and 1 from your father. So you could inherit the same peak from both parents or 2 different peaks. So when we're looking at that mixed DNA profile, we look at the number of peaks, and that's how we're able to estimate how many people are in that mixed DNA profile.
Okay. And is there anything different about analyzing, say, a lone DNA sample versus a sample that may contain more than 1 DNA profile?
No, it's the same overall process. Having more people in it can, complicate it a little bit more, but it's the same overall process as analyzing something we call a single source DNA profile, where it comes from 1 individual.
And you mentioned a DNA mixture program. Could you describe that and how you utilize it to perform analyses?
So we use a program called StarMix at our laboratory. It is a program that comes out of New Zealand, and it is used all across the United States. Over half of the labs in the country are online and live and have been using it for casework. And I believe another 30% have it in their laboratory and are in the process of validating it. It's the same software used by the FBI, the same software used by the US Army. So it's pretty standard in the field. But we use it in the case of mixture profiles because it can help us resolve some of these mixtures and generate those statistics or those numbers that I was telling you.
You did testify as to statistics and range. You mentioned a range that would be uninformative versus very strong. Talk about the range. What is the range and the significance of each spectrum of that range?
So the range that we had for our verbal scale, 0 to about 1,500, that would be your uninformative range. That range was established based on our validation. What we did was we looked at the highest potential false inclusion we could have, and I believe it was right around 1,500. So that's what we ended up setting as that. Anything from 1,500 to 1 million would be very strong support, and anything 1 million and above, that's kind of the top of the range, that would be extremely strong support.
Okay. And is that how you categorize where something would fall based on the spectrum, uninformative versus very strong evidence of, I guess, is that correct?
Support, yes. So uninformative, very strong support, and extremely strong support.
Okay. Did you perform any analyses on individuals Sean Holt and Prentice Jerome Brooks?
I did.
And what were you able to determine or conclude after those analyses?
If I go back to my report. I'm going to start with Prentice Jerome Brooks. For the chair sample, we tested the left side of the chair, avoiding possible blood stains. The DNA profile we obtained from that sample indicated a mixture of at least 3 with at least 1 male contributor. Prentice Jerome Brooks could not be ruled out as a potential contributor to this mixed DNA profile. The DNA profile obtained from the sample was approximately 180 billion times more probable if the sample originated from 3 unknown people than if it originated from Prentice Brooks in 2 unknown. As a result, that analysis provides extremely strong support for the proposition that Prentice Jerome Brooks is not a contributor to that DNA profile. He was also excluded from the mixed DNA profile from the red pillowcase. From the bed sheet sample, he could not be ruled out as a possible contributor. Similar to some of the analyses with Timothy Bryant, the software failed to produce conclusive results, which basically excluded him from the bed sheet sample. He was also excluded as a contributor to the DNA profile from the swabs from the wall by the door, from the swabs from the gear shift, from the swabs from the rear view mirror, from the swabs from the driver's seat adjustment controls, from the swabs from the armrest center console, from the antenna from the center console, from the swabs from the electronics in the living room. For the swabs from the flat screen TV in the living room, he could not be ruled out as a possible contributor. The DNA profile obtained from those swabs is approximately 32,000 times more probable if the sample originated from 3 unknown people than if it originated from Prentice Jerome Brooks and 2 unknown individuals. He was also excluded from the swabs from the items on the living room floor, both samples from the items on the living room floor. He was also excluded from the TV stand drawers, from the swabs from the bathroom door, from the swabs from the return vent, for the swabs from the handrail, of the staircase. He could not be ruled out as a contributor. However, the software failed to produce conclusive results, excluding him. For the swabs from the monitor, the computer monitor, he was excluded as a contributor to the mixed DNA profile. For the top of the nightstand, he could not be ruled out as a contributor to the mixed DNA profile. The DNA profile obtained from the swabs is approximately 1.1 sextillion times more probable if the sample originated from 3 unknown persons than if it originated from Prentice Jerome Brooks and 2 unknown. Therefore, this analysis provides extremely strong support that for the proposition that Jerome Brooks is not a contributor to that DNA profile. From the top of the bed in the spare bedroom, the DNA profile was a mixture with 2 individuals at least, with at least 1 male contributor. And that DNA profile from those swabs is approximately 9.5 times more probable if the sample originated from 2 unknown people than if it originated from Prentice Jerome Brooks and 1 unknown person. 9.5 would fall in the formative range. He was also excluded from the swabs from the nightstand, the swabs from the top of the bed, and the swabs from miscellaneous items. He was excluded from the swabs from the flat screen TV and from the swabs from the debit card. He was excluded from the DNA profile from the swabs from miscellaneous items on the master bedroom floor, as well as the swabs from miscellaneous items on top of the dresser. He was also excluded from the DNA profile from the kitchen sink and from the white trash can. He was also excluded from the swabs from the front door in the family room, as well as the coffee table and the light switch. For the swabs from the bedroom door in the spare room, that was the DNA profile, that was the mixture of at least 3 individuals. He could not be ruled out. However, we ran it through the mixture software. It failed to produce results, therefore excluding him. For the swabs from the bedroom dresser in the spare room, the DNA profile was also a mixture of at least 3 with at least 1 male contributor. The DNA profile obtained from the swabs was approximately 26,000 times more probable if the sample originated from 3 unknown people than if it originated from Prentice Jerome Brooks and 2 unknown. This analysis provides very strong support for the proposition that Prentice Jerome Brooks is not a contributor to this DNA profile. The swabs from the back of the spare bedroom door DNA profile that I obtained indicates a mixture of at least 3 with at least 1 male. And he could not be ruled out. However, when I ran it in the software, it failed to produce results, therefore excluding him. He was also excluded from the swabs of blood from the dresser top, from the flashlight, from the wallet, from the torn check, from the purse, from the scissors, from the knife, from the $20 bill. For the credit cards, he could not be ruled out as a possible contributor to that mixed DNA profile of at least 2 individuals. The DNA profile obtained from that item is approximately 1.6 trillion times more probable if the sample originated from 3 unknown people than if it originated from Prentice Jerome Brooks and 2 unknown. This analysis provides extremely strong support for the proposition that Prentice Jerome Brooks is not a contributor to the DNA profile. He is also excluded from the tape samples and the glass cup. For the pouch sample that I talked about earlier, where we did the exterior and interior samples, he could not be ruled out as a contributor to the mixed DNA profile. The DNA profile obtained from the sample was approximately 320 times more probable if the sample originated from 3 unknown people than if it originated from Prentice Jerome Brooks and 2 unknown people. That falls into that uninformative range. For the interior sample, he was excluded. For the roll of tape, it indicated at least 1 contributor, and he could not be ruled out to the DNA profile. The DNA profile is approximately 1.3 times more probable if the sample originated from 2 unknown people than Prentice Jerome Brooks and 1 unknown person. So that would fall into that uninformative range. He was excluded from the checking account statement, and he was also excluded from the carpet sample as well. The last sample that we tested was the sundress sample, and he was excluded as a contributor from that sample.
Okay, all right. And did you perform any analyses on the samples submitted for the individual named Sean Holt?
I did.
Can you tell the jury the results and conclusions from those tests as well?
Yes. Sean Holt was excluded from the sundress sample. He was also excluded as a contributor to the DNA profile obtained from the knife, from the $20 bill. For the credit cards, that mixed DNA profile that we obtained, Sean Holt could not be ruled out as a possible contributor to the mixed DNA profile. From that item is approximately 11 million times more probable if the sample originated from 3 unknown people than if it originated from Sean Holt and 2 unknown people. Therefore, the analysis provides extremely strong support for the proposition that Sean Holt did not contribute to the DNA profile. He was also excluded from the scissors and from the tape samples and from the glass cup. For that pouch that we have been talking about, he could not be ruled out as a possible contributor to the mixed DNA profile that I obtained from the exterior of the pouch. The DNA profile obtained from that sample is 55 times more probable if the sample originated from 3 unknown people than if it originated from Sean Holt and 2 unknown people, so falling into the uninformative range. He was also excluded from the DNA profile from the interior of the pouch, from the checking account statement, from the carpet sample, for the bed sheet from the bathroom. He could not be ruled out as a contributor to the mixed DNA profile that we obtained. However, when we ran it through our mixture software, it failed to produce conclusive results, therefore excluding him. He was also excluded from the DNA profile we obtained from the swabs from the wall by the door. For the chair that we tested from the spare bedroom, he could not be ruled out as a possible contributor to one of the samples that we took from the left side of the chair rail. However, similar to the other sample, it failed to produce conclusive results. He was also excluded from the swabs from the gear shift, from the swabs from the rearview mirror. He was excluded from the DNA as a contributor to the DNA profile from the swabs from the driver's seat adjustment controls. He was excluded as a contributor to the mixed DNA profile from the swabs from the armrest center controls and the antenna and the swabs from the electronics in the living room. For the swabs from the flat screen TV, that was the mixed DNA profile that was at least 3 individuals with at least 1 male contributor. Sean Holt could not be ruled out as a possible contributor. However, it failed to produce conclusive results, therefore excluding him. He also could be excluded from the items from the, as a contributor to the DNA profile from the swabs from the items on the living room floor and the swabs from the TV stand drawers, the swabs from the bathroom door, the swabs from the return vent in the bathroom, the swabs from the handrail of the staircase indicated a mixture of at least 3 individuals, and Sean Holt was not able to be ruled out. However, the software failed to produce conclusive results, therefore excluding him. Sean Holt could also be excluded as a contributor to the mixed DNA profile from the swabs from the computer monitor. The swabs from the top of the nightstand, the DNA profile was a mixture of at least 3, and Sean Holt was not able to be ruled out as a contributor. The DNA profile obtained from the swabs is approximately 110 quadrillion times more probable if the sample originated from 3 unknown people than if it originated from Sean Holt and 2 unknown people. Therefore, this analysis provides extremely strong support for the proposition that Sean Holt is not a contributor to that DNA profile. The swabs from the top of the bed in the spare bedroom, there was a mixture of at least 2 individuals. The DNA profile obtained from the swabs is approximately 1,500 times more probable if the sample originated from 2 unknown people than if it originated from Sean Holt and 1 unknown person. That would fall into that uninformative range. Sean Holt was also excluded as a contributor to the DNA profile from the swabs from the right side nightstand, from the swabs from the top master bed, from the swabs from the miscellaneous items on the master bed, from the desktop flat screen TV, from the debit card on the desktop, from the miscellaneous items on the master bedroom floor, from the miscellaneous items on top of the dresser, from the kitchen sink, from the white trash can, from the French door, from the coffee table, from the light switch. For the swabs from the bedroom door in the spare room, Sean Holt could not be ruled out as a possible contributor to the mixed DNA profile that was obtained. That mixture was at least 3 individuals with at least 1 male contributor. However, the software failed to produce conclusive results and was an exclusion. He also could not be ruled out from the DNA profile obtained from the swabs from the bedroom dresser in the spare room. Similar to the last sample, it failed to produce conclusive results, therefore excluding him. The same result was obtained also from the swabs from the back of the spare bedroom door. He was also excluded from the flashlight and the swabs of possible blood from the dresser top. He was also excluded from the torn check and from the purse sample as well. And that should be it for Sean Holt.
All right. Yeah, and I'm getting ready to transition into a different section of the report and her analysis. I just wanted to inquire whether or not this was a good time for a brief break.
Checking in with the jury. All right, let's take 5. All right, Pam, you can sit down if you need to. We'll be in recess for 5.
I need to go. I got you.
Yeah.
Is it back where you're from? Oh, yeah. So go out this way down the hallway.
If she tries to do that.
Okay, thank you.
Yeah.
And I'm trying to figure out like if I felt
So I did. So I didn't.
Yeah.
Yeah.
Yeah, they were. You look like that. You was supposed to say
Their assistant director.
Did you need to go to the restroom?
Oh, I'm okay. Thank you, though.
Every single time. I'll try. I'm so national registry of the roads. That's for sure. You put like the control center. And so I know a lot of their research is around like the effectiveness of projections, interviews, and
Con permiso.
No?
I just had to yeah, actually.
Disregard.
We only do these really focused.
I'll go after Garrett tomorrow, so you want to let the chief know as well. Looks like I'll be going up around
Yeah.
10 or 11 tomorrow.
Yeah, they're natural. It's just kind That's. Yeah.
No, he's getting ready to come out. Let him do it whenever. That's what he told me. Mr. Wilson do it.
Yeah, okay, he's there. Oh, it's plugged in.
You see how quick boy said no?
Oh, you brought it out.
Yeah.
Okay.
I need one of these. I need to get
Yeah,
one of these.
it's a,
It works pretty good.
Battery operated or something?
Yeah.
Or-
yeah, I wanna get one
I
too.
gotta get one of those.
You said
I'll
what?
break
The sharp what?
We'll come over, man, see it?
What are we gonna do with this? Are you gonna?
Yeah, I'll come back to it. You can just leave it here to remind me.
Yeah. I don't wanna make it.
Mm-hmm.
That's all. Yeah. 11 days better.
Let's go back on the record. Mr. Fawcett rises.
Yes, I do have something briefly. So Dr. Sullivan had an appointment in the morning. We had her come today. In case we had a chance to get her in, so I just want to let the court know that she's outside. If possible, we'd like to try to get her in today if possible.
All right. Well, I imagine there'll be some cross here. And so we'll see where that takes us. Tomorrow morning, her conflict lasts, you think, until when?
I think it's for the morning, but we would have witnesses to take up the morning. But I think if she went today, I'm just looking at the possibility of concluding our case by lunch. That's a possibility if she goes today. So I know that if she's not available in the morning, there probably wouldn't be a break, but I was concerned about that. That's why I had her come today.
Okay. Anything else you wanted to address?
That's it, Judge.
Anything else on the defense side?
I didn't know a decision had been made to admit Dr. Sullivan.
No, I haven't yet, but he's just asking for one. And so we can get back into that. Let me first actually see if I can address one thing. Again, Defense Exhibit 4, Investigator Sautel, and this matter of the email. Now that we've heard the testimony of Investigator Bryant in the cross-examination, is there still testimony that you believe remains for you to cover with Investigator Sautel? Are you renewing your request to bring him back and for us to go through that hearsay analysis?
No, Your Honor.
All right, so I'll consider that a moot point, and I'll return this to you if you want it. But here it is. All right, and let me kind of lay out where I think I am with this Dr. Sullivan issue, which is just to clean up the record. We got a Westlaw site from Defense Counsel. I'm looking like it has made its way into a report. So that's 602 US 779 from 2024. One more minute. Okay. And that's the Smith v. Arizona case. And that has already actually been reflected in Georgia case law. It has resulted in the reversal of a case a few months back in Watkins versus the state, 320 Georgia 862. And Watkins, Smith, and a lot of this precedent is coming down to drug-related testing. And some of the issues that pop up there, the core of it being is that when an expert is relying on opinions, that they're essentially acting as a mouthpiece for another expert, and those opinions are just being asserted for the truth of the matter asserted, that's when we have a problem. And so what needs to be clear here is whether Dr. Sullivan is solely relying on the raw data. And I'd also question whether even the report itself would be admissible. She may have signed off on it, but if she didn't write it or come to those conclusions herself at the time, I would question whether she should even be reading from the report. I mean, she could refer to it, I suppose, just she needs recollection refreshed, but her own opinions, I would think from looking at these cases, need to be coming from outside that report. And again, reviewing the raw data itself. That would really only be the pictures. And so she'd have to be able to lay the authentication for those pictures on her own.
Well,
I just want to lay that as let me just finish this thought, that's what I see as the landscape of this case law. Let me start there, and I'll start with the state, move to the defense. Do you think I've summarized that correctly, or is there some other nuances we should?
No, well, I agree with that, but I would think that within those autopsy reports are measurements and descriptions and weights of from taken and dictated. I think those are quantitative aspects of the report that Dr. Sullivan should be able to base her opinion on, just as she would, photographs and depictions of defects.
And so the challenge there would be she didn't make those measurements. And just like a chemist in a drug case is measurements when they analyze some drugs, I would wonder whether that's the same type of data that if someone else has done is now saying, for the truth of the matter asserted, this person weighed 100 pounds. Can someone else just take that and now say, I guess that's true?
Well,
I am skeptical.
Well, it wouldn't be the fact itself. It would be the opinion that's derived from the fact. So if there's a defect that's described and measurements taken, based on those facts, she may be able to derive her own expert opinion, just as she would say, I see a defect to the back of Ms. Thomason's neck, and based on that, it's my opinion that that very well likely could have caused her death, or something else. But that would be for Dr. Sullivan to testify to, and I think that would be clear during the course of the direct examination.
Well, and that's where I think I would take Mr. Simonoff's point here. Because of this complication, it might not be a bad idea for the state to compile a bullet list of the topics and opinions that she is going to propound, and just so we have some idea, and make sure that this distinction is very clear in her mind.
Your Honor, there are a couple of things. Sullivan did not observe the autopsy, so she doesn't have personal knowledge of any of the foundational facts.
And so what would be the difference between an accident reconstructionist who's qualified as an expert, looks at all the photos of the accident and says, here's my opinion?
She's not an accident reconstructionist, Your Honor. She's a medical examiner testifying as to an autopsy, and she's giving her opinion and asserting as a fact that this is what the autopsy found. She did not perform that autopsy. So there's a confrontation clause objection, Your Honor.
I mean, that's the core of what we're talking about is confrontation clause. No doubt about that. We're all kind of assuming it's testimonial. I guess we're kind of gliding over that part, which
I
is.
do have one distinction.
Testimonial.
Well,
I do have
perhaps not.
I do have one distinction, Judge. Investigator Williams was present for the entire,
All right.
observed the whole thing.
Then I think it's safe to say it's testimonial.
Investigator Williams can now testify as the medical examiner. But that doesn't solve the problem, Your Honor.
I don't think that's the point he was making. I think he was trying to say that they're not contesting that it's testimonial because you had a detective there making it very obvious that it was likely to be used in a criminal case, which isn't always the case. They do hundreds of autopsies. Some are overdoses, some are accidental, some are suicides. They don't know necessarily. So I don't know if that's been litigated, but we're going to go ahead and say that's conceded by the state. So just.
So there's a
Right.
confrontation clause. Thank you, Your Honor.
Thank you.
There is definitely a clear confrontation clause issue. And then, of course, the hearsay objection. And the state are offering the testimony to prove the truth of what is asserted. Otherwise, what they're offering it for is not relevant.
I thought the court just said if Dr. Sullivan can look at the photographs and make her own determination based on the visual depictions, then that would be permissible. And now, since Investigator Williams was present during the autopsy, we've eliminated issues about the authentication of those photographs because he can testify that they're fair and accurate representation. So that's a non-issue. And since there would be an evidence with that authentication, Dr. Sullivan would be qualified as an expert, I'm just assuming, and that she would be able to do that on the stand and make that determination.
Okay, well, let's do this. I want to throw one more cite into the record, which I think is the most on-point Georgia case. Predates this Smith versus Arizona, but it's Najee, 300 Georgia 659 rather. That's 300 Georgia 659, which is about substitute medical examiners. And in that particular case, very much making the distinction that it was independent testimony. Dr. Henniger, in fact, in this case, and applying some of the Supreme Court precedent. But so I think maybe your standby counsel, not standby, your second chair, or should be working on this and really nailing down exactly and explaining what the expectations are here in providing that to defense counsel before we can throw her in front of the.
Your Honor, and I'd be
And-
happy to do that during the parade, or
Uh,
during the direct testimony.
All right, but so at this point, we'll see what the state comes back with. But in terms of the confrontation clause objection, it's certainly something I'm aware of and sensitive to. I think it's not something that totally bars her testimony. Objection being preserved, of course. It's going to very much depend on what the state presents us with here. And on hearsay grounds, that would also be overruled. All right, with that, it looks like the jury's ready to proceed. Let's bring them back. Thank you, Deputy Scott. Please be seated, everyone. State may resume the direct examination.
All right. Ms. Cervidio, I want to ask you if you received any samples from James Jones, in this case, from Sandy Springs Police Department?
I did.
And were they received and maintained in the same way that they were maintained and received with the other individuals you just testified to?
Yes, they were.
And when a sample is received at DNA labs, can you talk about how it is preserved and maintained?
So when the sample is received by our laboratory, it is logged into our system. We have an electronic system that maintains chain of custody. And after it is logged in, it is put into our secured evidence vault. That vault can only be accessed by people who are qualified to work on evidence. It is maintained in that vault unless it is being actively processed by an individual and then returned to that vault afterwards prior to being shipped back to the police department.
Okay. And are there any security measures in place to prevent unauthorized access?
Yes, the laboratory in general has a badge system, so you would need a badge to get into the office. And then in addition, the vault has a keypad on top of that.
Okay. And in your handling of the evidence received from Sandy Springs Police Department, the samples received from the individuals you just testified to, in addition to the sample received from James Jones, can you testify that they were maintained in accordance with your procedures at DNA labs?
Yes, they were.
Can you say whether or not there was any evidence you observed of any tampering of those samples that were submitted?
No, there was nothing noted.
Okay. Can you tell the jury what you did once you received the samples of James Jones?
Similar to the evidence in the case, you would take the evidence out into the laboratory. These were buccal swabs. Like I mentioned earlier, that's a swab of the inside of the cheek. So you would cut a sample from that swab, put it in a tube, and then it would proceed through the same 4-step process in the laboratory from then on.
And talk about any conclusions that you were able to draw from the testing that you did on the sample submitted from James Jones in this case.
We obtained a single source DNA profile from that buccal swab from James Jones.
Okay. The jury, if you were able to reach any conclusions from any analysis that you did with that sample.
Yes, I was.
Okay, and what were those conclusions?
The first sample was the sundress sample. That was the sample that was taken from the upper back, lower rib cage area and the front exterior chest of that sample, of that item, excuse me, he could not be ruled out as a possible contributor to the mixed DNA profile that was obtained. When I evaluated this DNA profile, I had determined that it was a mixture of at least 2 individuals. So what I did was, it looked like it could be 2 or maybe even 3 individuals. So I ran it through the software as both. So when I ran it as 2, the software could not reach a conclusion. But when I ran it as 3, the DNA profile obtained from that sample was approximately 550 billion times more probable if the sample originated from James Jones and 2 unknown people than if originated from 3 unknown people.
Ms. Cervidio, I want to turn your attention back to that, the range that you were referring to. Your testimony previously was that 1,500 is the point where something is informative?
Uninformative or informative. Above 1,500 would be informative.
Okay, so we go from 1,500 to 1,000,000. And what was your description of when we hit 1,000,000?
Extremely strong support is anything over 1 million.
Okay, and so on the sundress, your testimony is that, what was that figure again?
The DNA profile was approximately 550 times more probable.
Okay, so what would that still be considered, or what was your classification of that particular finding?
That analysis provided extremely strong support for the proposition that James Jones is a contributor to that DNA profile.
Okay. Let's talk about the next thing you analyzed in this case, submitted against the DNA from James Jones.
The bedsheet sample,
Okay.
going in order. So the bedsheet sample, we had collected a sample previously from the edges of the sheet, avoiding staining. James Jones could not be ruled out as a possible contributor to that mixed DNA profile that we had obtained. In this case, that DNA profile was approximately 10 times more probable if the sample had originated from 4 unknown people than if it had originated from James Jones and 3 unknown people. So the scale would be in the uninformative range for that.
Okay. Can you tell the court if you had an opportunity to analyze a gear shift that was submitted by Sandy Springs Police Department?
I did.
And was that a gear shift submitted from a vehicle?
I believe so.
And were you able to reach any, or can you tell the jury any conclusions that you reached from that analysis?
Yes, James Jones could not be ruled out as a contributor or a possible contributor to the mixed DNA profile that was obtained from the swabs. Similar to the last sample, I ran it as 2 and 3 contributors. The software failed in relation when 2 contributors was considered. When 3 was considered, the DNA profile obtained from the swabs is approximately 2,900 times more probable if the sample originated from James Jones and 2 unknown people than if it originated from 3 unknown people. That analysis would provide very strong support on the verbal scale for the proposition that James Jones is a contributor to the DNA profile.
And did you have an opportunity to analyze an armrest center console from that same vehicle?
I did.
Can you tell the jury the conclusions that you reached from that analysis?
James Jones was not able to be ruled out as a possible contributor to the mixed DNA profile that was obtained from that sample. The DNA profile obtained was approximately 43,000 times more probable if the sample originated from James Jones and 1 unknown person than if it originated from 2 unknown people. That analysis provides very strong support for the proposition that James Jones is a contributor to that DNA profile.
Okay. And did you also seize on a French door submitted by Sandy Springs Police Department?
I did.
Can you tell the jury your results and conclusions from that analysis?
James Jones could not be ruled out as a possible contributor to that mixed DNA profile that was obtained. When I considered 2 individuals in the mixture, the software failed to produce conclusive results. However, when I compared under a proposition of 3 contributors, the DNA profile from the swabs is approximately 19 million times more probable if the sample originated from James Jones and 2 unknown people than if it originated from 3 unknown people. That analysis would provide extremely strong support for the proposition that James Jones is a contributor to the DNA profile.
All right. Can you tell the jury if you conducted any analysis on a light switch labeled in spare room submitted by Sandy Springs Police Department?
Yes, James Jones could not be ruled out as a possible contributor to the mixed DNA profile that we obtained from that sample. When we compared to a proposition of 2 overall contributors, it failed to produce results. However, the DNA profile obtained from the swabs is approximately 4.2 thousand times more probable if the sample originated from James Jones and 2 unknown people than from 3 unknown people. So that analysis provides very strong support for the proposition that James Jones is a contributor to the mixed DNA profile from this item.
Did you also test and analyze a pair of scissors submitted by Sandy Springs Police Department?
I did.
And can you tell the jury your conclusions from that analysis?
James Jones also could not be ruled out as a possible contributor to the mixed DNA profile previously obtained from the handle area of the scissors. The DNA profile obtained from that handle area is approximately 840 million times more probable if the sample originated from James Jones and 2 unknown people than if it originated from 3 unknown people. This analysis provides extremely strong support for the proposition that James Jones is a contributor to the DNA profile from this item.
Okay, and again, that's on that scale from, you mentioned from 1,500 to 1 million?
Yes, that would be above 1 million.
Okay. All right. Can you tell the court how many total items that you tested that was tested against the sample, James Jones?
For James Jones in particular, I believe there was 1, 2, 3, 4. About 30,
Okay.
I believe, comparisons I did to his DNA profile.
The 30 comparisons that you performed against the samples submitted by James Jones or by the Sandy Springs Police Department, your testimony is you found that he was a contributor on the sundress, the gear shift, the armrest center console, the French door, the light switch in the spare room, and the scissors. Is that your testimony?
My analysis provided support for those propositions.
Okay. One moment, Judge. All I have, Judge.
Cross-examination.
So let's see. A person inherits 1 allele from each of their parents at each locus, correct?
Correct.
And so each person should have 2 alleles at each locus, correct?
It may be the same allele from each parent, and in that case, it would appear as 1 peak. But yes, there is 1 allele that is coming in from each parent. Mm-hmm.
Okay, so it's possible that 2 different people may have the same allele at a locus.
Yes, it is.
And people may sometimes inherit the same allele from both parents.
Correct.
So when you look at peaks on an electropherogram, and that's what that thing you called with peaks is actually called.
It is.
An electropherogram. There are literally thousands of possible theories that might account for the peaks observed in a complex mixture, correct?
I don't know thousands of possible theories. Can you rephrase that question?
Well, there are possible explanations. Let's say you 15, 18, 20 and 24, that may mean one person is a 15 and an 18. It may mean one person is a 20 and a 24. It may mean that one person is a 15 on both from both particular parents, and so on and so forth.
Yes.
There are a number of possible combinations.
Yes, correct.
Perhaps that's a better way of explaining.
Yes.
There are a number of potential explanations.
Correct. There could be a number of different combinations.
And peaks are sometimes produced spuriously due to the presence of small amounts of contaminating DNA.
They could be.
This is called drop-in.
Yes.
Or the process may produce small false adjacent to large peaks due to stutter.
Correct.
So sometimes it's even difficult to know how many contributors you've got.
It can be. It can be. That's why we have a rigorous training program to help us determine how many contributors may be in a DNA profile. In addition to that, our software, where we run these complex DNA profiles, has oh my goodness, diagnostics that you can look at, and if they're out of range, that might be able to tell you that something is wrong with the analysis. For example, if you're in your car and a light comes on, that tells you something's wrong and you need to look deeper or look more closely at your car to see what's happening with it. It's similar to that.
Okay. Now, unlike the GBI, you're a private DNA laboratory, correct?
Correct.
And you were retained by the Sandy Springs Police Department?
Yes.
And you were paid for the work you did?
Our company.
And how much were you paid?
I was not paid anything specifically for this case.
Your company?
I don't know that.
No idea at all?
I don't know. I know we did a lot of testing, so I'm sure it was expensive, but I'm on the science side of the house. I do not deal with billing or sales, so I am unaware of what the price was.
Well, you analyzed more than 100 items of evidence.
Yes.
And you prepared 6 reports.
I did.
And your estimate for the first report was just under 40,000.
I can't speak to that.
Sorry?
I can't speak to that. I don't know anything about prices. No.
Are you being paid for your testimony here today?
I am not. My company is.
And how much is your company being paid for your testimony here today?
I don't know.
Your Honor, I would object that the witness has testified that she is not familiar with the amount of the total monies paid to the company or the rate. There are other witnesses that she can ask this, but she doesn't have the knowledge of this.
All right. Well, at this point, she's answered the question. And so if you feel you have a basis to renew it, you can at that time. You can move on, Ms. Levinsky.
Aren't you the owner of your company?
I am not.
No.
No.
Okay. Would you agree with this statement? DNA analysis of complex mixtures, which is defined as mixtures with more than 2 contributors, is inherently difficult, and even more so for small amounts of DNA.
Yes, it can be.
That comes from the PCOS report.
It does.
I believe you would be familiar with the PCOS report.
Fairly. It came out a number of years ago, but I do know about it at the time.
And could you explain to the jury what the PCOS report is?
It was a report that was issued in the forensic science community, and it talked about mixture interpretation and some of the challenges that we face as a community with mixture interpretation.
STR mixes reliable for three-person mixtures in which the minor contributor constitutes at least 20% of the intact DNA in the mixture.
Is that a question?
Yes.
That might be paper, but our laboratory does a validation of StarMix. It's actually required by the FBI. So when the StarMix program was created, it underwent a developmental validation, and that validation got put out to the community, the forensic community, and everyone reviewed it, and it was published. Each lab in the United States, when we bring online a new technology, we have to do a thorough validation. What that means is we test that software using all kinds of different samples. We have to make sure it's working and it's working appropriately. For example, when you have a car, they test cars. They do all kinds of testing before they release that into the market. So it's very similar. So we did one to test what types of samples, what quantities of DNA we could use, how many mixtures or how many people in a mixture we could do, and all of these mixtures fell within that range of testing.
I'm not sure that I got that as an answer to the question. Do you agree with that statement?
Can you repeat the statement?
STR mixes reliable for three-person mixtures in which the minor contributor constitutes 20% of the intact DNA in the mixture.
I do agree it's reliable for that situation.
But below 20%, it becomes less reliable, correct?
I wouldn't say it becomes less reliable. It really depends on the mixture itself. How the program works is it takes different probabilities. So it looks at all those peaks that we were talking about, and it breaks down what are the likely peaks that line up with each other. What are the different combinations of DNA types within that mixture? And then it compares an individual to that mixture. So if you do have a minor DNA profile, and what minor DNA profile means is there's DNA from someone that's lower, there's less DNA from somebody than the major contributor, for example. That will be reflected in the statistic because it takes into account that uncertainty.
Oh, and before I forget, what is mitochondrial DNA?
Mitochondrial DNA is DNA that's inherited on the maternal line from your mother. You have thousands of copies in your cells, as opposed to you only have one copy of your nuclear DNA. Mitochondrial DNA is actually the primary method from fallen soldiers that we used at AFTL as well while I was there.
If you were going through a house looking for skin cells and stuff like that, would you be looking for mitochondrial DNA?
Typically, you don't want to, mitochondrial DNA can be a useful tool, but because everyone on your maternal line will have the same DNA profile, it's not as discriminatory as something like nuclear DNA, which should be, or autosomal DNA is what we call it, which should be inherent to you as the individual. I would have the same mitochondrial DNA as my mother, as my sister, as my brothers, because it goes down that maternal line. Any children I have should have the same mitoDNA profile. So no, that's not the typical form of testing you would use for that type of sample.
And then the cuticle tool, an insufficient amount of male DNA was detected in the sample collected from the cuticle tool. Is that correct? Item 100. And I believe you might find that in report.
Yes, you're correct. An insufficient amount of male DNA was detected on that sample we collected from the cuticle tool.
So that was never analyzed.
Not beyond determining that there was an insufficient amount.
Now, let's talk about the sundress.
Okay.
The sundress was first reported on in report number 5, correct?
Yes.
And in report number 5, dated May 26th of 2020, and perhaps let's see if my technical skills will get me there, or if Mr. Simonov's technical skills will get us there. I'm trying to pull up report number 5, which would be defendant's exhibit. It would be on that flash drive. And that is exhibit number 10. My tech skills are dreadful. Is that your report number 5? I think you've got it in front
Yes.
of you.
Yes, I do. Mm-hmm.
And perhaps let me introduce a copy.
On the tenderness and evidence.
Yeah.
So go ahead and do that, and if you want to publish it.
Yes.
Like,
Thank you.
Do you recognize the document?
I do. Mm-hmm. Of course.
You're on our big line.
No objection.
All right. It's submitted.
In report number 5, dealing with the sundress, you said the following. Oh, dear. You didn't say I did. That was me.
It's follow. All right, how about now?
Try now. Okay. You had analyzed the sundress.
Yes.
And you said that the DNA profile from the sample is approximately 14 quadrillion times more probable if the sample originated from K. Thomason and one unknown person than if it originated from 2 unknown persons.
Correct.
That correct?
Yes.
Therefore, there is extremely strong support that K. Thomason and one unknown person contributed to this DNA profile rather than 2 unknown persons.
Correct.
And in that report, number 5, you had done comparisons with Prentice Brooks, Timothy Bryant, Sean Holt, Brian from Brandon Holt, Brandon McDonald, correct?
Correct.
And in all of those analyses, for want of a better term, you had done your as two contributors, correct?
No, I had excluded them prior to running the sample in StarMix. So what we do is we look at the DNA profile from the evidence. We always analyze that first before we analyze any of the reference standards because we want to make sure we're not biased. So we analyze that first and we determine the number of contributors in it, the estimated number of contributors. Then we compare the individuals, their DNA profiles to that mixture. If I don't see those individuals' DNA types or I see that they're missing a lot, then I can visually exclude them before I even run them in the software. So that's what I did for these individuals. That's why they could not be excluded and then run it in the software.
Now, then get the sample for James Jones, correct?
Correct.
And before you get the sample for James Jones, does Detective Williams talk to you?
I don't recall. I know he submitted that sample, but I don't recall if there were any conversations between us, between the 5th report and the 6th report.
Don't recall that at all. All right, let's look at your 6th.
So,
You said the DNA profile obtained from the sample failed to produce conclusive results in comparison to James Jones when a proposition of 2 overall contributors was considered.
Yes.
Correct?
It is.
And you did in your report, in your interpretation report, when you did the analysis regarding the contributions, the mixture proportions in the sample on the nightshirt, and this would have been when you did report number 5, you did mixture proportions of 92% and 8%, correct?
I will have to check in my case file.
And perhaps I can help you a little bit. Show you defendants 12.
Thank you. Yes, contributor 1, the mixture proportion was estimated at 92% of the DNA profile, and contributor 2% of the DNA profile.
And at that time, there was no suggestion that there were 3 contributors, correct?
There were indications that there may have been 3 contributors. The only way to know for sure the number of contributors is to actually make a DNA mixture yourself, which obviously we do not do in the lab unless we're doing validation type samples where we're testing something. So I had estimated there were at least 2, but I did see indications that there could possibly be 3, and that's why I did run it as two different propositions in my report.
So back when you did report number 5 in May of 2020, you said 2 contributors, 92% and 8%. You didn't say, well, maybe there's a 3rd contributor hanging around here.
I reported it as a mixture of at least 2 individuals.
Okay. So then in July, the police sent you the buccal swab, for James Jones, and you run her DNA inputting the information as 2 contributors, and you say it fails to produce conclusive results.
Correct.
Tell me what you mean when you say it fails to produce conclusive results.
That means that if there is truly only 2 individuals in there, that individual would be excluded, like I mentioned earlier.
That individual is excluded because that person's DNA does not match fully the profile of the other profile in the DNA song.
Yes, there would be some other minor DNA type that the software could not explain with 2 people and that person.
Hence, it would give you a likelihood ratio of 0.
Correct.
So when you say in your report, it failed to produce conclusive results, you mean, in fact, she was excluded, correct?
When the proposition of the number of contributors was 2 contributors.
And you would agree, would you not? There's a difference between saying no conclusive results were produced and she was excluded.
That was our report wording at the time for a likelihood ratio of 0, because basically the software is erroring. It's saying, I cannot analyze this DNA profile as a 2-person mixture with this person when looking at this person as a part of that DNA profile. So that was our wording at the time. But basically, yes, it's excluding that person under that condition of 2 overall contributors.
So instead of saying that person's excluded, you say, oh, well, no conclusive results. Okay. You then run it as 3 and you get this 550 billion times more probable, and you get a new percentage. And correct?
Yes, the percentages would slightly vary because you are telling the software that there is 1 more person in there.
And what were the new percentages?
I do not have, I can look and, do you have a copy?
I do.
Okay.
Defendants 13.
Thank you. The new percentages were 91% for contributor 1, 8% for contributor 2, and 1% for contributor 3.
And you would agree, would you not? This is the first time the decision is made to run that nightshirt with an extra contributor in the sample?
It was the first time I ran an S3. Everyone else had been previously excluded, and I had just run it against Kay Thompson, who was the major contributor in the DNA profile.
And when you say it's 550 billion times more probable if the sample originated from James Jones and 2 unknown persons than if it originated from 3 unknown persons, that's also not correct, is it?
The DNA profile is approximately 550 billion times.
Well, is that correct? I thought you said it was 14 quadrillion times more probable that Miss Thomason contributed to that sample.
The DNA profile also is 14, I believe 14 quadrillion times.
So there aren't 2 unknown persons.
No, that's not. Like I said, the number of contributors is never known. When it's giving that statistic, it's giving that statistic in relation to that person. When you have a major contributor like this, we have done studies at our laboratory as part of our validation, like I described, that says what would happen to the likelihood ratio of someone who is more of a major donor if you increased to 3 or 1 higher. And the finding was that it would not vary. So there was no reason to rerun her as 3 individuals, or rerun the mixture as 3 individuals. In addition, this was a sundress that was taken directly from her body, which we call that an indigenous sample in our community. So at that point, you assume that she's going to be on her own sundress.
So would you agree it's nonsense to say it's more probable that it's James Jones and 2 unknown persons than if it originated from 3 unknown persons?
No, I think that the DNA profile obtained from the sample is approximately 550 billion times more probable if the sample originated from James Jones and 2 unknown people than if it originated from 3 unknown people.
And we just skip Miss Thomason.
I can read that statistic as well if you would like.
Now, even with your 550 billion times more probable, the best you can say is that Miss Jones cannot be ruled out as a possible contributor to the mixed DNA profile, correct?
That was the statement I made before I made the comparison. And then you have your statistical analysis, which is, like I said, the DNA profile obtained from the sample is approximately 550 billion times more probable if the sample originated from James Jones and 2 unknown than if it originated from 3 unknown.
You cannot say that it's her DNA.
No.
And you would agree, would you not, that increasing the number of contributors increases the chances of obtaining a false positive?
It could. It depends, but it could.
Let's have a look at item 11, the swabs from the gear shift. They're also covered, I believe, in report number 6.
Yes.
And this is another of the reports where you said two sets of propositions were considered. The DNA profile obtained from the swabs failed to produce conclusive results when a proposition of 2 overall contributors was considered.
Correct.
Is that again your language for she was excluded?
Yes.
Okay. So you had previously run this DNA sample in, I believe it was
The third report?
The third report. And you said that the DNA profile obtained from the swabs is approximately 530 trillion times more probable if the sample originated from K. Thomason and one unknown person than from two unknown persons, correct?
Correct. This is the same type of situation as the last sample that you mentioned, where you have a major component, and that's where you're getting that DNA profile obtained from the swabs is approximately 530 trillion times more probable if the sample originated from Ms. Thompson and one unknown person than two unknown people. And then I excluded every other person in that original report. And then when in the further report, I did analyze as 2 and 3 based on what I saw in that DNA profile.
So would it be fair to say that by then you'd excluded people and you'd done an awful lot of analyses and you'd spent an awful lot of money, correct?
I had not spent any money.
Well, your lab had spent an awful lot of money.
We processed a lot of samples.
Let's find report number 3. That's Defense Exhibit 8.
Here are your other ones as well. Of course.
Your Honor, and I'm going to ask to introduce defendants 13, 14, and 8 into evidence.
No objection, Judge.
13, 14, and 8 are admitted.
Let's look at defendant side. That's done something. This one, can you know?
It's on right now. It's just not pointing to it.
Thank you, magic.
I can see the green light.
Yes. The DNA profile from the swabs is approximately 530 trillion times more probable if it originated from K. Thomason and one unknown person than if it originated from two unknown persons, correct?
Correct.
And again, you determine proportions.
The software did.
Your software determines proportions
Correct.
for this particular item.
Yes.
Sorry. Yeah. and that would be defendants 15. Mixture proportions of 93% and 7%. No third contributor.
Thank you. Yes, this is the two-person run that I had done when I was comparing to Kay Thomason. The proportions are 93% for contributor 1 and 7% for contributor 2.
You get the swabs for James Jones, put in 2 contributors, get an exclusion. So you decide, well, let's put in a third contributor, correct?
No, I analyzed the DNA profile. When you have a situation like this, just like with the last sample, where you have a major DNA profile and then more of a minor DNA profile, it can be difficult to determine the exact number of contributors. I saw indications that there could be 3 contributors, so I ran both sets of contributors.
There was no suggestion in the electropherogram that there were 3 contributors, was there?
May I refer to my notes?
Please.
There was an indication that I noted in the case file at D5 that there may be 3 contributors. So in both situations, this profile and the last, when I wrote down on my tracking sheet what I had done, I put 2 contributors, 3 contributors, that's what I'm running, and I wrote why. So at the D5 location, there was an indication that suggested there could be 5 people. That's why I ran both.
Wasn't it?
So when you look at mixed DNA profiles, you don't just look at the number of alleles. You also look at the height of alleles as well. So for example, for a person that has 2 alleles at one location in a single source profile, you expect those alleles to be fairly even in height because you're getting half your DNA from mom and half your DNA from dad. So when you're looking at a mixed DNA profile, if there's peaks that are uneven, that can start to support that there's an increased number of people in that DNA profile. So that was what I noted for this particular sample in my notes. Would you like the locations I noted for the other sample?
No,
No.
thank you. Now, you then get this, and you say it's very strong support that the sample originated from Jones and 2 unknown persons.
Correct. The likelihood ratio for this was a lower value. It was 2,900. So that falls in the very strong support category.
In your report, you tend to talk in terms of millions, billions, trillions.
I have statistics much lower than that in this report as well. But yes, we do have some statistics that are in billions and trillions.
2,900 times isn't a particularly high number, is it?
No, that's why we have that verbal scale to show that it is a lower level of support for that particular proposition. The analysis is providing a lower level of support.
And that's the strong support.
Very strong support.
And then, of course, you now get new proportions to go with it.
Yes, when you rerun the sample with a different number of contributors, you have to get slightly different proportion numbers because you are telling it there's an extra person. It has to account for that.
Tell me, is it Cervidio?
Cervidio.
Cervidio.
Correct.
Thank you. What does it mean when you say in your report that there should be reference samples taken from first-degree relatives?
So we have a note that goes in our report when there are flags in the DNA profile that suggest that there could be a family member contributing to that DNA profile. So it's one of those diagnostics that I talk about, or flags that go off. So we always recommend at that point that first-degree relatives are submitted. By first-degree relative, I mean brother, sister, or parents or children, in order to do conclusions or comparisons to those individuals and either rule them out or generate a statistic in relation to them.
So it's kind of like a red flag?
It's a flag.
Right. And with the swabs from the Centre Council, your third report, said it is 16 trillion times more probable if the sample originated from K. Thomason and one unknown person than from two unknown people, correct?
The DNA profile is 16 trillion times more probable.
Correct. Okay. And then in report number 6, you refer to again the red flag.
Yes, for that sample, correct.
Now, item 66, the French door in the family room. This was first included again in your third report.
Yes, that's correct.
And in that report, you again said that the DNA sample profile obtained from the swabs, and let me find it, sorry. The DNA profile from the swabs is approximately 14 quadrillion times more probable if the sample originated from K. Thomason and one unknown person than if it originated from two unknown persons.
Correct.
Same thing.
Yes.
And again, you do proportions.
Yes.
And the mixture proportions there, little different, were 95 and 5. Again, no third contributor, correct?
Correct.
And then, of course, along comes James Jones' sample, and you decide to add a third contributor.
I assessed the DNA profile like with the past samples. For this particular sample, at D13, there was the location. D13 is the location that I was looking at, also suggested 3 individuals. So that's why I also ran it as 3.
And you then found in report number 6, I believe, I'm losing my place in reports. And here you find that the DNA profile obtained from the swabs is approximately 19 million times more probable if the sample originated from James Jones?
Yes, then if it originated from 3 unknown people.
Now, what I found particularly interesting about this one is that when you did the proportion with some really interesting proportions, and this is defendants 22.
Thank you.
And would you read for us the proportions you found with 3 contributors on defendants 22?
The mixture proportions for this sample are listed as 94% for contributor 1, 4% for contributor 2, and 1% for contributor 3. If you add those up, that equals 99%. That's because those mixture proportions are estimates. And so, if it doesn't equal 100%, that just means it's a little bit, it's rounding, basically.
I'm not sure I understand that.
So at that point, if you look into the background of the software, it's 94 point something, it's 4 point something, it's 1 point something. So altogether, those numbers equal 100%. But on here, it just shows what that kind of truncated number would be.
So it went from being 100% to being 99%.
No. Oh, you mean the total?
Yes.
These are the estimated values. Like I said, in the background, it equals 100%. But because it's truncating those numbers, that's why it equals 99%.
So then we look at all the items in which Miss Jones was ruled out as a contributor. I don't think you mentioned those.
No, would you like me to go through them?
I'll be happy to do it if you confirm them for me.
Okay. Would you mind mentioning the report as we go through?
It's
all in the 6th report.
It's all the 6th report.
Perfect. Thank you.
Miss Jones only becomes a factor in report
Yes.
number 6.
Thank you.
And as I have it, she's ruled out from item 76.
Correct.
the chair from the spare room.
Yes.
Do you know which chair that was?
I don't know if there were several chairs in the room. I'm not sure. Which
Is
one?
it,
I
is
believe,
it that chair over there or is it something else?
I believe it's that chair over there. It looks like that chair.
Okay, so that chair over there, she is actually ruled out as a contributor.
Correct.
Okay. The red pillowcase and pillow.
Yes, she's excluded.
Antenna from the center console.
Yes.
Swabs from the electronics in the living room.
Correct.
Swabs from items on the living room floor.
Correct.
Swabs from the bathroom floor.
Correct.
Swabs from the return vent.
Yes.
In the bathroom.
Yes.
Swabs from the handrail of the staircase.
Yes.
Swabs from the computer monitor in the dining room.
Correct.
Swabs from the top of the nightstand in the spare bedroom.
Correct.
Swabs from the debit card on the desktop.
Correct.
Swabs from miscellaneous items on master bedroom floor.
Correct.
Swabs from kitchen sink.
Correct.
Swabs from coffee table in family room.
Correct.
Swabs from bedroom door in spare room. And can you tell me, is that the item over there?
It looks like it could be. We should have our own item number on it. So I can't tell you for sure without further inspection, but it does look like it.
I'd like to have a look at it, perhaps.
Your Honor, is that okay?
You can step down.
Sorry. Sorry.
Yeah, well,
That's it.
just it's not on the record.
Thank you. Thank you so much.
All right, can you repeat any question and answer that you asked her? Ms. Levinsky, can you repeat any response she gave when she was over there?
Sure. Thank you. So the bedroom door in the spare room is the door that has been produced in the courtroom.
Yes.
Swabs from the bedroom dresser in the spare room.
Yes, he's excluded. James Jones is excluded.
Swabs from the back of the spare bedroom door.
Yes.
The swabs from the flashlight or the flashlight.
Yes.
Torn check.
Yes.
Purse.
Yes.
Roll of tape.
Yes.
Checking account statement.
Yes.
And then there are other items in which it is, in which she is not excluded, but the likelihood ratio is uninformative.
Correct, or supports exclusion.
So for example, item 99, the bed sheet from the bathroom.
Yes.
That 10 times more probable if the sample originated from 4 unknown persons than if it originated from James Jones and 3 unknown persons.
Yes, the DNA profile is.
Therefore, the strength of support for our position could not be determined.
Correct.
The swabs from the driver's seat adjustment controls.
Yes.
Again, uninformative.
Yes.
Swabs from the flat screen TV in the living room.
Correct. Those are also in the uninformative range.
Swabs from the items on the living floor.
Yes. I also, for this sample, ran this as 2 and 3 contributors because I saw an indication that there might possibly be 3. When I ran it as 2, it failed to produce conclusive results. And when I ran it as 3, the DNA profile obtained from the swabs is approximately 98 times more probable if the sample originated from James Jones and 2 unknown people than if it originated from 3. So that would also be uninformative.
Swabs from the TV stand drawers.
Yes.
Uninformative.
Correct.
Swabs from the bathroom floor. Oh, sorry. She was excluded.
Yes.
Swabs from the top of the bed in the spare bedroom.
Yes.
Again, uninformative.
Correct.
Swabs from miscellaneous items on top of the dresser.
Yes, that was uninformative.
Wallet.
Yes, that was also uninformative.
Five credit cards, 1 rupee bill and 1 AARP card. There is strong support that 3 unknown persons contributed to this DNA profile rather than James Jones and 2 unknown persons.
The analysis provides very strong support that James Jones is not a contributor to the DNA profile. For this sample, the DNA profile obtained from the item is approximately 200,000 times more probable if the sample originated from 3 unknown people than if it originated from James Jones and 2 unknowns.
Similarly, I believe something, the exterior of a pouch.
That was uninformative.
Now, your lab had an issue, did it not?
Can you rephrase the question?
Well, did your lab have a problem with the way it was doing things at the time this case was analyzed?
Is there more information?
During documentation was sent to me regarding corrective preventative action that you're.
Jan, I'm going to object. If we're talking about a document that was sent to her from someone
Let's
else.
rephrase the
No.
question, Ms. Lubinsky. You can ask
It
her.
was sent by
Well, no,
the
we're not-
prosecutors in this.
Excuse me, Ms. Lubinsky. You can rephrase the question if she has knowledge of the thing. I don't think I need you representing what you were sent by someone else that is not here. So you can rephrase the question.
Well, let me ask her if she recognizes this document.
Start there.
Thank you. Yes, I do recognize this document.
Jan, the next question I would ask, because of what was started with the question of the defense, is if this is a document that she either produced or has direct knowledge of, because if she doesn't, then it's hearsay, and that would renew my objection.
All right.
And Ms. Cervidio,
Yes.
did you produce that document?
Yes, my signature is on this document.
Will you explain to the court? Sorry, no, don't explain to the court. First of all, which is on that document, it is a document that you produced.
It is a document that I signed off on. The original document was submitted by an analyst at our laboratory. The quality assurance manager completes a section, and then I have a final review and sign off on this document as the technical leader.
And at this point, Judge, I would renew my objection. It appears to be statements from someone that's not in the courtroom.
All right, well, she hasn't tendered the document, but to the extent you're about to tender the document, again, I don't think that would be proper, but it does appear you can ask her about the contents of it and the subject matter because she has knowledge of it.
Well, and Judge, if my understanding of the rules is that she can ask her a specific information from her direct knowledge, but not as to the contents itself. Like what is on the page, I wouldn't be able to ask.
It's all going to depend on the phrasing. Let's hear the question and we'll go from there.
You're acquainted with any issues in your laboratory?
Yes.
During recent validation work, it was discovered that the slope and intercept values in the global filer 2-base pairback stutter file for STR mix V2.6 did not align with those published in DLI's internal validation of the software.
Yes. So as I mentioned before, we have internal validations that tell us that's how we evaluate software, that's how we evaluate new technology at our laboratory. And when we did a review, we discovered that there was a typo in some of those settings in that validation. So as part of an accredited laboratory, anytime that you find an error to a certain magnitude or to a certain degree level as far as the investigation goes, you have to initiate a corrective action. So that's something that every laboratory has. We are required to have that. Every public laboratory has those as well. And for this typo, we did an investigation to see if it affected any of our casework, and it did not. And as a result, we found that those that typo, those settings with that typo do not affect the casework, and they're still in use today in casework. So we did not change any of our methods that we did at the time of this report to now.
So there was an error, you investigated and found that it did not affect things.
Yes, our quality assurance team investigated it.
May I have one?
If she didn't, then no.
All right. Okay.
So, did you run more than 2 contributors on the sundries for anyone other than James Jones?
No, I believe that everyone else was excluded visually up front. Let me confirm.
Well, wasn't Miss Jones excluded when you ran it?
When I ran it in the software, but as I explained, the first thing we do is we do a visual comparison. And if an individual is missing a great amount of alleles, we don't run them in the software. So everyone else besides Ms. Thomason was visually excluded. So I did not run them in the software.
And that applies to all of the items. Is that correct?
That applies to, yes, that theory applies to all of the items.
So the only person you ran 3 contributors for was Miss Jones.
For the sundress, yes.
And for, let's see, the gear shift.
Yes, for the gear.
The center console, the back door, etc. Correct?
Yes, for the center console. And yes, for the door as well.
Why did you stop at 3 contributors?
I didn't see any signs of 4 contributors.
Oh.
I saw possible indications of 3. And like I said, I recorded the locations that suggested 3.
Now, the verbal ranges that you come up with, very strong support, extremely strong support, etc. These are arbitrary characterizations, correct?
The verbal scale that we used was recommended to us by the manufacturer of the software. We incorporated that uninformative range, like I discussed earlier, on internal validation. We wanted to look at what the highest false inclusion that we saw during our validation was. So that's why we established that uninformative range there.
And talking about false inclusions, with the additional contributors, there is greater likelihood of false inclusions, correct?
I would say it's possible. I can't give you a likelihood of a false inclusion, but that's why we have these statistics and things like that to put weight to that. That's why we don't just say cannot be excluded, because what does that mean? You have to give a statistic and a weight to that value.
Do you have a likelihood ratio, or do you have any figures on false inclusions using the software?
Yes, that's why I mentioned the uninformative range. We made that range based on our highest false inclusion that we saw during validation.
And how many false inclusions have you had?
I don't know.
But you've had false inclusions.
As part of our validation, yes, and that's what I said. We established that range. 1,500 was the highest that we saw. Right south 1,500 was the highest that we saw for false inclusions.
But you don't know how many you saw?
No, I don't recall. It was a lot of data. It's a lot of DNA mixtures. It's a lot of samples. I can't be sure. But again, that's why we're saying it's uninformative for some of these statistics, because we're saying it falls into that range.
I have nothing further, thank you.
All right, members of the jury, feel free to stretch in place if you'd like to, and but if no one needs to step out, then we'll see if the state has any redirect.
And so it looks like I had your pronunciation incorrect. So Cervidio?
Cervidio, yeah.
Cervidio, okay, all right. So the processes that you described and testified to this afternoon related to testing mixture samples of DNA submitted, are they considered, these procedures in the test themselves, the application, are they considered reliable scientific procedures in the community?
Yes, there's considered reliable. Like I said, there's developmental validations, there's internal validations. These are validations every forensic, accredited forensic laboratory has to do.
Okay. How many, just generally, how many years has this program or the analysis that you're conducting on mixture samples of DNA been in use actually?
At our laboratory, 10 years. Internationally, beyond that, it is used in Europe. It is used in New Zealand.
Okay. How many states in the United States is this process used in?
I don't know the number of states. It's many. Like I said earlier, over 50% of labs in the country are online actively. And I think, you know, another like 20 to 30% have at least bought the software or in the process of validating and bringing online the software.
Okay. And are there any certifications associated with the program, such as in conjunction with the FBI or any other federal agencies?
So I don't know that I would say certifications, but the FBI also does use this software. So does the U.S. Army Crime Lab. I will say, you know, we are audited several times a year to the FBI quality assurance standards. That's when they come in, they make sure we're doing everything appropriately, and they have reviewed our validation as part of that.
Okay. And how many states has your laboratory testified to in relationship to mixture DNA analysis?
Many. I don't know that I could put a number on it, but many all over the country, and we've testified internationally as well.
Okay. And are you still engaged in the process of receiving submissions of mixture DNA samples and conducting those tests?
Yes.
All right. That's all I have, Judge.
Any recross on those points?
No, thank you.
Can this witness be excused on behalf of the state?
No objection.
Thank you, ma'am. You can step down.
Thank you.
All right. Does the state have any other more brief witnesses on deck? I don't think that would be one of them. What else do we have? Anyone else?
Don't believe anybody could be brief.
All right. Okay. Members of the jury, we've again covered a lot of ground. I have been talking with the parties about where we are in the process during breaks, and I do believe we still are on track to have this case in your hands for your consideration at some point on Friday. And so if there's anything we need to address, feel free to indicate, but seeing none, we'll excuse you for the day, expect you back so we can get started again at 9 o'clock tomorrow morning. Please don't discuss the case with anyone, including amongst yourselves, or do any research about the case. Take care. All right, the jurors have exited, and I know we've got Dr. Sullivan to address. We've got Detective Williams. What other witnesses are possibly on the horizon for tomorrow on behalf of the state?
Your Honor, I think it would be, what we plan on calling is Dr. Sullivan, Detective Williams, and Detective Garrett, well, Mr. Garrett, former Detective Garrett.
Garrett Key. Okay.
Sir.
And then that would be the conclusion of the state's case?
Right now, I believe so.
Yeah, I know things come up, not holding you to
Yeah, they
that.
do, but I think so.
All right. And then, all right. So again, just planning ahead, it sounds like there's a chance, depending on cross-examination, that we would combine the lunch break with our charge conference. So just want to put everyone on notice of that. We've received the proposed charges and we'll form a compilation packet. And actually, I think we should be able to go ahead and email that over to you. We'll do that tomorrow morning, along with the proposed verdict form, so we can roll right into the charge conference where we are from there. Of course, that's presuming that the defense doesn't have any evidence to present. And we'll, of course, go through that point when we get there. More to the point, I know we have to address Dr. Sullivan. Well, also, I don't think I closed this loop. You can let Investigator Sautel know that he's excused, it sounds like. And then I know we have Dr. Sullivan to address. Anything else on behalf of the state we should bring up now?
I don't think so, Your Honor.
Okay. Anything else on behalf of the defense?
When would be heard on Dr. Sullivan?
We'll do that now. We'll do that now. So where we'd left off was, I believe Mr. Wilson was going to get some clarity on, ensuring that Dr. Sullivan has an opinion to offer that is within these guardrails that I'd lined out and suggested by this Smith v. Arizona case. And if we can always bring her in here to, now that the jury's not here, to get some preliminary testimony on those opinions and just the basis of them, not necessarily diving into them and their substance, but just what exactly is she basing her opinions on. So, Mr. Wilson, do you have anything to report back to us that you've provided to defense counsel?
I did. As much as I could, given the time that time constraints I was under. And I think it might be helpful to bring her in to voir dire. Would that?
Okay. Well, what did you provide, by the way? Was it an email?
It was just a written, it was a written email.
All right. Mr. Simon, are you taking this direct? Is this?
It wasn't planned to be, but I might be.
Co-counsel's nodding her head, so I think.
It's sort of an emergent issue.
All right.
We weren't planning to be here for a Daubert hearing today, but I guess we're doing one. Because the problem is that, so there's a few things I want to address before we get a witness in here. I did receive something of a written summary of findings that is 4 sentences. And I received it about a half hour ago.
Why don't you just read those into the record?
This is an untitled Word document that says, I relied upon several photographs taken at the time of the autopsy to reach the following conclusions. I reviewed a picture of a stab wound to the back of the neck and noted that the injury was from back to front and transected branches of both the left carotid artery and the left jugular vein. This wound caused blood loss, which in turn was the probable cause of death in this case. There are pictures of marks on the left arm, which is suggestive of a ligature mark. I also see pictures of ligature marks on left leg. I suppose that's 6 sentences.
Okay. And so if that is the sum total of her conclusions and observations based on photos that they're able to authenticate, what's left here as an objection?
All right. There are 2 things that I want to address. Number 1 is that the court mentioned Najee as a case. And the court was correct in pointing out that Najee is a pre-Smith case. Having read Najee now, Smith directly overturns that case. Smith goes completely in the other direction of that case. That case does not apply for both hearsay issues and confrontation clause issues. The hearsay issues, as far as the factual findings of and the work done by the original ME on this case, are hearsay because the old 703 would allow them. They could base their expert opinions on hearsay. The revision to 703 doesn't allow that anymore. And with the Daubert test becoming state law, there are issues here that what the state is arguing, barring up in the state's argument, they're trying to hide behind expert opinion testimony, essentially, to backdoor in hearsay statements from the original medical examiner because he's not available today. And under 702 and 703 as revised, that doesn't apply. That's not an avenue anymore.
When you say as revised, what exactly are you referring
When
to?
Daubert was implemented.
Are you just saying,
702
you're just saying the
and
Daubert
703.
standard?
Yes.
Okay.
But under the old standards, sure, that could possibly be done. Under the new standards, there's a whole other test that has to be done. So yes, we will probably end up voir direing the witness here shortly. And we're gonna be asking, you know, what medical examiner is going to establish a cause of death based on photos alone without an autopsy. Because that's where we are at this point. That's what we have to determine. So I'll look forward to hearing from the medical examiner on that. This is not, as the court pointed out, an accident reconstruction comparable case. This is different. The state is going to, especially if the factual findings from Dr. Henniger she's allowed to refer to those and make statements and opinions based on those. This is going to be hearsay that doesn't need expert testimony to interpret. This is just relaying those conclusions and factual findings that the original AME had. That's exactly what Smith is saying is a problem. And that's exactly where the confrontation clause kicks in. So if we're just talking about the photos, there's an issue with that as well, because again, she wasn't there for the photos, but it sounds like they're trying to authenticate through Detective Williams. But even those are findings, part of the report that were performed by Dr. Henniger. So these cases potentially apply to those as well. And hiding behind the expert opinion laws does not save the state, because those got revised. There is no hearsay that can be backdoored through those. So we object to their characterization of what they're going to be bringing in through Dr. Sullivan. Smith still applies, and the confrontation clause objection, the hearsay objections, all of those are going to be continuing objections for us through her testimony. So those are kind of the two main points that I want to address, Judge.
All right. Well, I do think it would be valuable, since we have Dr. Sullivan here, to have some preliminary testimony on what she's expected to testify to tomorrow. Looking at the Daubert test, I think, and I would say that we do not need to hear, or I'm going to just go ahead and say definitively, we don't need to hear testimony at this phase about whether she's qualified, whether there's sufficient training. We can skip over that prong. We can skip over the prong about whether her testimony or opinions would assist the jury. And instead, we'll focus on testimony and opinions, whether they're based on sufficient facts and data and a reliable methodology. I want to hear preliminarily what you've outlined. Were there any other conclusions that you were referring to other than what she just said by looking at these photos?
We're just looking to have her introduced for her cause of death, whether she can ascertain them from the photos, and I think she did. Your Honor, I will respond briefly if I could. You know, I think that to say that Smith versus Arizona overruled Najee versus State, I think is a big stretch. It is those cases all deal with the conclusions based on scientific tests. This is a totally different situation. We're not basing it we're basing on viewing of pictures, and this is Najee, and Najee still, and Daubert is for unique scientific theories. There is nothing uniquely scientific about an autopsy that hasn't been done, and autopsies and medical examiners have been part of the law for 100 years.
And again, that's why I'm saying we can skip over the methodology. The part of the Daubert prong is still that she has to have come to an opinion that is based on sufficient facts. That's the core of what we're talking about here. And that's I don't think we need to get into the nuances and debate over just how this new case has affected prior case law. I think that what the Supreme Court points out last year is that you can still have substitute testimony in some capacity, but you just cannot be relying on facts asserted for the truth of their matter that are that were made by another expert. And
I-
it doesn't sound like that's what the state's doing. Let's find out. So,
It would be based on
Yeah.
her independent judgment.
so that's what we just need to get to here. NAJI.
Your Honor, before we begin. At one point, the statements that I read, that I received, I did not receive which photographs those, opinions were based on either, so.
We can explore that.
Do that while we're on the record as well.
All right. Welcome, Dr. Sullivan.
Hello.
Whenever you're ready, if we could have you sworn and we'll dive right in.
I do. For the record, would you please state your name for the court?
Karen Sullivan, KarenSullivan.
And what is your job?
Chief Medical Examiner for the Fulton County Medical Examiner's Office here in Atlanta.
And as part of your job, do you review autopsies performed by other doctors?
Yes.
And do you review photographs in order to come to conclusions?
Yes.
Did you review an autopsy regarding Kay Thomason?
Yes.
And did you base your opinions on, or what did you base your opinions of cause of death on?
The autopsy photos, matching them with the draft report of Dr. Henniger.
But were you able to come to an independent conclusion? Let me ask you a different way. If in this case, had you just seen the photos, could you have come to a conclusion on cause of death?
Given the circumstances surrounding Ms. Thomason being found, yes.
And what pictures did you rely upon that were very instructive in your decision?
There were a number of photographs of Ms. Thomason, especially the back of her neck, also her extremities and torso.
And what conclusions did you make based on viewing those pictures of the back of her neck?
There was a stab wound that was demonstrated on the back of the neck with reflection or dissection of the skin and soft tissue showing the region of her neck.
And were you able to reach a cause of death based on those pictures?
Yes.
And what was your conclusion?
That the cause of Ms. Thomason's death was a stab wound of the neck.
Did you review all the pictures from the file?
I did review the photos back when when I peer reviewed the case, but I don't remember specifically what all of the photos were.
Could you briefly discuss the process of peer reviewing?
Well, at the time, each of the medical examiners in the office would peer review the report and photos of a particular case before it was finalized by the medical examiner who actually did the autopsy. So any case where the where the manner of death was either homicide or undetermined was subjected to a peer review.
I just have a moment, Your Honor.
Let's do this as well, Mr. Wilson, just
Yes,
because I would anticipate you doing this tomorrow.
right.
Is if you could gather all the photos that you were contending were going to be admitted either through her testimony or through detectives, and we can just have those identified so we know exactly what we're referring to, and when the time comes to it, we can always already have objections and perhaps even a tentative ruling,
Well,
unless you don't have those.
well, I don't have some of the ones that I wasn't going to use because Dr. Henninger was going to testify, and some of them are incision photos.
So you just haven't elected which ones you're going to use
Yes,
yet? Okay.
and I don't have the right ones that I would need to give to the court and Dr. Sullivan to allow her to,
All right,
those
that's
are the
fine.
ones that she's based on.
All right, just let us know when you're ready, if you're conferring.
I just have a moment, Your Honor. Nothing further, Your Honor.
You said there was an additional opinion about marks on the arms and legs as well.
Oh. Yes, I mean, I did you observe, were you able to observe pictures? Can you tell by pictures whether or not there are ligature marks on the victim in this case?
There were some marks that were suggestive of ligature marks. I couldn't specifically say that the marks were due to a ligature, but were blunt force injuries in nature.
I just have one more moment, Your Honor. Nothing further, Your Honor.
All right, so just so we're all on the same page, she's described the facts and data that she's basing her opinions on, and there are no other opinions the state was seeking to introduce through her testimony?
I don't believe so, Your Honor. As to the cause of death.
Okay, Mr. Simonoff. I think of what she's just said, yeah, everything she said so far.
Good afternoon.
Good afternoon.
Thanks for being here. I know it was a little hectic. I have a few questions about, well, let me ask this. As a general question, why are autopsies performed?
To determine the cause and manner of death.
Okay. And in homicide investigations specifically, are autopsy the standard practice?
Yes.
And is it a reliable practice?
Yes.
Is it considered a principle in the field, a gold standard, if you will, to determine the cause of death?
Yes.
Okay. You are basing your conclusions today on the cause of death on both the reports from Dr. Henninger and the photos, or just on the photos?
I'm basing to explain the peer review process, I'm basing the peer review on both the draft autopsy report and the photographs. If I'm given the circumstances surrounding the person who is deceased being found, looking at the photographs alone would allow me to come up with a cause of death.
Okay. Is that standard in your field?
I don't know what you mean by standard in the
Well,
field.
we just talked about autopsy being a reliable principle, a reliable method to determine cause of death,
Mhm.
that it is usually performed in homicide investigations. If there was just photos of a decedent, you just saw photos, injuries on them, that wouldn't be standard in a homicide investigation to determine a cause of death, correct? There would be an autopsy performed.
There would be, depending on what the injuries were, if there were injuries. If there were no injuries, just seeing pictures of a deceased person wouldn't help you to accurately say what the cause of death was.
But as in this case, there are injuries.
There are.
So in a case like this, determining it without an autopsy, just based on photos, would not be the standard principle or method.
That is correct.
Okay. Now, you reviewed the photos and the report. And the reason I'm making a distinction about this is because it makes a difference legally. But when you peer reviewed the case, when was that?
Whenever the case was finalized, I don't have that date, but before that date
Is it years
was
ago?
when, I'm sorry?
Is it years ago?
Yes,
Did you review any photos more recently?
today, when I was asked to testify.
How many?
I can't remember, 6 or 7 photographs.
6 or 7. Now, compared to a normal autopsy and all of the data and testing that's performed pursuant to that, is reviewing 6 or 7 photographs comparable data?
No, during the peer review process, I would have reviewed all of the photographs.
Right. But if you had performed the autopsy yourself, compared to you reviewing the 6 or 7 photos you did today, you would have a lot more information, correct?
Correct, and I had more information back when I peer reviewed the case because I reviewed all of the photographs.
Yes, yes. And if you had performed the autopsy yourself, you would have followed the reliable principles and methods that we talked about. And you would have more facts and data that would be sufficient to pronounce a cause of death versus just looking at 6 or 7 photos today. Would you not?
That is correct.
Okay. Do you happen to know the reason for Dr. Henninger's absence?
Your Honor, I object. That's not relevant. And she doesn't work with Dr. Henninger.
I'll allow it. You can answer the question if you have any knowledge.
I was told that he was out of town.
Okay. Nothing more than that. Okay. That's all, Judge.
All right. Anything else from the state?
No, Your Honor.
Okay. Dr. Sullivan, I understand you do have a scheduling conflict tomorrow morning. What time did you think you might be available to rejoin us?
I have a dental appointment in the morning, and then I'm supposed to give a tour to Judge Carnicel's interns from 12 to 2.
Do you have any window in between there?
The dentist, who knows how, yeah.
What
Hopefully,
time does your appointment start?
7:30. So
Are you expecting to be there 5?
I'm just telling you.
Okay.
I'm hopefully not, but
Well, if you could, once you're done with the dentist, make your way here. And if we need to, we'll pause whatever testimony we're in the middle of and may sub you right in, okay?
okay, sounds good.
Thank you for your patience. All right. Mr. Simon, I'll allow you to complete the record, but as I understand 702, I think a lot of the issues that you raise and address are going towards the weight that someone could assign this expert opinion based on the analysis she's done and not its admissibility. Reliability under 702 is not held to the standard of correctness. She could have more data, and she would if she had done the autopsy, but I think based on her expertise and her experience, it is possible to look at even just 6 photos, and based on the condition of a body, make an opinion about the cause of death. So you feel at this point, I would overrule the objection on the confrontation clause based on what I've heard on hearsay, and I believe the issues of the discovery and late disclosure of the name have also, I think, at this point, been addressed, allowing you to explore the bases of her opinion and what she intends to rely on. So if you have anything else to add for the record, you may.
On record. Number one, the confrontation clause objection, we like to make continuing objection throughout her testimony and through the end of trial, as well as the hearsay objections related to that. Number two, Your Honor, the notice objection, I do want to flesh that out a little bit because, again, we're kind of.
I mean, how would you prove prejudice here? Are you contesting the manner of death? Are you contesting that she's dead? What's the prejudice?
Prejudice is that we are entitled to not have trial by ambush. We're entitled to have a witness list.
And so how have you been ambushed? Has she now been is she dead a different way than you expected?
I don't know what she's testified, what she's actually testifying to, except what's in those 6 or 7 photos that I haven't even gotten. Okay, that's the problem, is that we're getting this stuff without any ability to prepare or advise our client of. That is violative of substantive due process. That is the issue. It's not just a question of, well, we can just put anybody on the stand as long as they say the same thing. The question is, how do we cross-examine every particular witness? That's why we need notice for witnesses, is because depending on what the witness's background, testimony, history is based on, we can advise our client on what to do. We can tell them, here's what the witness list looks like. We can tell our client, this is what we expect to see at trial. This is how we're going to strategize against this particular witness. And getting served a different witness 2 hours ago in the middle of trial while we're taking testimony from someone else is exactly trial by ambush, is exactly violative of substantive due process. And quite frankly, Judge, this court's own standing order is meant to address exactly this behavior. This is why we have case management hearings. This is why we have case scheduling orders. This is why the state is supposed to subpoena witnesses, so that if somebody flies the coop, they can get a material witness warrant. But that didn't happen here today. And Ms. Jones's substantive due process is violated because of that. I'm sorry if I'm getting a little animated, but just because she's going to confirm what the state's original witness is going to say doesn't mean that we're prepared to cross-examine her as a witness. So yes, I am renewing that objection to notice. I am renewing the discovery violation objections. I think that they are obscene at this point in a trial. If this was a motions hearing, if this was a final plea hearing, if this was even calendar call when we don't have a jury waiting in the back, I can see the court making arrangements, making exceptions, but no, this is completely different. This violates Ms. Jones' substantive due process. That is the key line here. The other objections, yes, Your Honor. 702 does put down several factors that the court has to consider. One of those factors is sufficient facts or data. And we know by her testimony what the standard procedure for determining cause of death in this state, in countless homicides, is. That is an autopsy. She can't testify to the autopsy. She simply cannot. She wasn't there. She does not have access to that gold standard of the sufficient facts, data, and reliable form, and is required by 702. She reviewed years ago a report and all of the photos, and then today came in and reviewed 6 or 7 photos. That is not sufficient facts or data. How do we impeach her? How do we cross-examine her? How do we get into the details that are potentially exculpatory in an actual autopsy examination? That, in and of itself, relates back to the substantive due process notice and discovery objections as well. We are unprepared not because of anything we've done. Ms. Jones's rights are in jeopardy now, not because of anything we've done. And this trial has now turned into something completely different than the usual trials that Your Honor seen in this courtroom, not because of anything we've done, but because there's a witness that hopped on a plane that wasn't seen. Those are my objections.
All right, noted, Mr. Simenoff. Anything else for the?
Your Honor, these are, I just want to say for the record, when they say that they don't have notice of these pictures, that's just not accurate. They've gotten these pictures. That's what it's relying on. And to suggest that we're giving them new pictures today, that's not true. So I understand we are put in a bad spot. That's why we've kind of dialed everything back. So we're trying to do the best we can. So, Your Honor, I just didn't want that to go unanswered.
All right. Understood, Mr. Wilson.
He is right that we have the.
And that's not how I interpreted your argument, Mr. Simenoff. That's not how I interpreted your argument, but I would still rely on what I've previously noted, which is that, yes, this is not how trials ideally should be conducted. And I think has been noted throughout our case law that there really is no such thing as a perfect trial. And we need to make sure, though, that it is a fair trial. And that is my overriding focus. And so if this were perhaps a situation where I could see more identifiable prejudice, where things are now not able to or coming out differently than they might otherwise have, or this is if this was the DNA expert or the cell phone mapping expert that's more at the core of this case, where this is an identity defense as I took it from opening, then I think that could very much change the analysis. But so far, I'm not seeing this rising to the level of requiring outright exclusion. I think the state, usually this would be probably a 30 or 40 minute direct examination of Dr. Henninger. If he was here, he'd be going into great detail as to every little mark and notation. They'd probably be showing him the crime scene photos and asking him what this means or that means. It doesn't look like that's what they're doing here. They've turned this into a 3-minute direct, which is just to confirm a cause of death, which I don't even see as a contested issue, and which could probably already be surmised based on the evidence that's already been admitted, if there really is even, if it's even a remaining element of the crime. But
May I make one final request then? Why tender her as an expert? Let her give lay opinion testimonies to the cause of death. Why not just tender that through Investigator Williams in that case?
all right, Mr. Simon, at this point, the state has presented this witness. I think we've gone through the analysis. I mean, she would still have the right to be asked hypotheticals based on her training and experience. As a lay opinion, I don't know if she would be able to just look at a photograph and be able to say, I have an opinion on cause of death. And so to that end, I think that we've made a record, we've gone through it. Your objections are preserved. But I do believe that we can proceed tomorrow with her truncated testimony as presented today. And so it sounds like we would begin tomorrow morning with, was it be Detective Williams or that other witness?
I would think it would be Detective or Mr. Garricky.
Okay. All right. Then we'll pick that up at 9 a.m.
Sir.
and go from there. We're in recess until 9 a.m. Thank you all.
Are we gonna let you off?
Yeah, just to mount it up and pack up and leave. Oh, they're putting it over there. I wouldn't think they left.
Shirley Levinsky, you didn't give him exhibit speech. Oh, the exhibit. Okay.
Sorry.
Well, I mean. Yeah.
So 8, 13.
Well, no, I don't need the list. I mean, oh, no. What do you want? Yeah, whatever.
You want to let it play?
Sorry.
No, I don't. I didn't need it. He likes it for older. Hey.
No, we're not. We're not.
I'll let Sautel. Oh, that's okay. Is it okay if he comes back in?
Absolutely.
I'll let him.
Try it twice. Try it twice. You're gonna be.
Think about it. No. No, I mean,
Nah.
no.
Mom, and you should have noticed the.
Not taking your car? Oh, okay.
I got it.
Okay.
Let's see. Sir?
Did you give me everything?
I
All the
did.
exhibits?
I hope so. Yeah, I think I did. There's those 3 big ones.
Okay, yeah, fine. Yeah. I should have got you to take a picture when you had them laid out for. From what I didn't want to interrupt you.
Oh.
At the